Good morning, everybody. Back on the bicycle. It's like the same routine that we got to know last year. Already back in it. Day 2 of the trial. Day 2 of Commonwealth versus Karen Reed. It's like we've seen this before. A little bit different though. It's kind of like when you see something off in the distance and it's like kind of hot, so there's like heat waves and it gets a little distorted. It's not quite the same as you remember it, but it's got this vague familiarity. Well, yesterday kind of set the stage for us. And you have a little bit of time to reflect and think back over kind of what you saw. And sometimes I have some of my best ideas about things, I feel like, after they've had a little bit of time to simmer. So I have some thoughts about the opening statement, particularly Hank Brennan's opening statement, because a couple things really stuck with me. A couple things really stuck with me about it, and the main one is that how he really tried to claim the mantle of facts, science, and data. He kept saying that. He said that a few times. We have the facts, science, and data. But he never did much to explain that, to lay out exactly what science, facts, and data you have. And the thing about data, it really needs to be explained. If you just drop out there, hey, hang on, I got a weather station. It's 33 degrees outside right now. I just dropped that out there. What is that supposed to mean? What does anybody care? What does it matter that it's 33 degrees? Well, I'll tell you it matters that it's 33 degrees. That's colder than it's been in the morning for quite some time. It's very close to freezing. It means I need to watch the temperature forecast in the coming days, because if we're going to get a cold spell, I could get some fruit damage. I have to go make some extra effort to take care of my apricots, because my apricots will freeze in a hard freeze. So you got to go out and get the sprinklers on them. Maybe to some of you, 33 degrees right now is perfectly normal. Maybe that even sounds a little balmy. It is 5:48 in the morning. So things have to be explained. To just drop out there, there's Waze data. There's a timeline, of different things happening. In and of itself, that's not explaining to the jury why Karen Reed is guilty. Even when he tried with that timeline, it was a mess. That timeline was a mess. He's all over. He's like, on the one hand, she's arriving at 12:34, but then John is getting out of the car at 12:32. So this is kind of a big tell that he's trying to claim the facts, science, and data, because remember, the opening statements are the commitment. This is your commitment that you're making to the jury. I'm going to show you this. I'm going to follow up. And that's how you know you can trust me. And so to deliberately put something out there that you can't follow up on, like, surely he knows he's going to lose the facts, science, and data battle. This is why he's so he's so terrified of ARCCA, right? And that's when it kind of clicked for me. That's why. That's why he's trying to claim the mantle of facts, science, and data. He is floating his balloon out there. We're going to win on the technical side of this case, on the off chance that he gets what he wants and he gets ARCCA excluded, or he gets them limited so that they can't respond to, this guy that he's found to put blue paint on his arm and do some tests and so forth. He's just floating a balloon. Thinking maybe if I can get them kept out, I can win this facts, science, and data battle. But it won't be as it won't be as close a fight. And if he can't, he's got a backup position. And he already told us what his backup position. And what is his backup position? It's the same one we had last time. I hit him is the backup position. And it's powerful. It's powerful. And the reason why it's powerful is that strength, that influence that people's own words have, persuasive power of them. We just are so willing to believe that what people say is the truth, that even if it's hard to reconcile that with other evidence, with objective evidence, it's still, we still might struggle with that and question that. I don't know how these right, but she really believes it. The theme of the case, hat tip to Melanie Little. She is the first one I saw call it out, but then Mr. Alessi, picked it up and ran with it. Theme of this case for the Commonwealth, it's ipsi dixit. Okay, ipsi dixit. That's a Latin phrase. It just direct translation just means he said, but it's used. It's an expression that talks about like just because I said it, like it's true just because it's been said. Like that's all you need, just the fact that it was said. And ipsi dixit comes up so much in false confession cases. We've got this big archive now. National Registry of Exonerations has just a ton of case information about situations where people have been found guilty, later exonerated. And you can pick up different themes and just factors that play into what creates a false conviction, a wrongful conviction. False confessions are a big one, and part of the reason why is just that power we have. People tend to think if you said it, especially if it's against your interest, you wouldn't say something like that if it wasn't true. We just have this idea people wouldn't say something like that if it wasn't true. But people say things that aren't true all the time for a whole variety of reasons, and sometimes knowingly, sometimes unknowingly. They don't realize that they're not telling the truth. So people's words are particularly bad evidence. And we've known this for quite some time now. It all kind of started falling apart in the 90s with Dr. Loftus. Dr. Elizabeth Loftus was like the first big memory researcher. She testified as an expert in a whole bunch of the satanic panic cases back in the day. Kind of started off with daycares with children, sometimes 2, 3, 4 years old, like very young children that would report things that are just so fanciful and delusional and insane because they're being coached. And people would buy this. People would buy these stories, and they would convict people and put them into prison for things that just on their face, you're like, this can't happen. This is not even possible. And then that evolved from children. It became adult. Adult people now have repressed memories of satanic abuse and rituals and things like that. Like, once again, doesn't add up with physical evidence, but there are these very strong memories that people have, and it's so persuasive that people will convict people, put them in prison on the basis of, I just remembered out of the blue this horrifying, implausible thing that happened to me when I was a child. So then Dr. Loftus kind of blew all that up because she started researching memory and how does memory actually work? And is it this video recording that we have in between our ears like we kind of think it is? We really think our memory is very reliable and we rely on it very heavily. And essentially what Dr. Loftus has discovered is that memory is not reliable at all. Memory is not something that you just capture it and fix it and store it away in your mind. Memory is a constantly evolving process, and it's very easily tainted. She did a whole series of experiments to show how easy it is to implant a false memory in somebody. And so, here we are now, 20, 25, 35 years later, and haven't seen a satanic panic case in a while. Haven't seen a prosecution of somebody recalling a repressed memory of, satanic abuse from their childhood. It's been quite a long time since we had that sort of epidemic. And I think the evolution of the memory science is a big driver behind that. So we understand much, much better now than we did 30, 40 years ago. Memory is not particularly reliable. And so to the extent that you have a witness in court testifying about what they remember, it's not particularly good evidence. It's just not. But that's the ipsi dixit theory. The ipsi dixit theory is ignore the evidence. Don't pay attention to that. If I lose on the facts, science, and data, because the facts, science, and data make it look like John could not have been hit by a car, just ignore that. These people said it. She said it. The witnesses said it. I hit him, I hit him, I hit him. That's the real focus of this case. Yet again, it's the facts, science, and data. This is a head fake. It's a head fake. It's a just in case. Just in case I can get ARCCA booted, and then I might have a chance. I still got that whole problem with my own medical examiner doesn't back up my case, and I had to bring in hired guns because Trooper Paul is such a disaster. Had to bring in hired guns to try to substantiate something on my behalf. But if you don't have the crash daddies over there on the defense side ridiculing your case and pointing out how ridiculous it is, it's a closer question. You might actually convince some people that you do, in fact, have the facts, science, and data on your side. But he doesn't really expect that. It's just a play. It's a head fake. I'm going to go this direction. And the whole time, what it's really about the ipsi dixit. I hit him, I hit him, I hit him. And that's why he started. That's why he started with firefighter Timothy Nuttall. That's why Timothy Nuttall was his first witness. Timothy Nuttall is a true believer. It's like an amazing case study in confabulation, watching this guy on the stand. I say confabulation because I tend to give people generally the benefit of the doubt when they're not telling the truth. And it's very obvious. It's so obvious that Mr. Nuttall isn't telling the truth. His story doesn't align with his own story. His story doesn't align with other people's stories. And his story doesn't align with what you can see with your own eyes on the video recording. So he's obviously not telling the truth. But that doesn't mean he's lying. And I try to give people the benefit of the doubt because people say incorrect things all the time. And most of the time, you're not lying. It's inadvertent. And I gotta be real frank with you. Timothy Nuttall, he's not a smart man. He's not a smart man. He's actually quite earnest. When I'm watching him on the stand, he comes across as very nervous, very anxious, but also, you know, pretty sincere. Like, I think he really, really, truly believes. He really, truly believes that he's heard it. And he believes it so vividly. This is the beauty, like I'm saying, the case study in confabulation. He remembers it so vividly, and yet it didn't happen. You would think he would have learned from the last trial that the vividness of your memory of something does not correlate with its accuracy. Because that's exactly what happened at the last trial with the puffer coat. He had a very, very vivid memory of John being in this puffer coat because he had a memory of trying to take the coat off of him, and his fingers were so stiff. They were so cold and so stiff that it was very difficult to get the sleeves around them. And we know the reality is that John was never in a puffer coat. They never took a puffer coat off of him. And the clothing he did have on, they cut it off. They cut it off. So he has this very vivid memory at the last trial, and it's not true. So you would think he would have learned that, but Timothy Nuttall is not a smart man. He's just an earnest man. He's a true believer. A true believer in the I hit him narrative. He really believes it. And he believes it so much that that memory gets stronger and stronger and stronger and more vivid every time he remembers it. Now, the fifth time he's told this story, okay, we have him telling it to Trooper Proctor on February the 8th. We have him telling it to the grand jury. We have him telling it in the first trial. Sorry, the fourth time. And now we have him telling it in this trial. The fourth time he's told this story now, he's finally landed on the right version, right? I hit him 3 times. Why? Well, that's what Jen McCabe says. But he's landed on the right version. I hit him. And now he's conjured up a whole new vivid memory of exactly when it happened. When he can picture it in his mind. That's why he comes across as so sincere. Because he can remember Flamati down there doing the chest compressions, and Kelly is down there as well at his feet. And it was like right around maybe in the time when they were changing off. Everybody is down there kneeling by John, and Karen runs over and says it. And even though it doesn't mean anything to him, he remembers it, right? There's this disconnect between your motivation and you know what you're reporting caught your attention. You don't pay attention to things that are irrelevant. You just let them go. For something to stick with you, it has to be meaningful. So we have this conflict between he's telling us it's not meaningful because he has to do that, because they didn't do anything about it. This is part of how we know this is a confabulation. Nobody acted at the time like this was actually said. Nobody said it at the time. Nobody acted like this is what happened. And it doesn't add up with people's recollections. The objective evidence that you can see when you watch the body cam video or the dash cam video, and you see here's when everybody is down there by John, and Flamati is doing the chest compressions, and we watch the entire video until John is taken away at that point. Karen didn't come over there. So then he tries to shift, right? No, it's at this earlier part of the video. Okay, but that's not when what you described in your very vivid memory was happening. So no matter what, your memory about this is wrong. because either Karen didn't come over and say it when Flamati was doing the chest compressions, or she did come over and say it, but something else was going on, and it's not what you reported. So no matter what, your memory doesn't add up, and it just keeps shifting. It just keeps shifting. But he's probably, from my perspective, one of the best of the I hit him witnesses, because he's such a good confabulator. He so sincerely believes in it, like to a fault, because his memory keeps evolving and his recounting keeps evolving. And this is exactly the kind of thing that Dr. Loftus talked about in all of her memory research. It's the recall, the process of recall. It's not, I'm going to dip into my memory and find that videotape and replay it in my mind and then tell it to you. It's a rewriting every single time you access it. And so some people are going to be more suggestible than other people when it comes to rewriting their memories. My impression of Mr. Nuttall, firefighter Nuttall, yeah, he seems very suggestible to me. And I get that not just because he seems to be a really good confabulator. Okay, he got the I hit him, and he ran with it, and he has now taken it. And I think part of his demeanor on the stand kind of emphasizes what's going on with him. He was so anxious. He was so anxious. His forehead was just constantly wrinkled. His eyes are massive. He's sitting there in an adrenaline dump. He's shifting. He's pulling his collar. His ears are red. This is a man who knows already this isn't going to go well. And he's anticipating. Maybe he's been told everyone's going to hate you. And he just sincerely thinks, I'm just doing my job here. Looks like they're almost getting ready to get going in here. Let's get the sound on.
Please be seated. Court is in session. 22 CR 117, the Commonwealth versus Karen Reed.
Only 8 minutes late today.
Okay. All right, so I was told counsel wanted to see me about something.
Yes, good morning, Your Honor.
Morning.
Last night we received 19 new exhibits. One of the witnesses that the Commonwealth intends to call today, Trooper Gorino. Many of these reports are celebrate reports that are run with new software and not addressed in any corresponding report. Some of them include data that have never been discussed by Trooper Gorino. There's at least one PowerPoint that is hundreds of pages long that appears to be cut and copied text messages and various phone calls that, again, we received at 10:45 last night. This is in violation of Rule 14, and we're asking the court to exclude, at the very least, the lengthy PowerPoint of phone calls and text messages that have been copied and pasted into a PowerPoint, because we have no ability to go through in a timely manner and review them for accuracy.
What do you say about that, Mr. Brennan?
Your Honor, all of this information is from the phone discovery, which they've already had. There are a number of different select PowerPoints that were
When did they get it?
last night,
No, when did they already have?
2023.
Okay.
And so what you may remember from the last trial is that there is, for example, Mr. O'Keefe's entire phone log, and then it's separated by his phone calls with the defendant, perhaps another witness. And so what we did is we tried to consolidate. Instead of having 50 of these things, I try to make them more limited. We did use more updated software. The only difference is it shows emojis. In addition, we took the phone calls and the emails or the text messages, which was presented at the last trial. Content has not changed. We just put it in a PowerPoint so that when it's read, instead of just reading the text messages and then searching for the phone calls, where Trooper Gorino would then refer to a separate document, it's simply an order. There is a presentation of a different PowerPoint, which is from the old data, 2023. but it is information that was not introduced at the last trial, although it was clearly provided to the defense in advance. And what it is, it's healthcare data of the defendant's watch Jennifer McCabe's watch. And what it does is it tracks her heart rate from midnight all the way through the next morning. Now, although that information was available to the defense, they could have done what they wanted with it. That information was never put in a PowerPoint presentation. I will not and do not expect Trooper Gorino to talk about it during his testimony. He's a witness I'm going to ask the court to recall. The reason I turned that over was to be transparent and to be collegial. We would not introduce it on direct, but as Your Honor ordered, there was an order not to get into third-party culprit evidence. Jennifer McCabe was never identified as a third-party culprit, yet in the opening, the defense suggested something about 227. If the defense is to cross-examine or suggest that a phone call occurred at 227, this would be to rebut that information. I could have waited until after the cross-examination and then sprung this as a surprise upon the defense because it is powerful evidence showing her heart rate is inconsistent with being in a criminal conspiracy, yet we provided it in advance so that it have notice days before Trooper Gorino would even testify.
Oh, there's a heart rate now?
So the
A heart rate?
PowerPoints that were provided last night, you don't intend to use either one of those in your?
The presentation I would regarding the text messages and phone calls. At the last trial, Trooper Gorino read the text messages from the screen, and at the same time, he would look at the phone calls, and he would go back and forth between the papers. This is simply putting the phone calls with the text messages in the chronological order so that on the screen, rather than read text messages and then refer to the phone calls and state there was a phone call, it can simply be shown on the screen.
What do you say about that, Ms. Little? It's content you had, it's messages that came in at the last trial.
The problem, Your Honor, is this is not from a Cellbrite report. It's been individually.
I need to see it. I need to take a look at this. Do you have an extra copy for me, Mr. Brennan?
I can provide a copy, Your Honor.
So Trooper Gorino is not going to be your next witness after Ms. Roberts, is he?
It's going to be Peggy O'Keefe, and then it would be Trooper Gorino. As I said, I can recall him, and I expect to because there's a number of other events. If it becomes an issue, I can call him to authenticate the phones that we'll need for our further witnesses, which is Ian Whiffen and Jessica Hyde, and then I can simply recall him. I don't need to read these to the jury today, but there's nothing new in it. There's nothing surprising, but I will make this as easy as possible for everybody.
All right, I'd like to be able to take a look at this. I'd like the defense to take a look at it. You're right, Ms. Little, you're entitled to be able to spend some time looking at what the Commonwealth intends to put into evidence today. So, so I just took, I guess, Mr. Lally's copy. So if you can get me, Mr. Clerk, would you give this back to Mr. Lally? If you can get me another copy today, that would be great.
And when should they do that?
He's really being called to
Mid-trial?
authenticate documents.
Okay.
The defense may have other plans for him. There's no need to introduce any of this today through Trooper Gorino.
Okay.
He will be not only a fact witness for downloading and authenticating, but he is essentially our reader. I can bring him back today. I can bring him back in 2 days. It really doesn't matter. I don't want to deprive the defense of time to review.
Okay.
And so
Sure.
whatever is the time they need, I'll defer.
Okay. So that's what we're going to do.
Thank you.
All right. And Ms. Little, if you can take a look at them by tomorrow and let me know if you have any objections tomorrow. Does that give you enough time?
Tomorrow.
Yes,
No.
thank you.
Okay. All right. Was there anything else before we started?
Not for the Commonwealth. Thank you.
All right.
Your Honor, I did email Mr. McDermott yesterday evening. We did speak with Dr. Wolf yesterday, and he is not available on Friday. Is there another day that works for the court reasonably soon that we can have them come in?
We could do it tomorrow afternoon if tomorrow is a better day for him.
State.
Yeah, they're just in Pennsylvania, right?
Could we do a Zoom hearing tomorrow?
No, he needs to be here in person. Mr. Alessi, I issued an order late yesterday. You were the one yesterday talking about this voir dire. I assume that you folks provided that order to the ARCCA witnesses. We don't have an address to serve them. We don't have enough time.
I provided a copy.
All right, so we could do tomorrow afternoon.
We have to make travel arrangements for them to get here. Yes. And that's, he has a conflict that begins on Thursday and goes until Friday. And so, is Is there a day next week that works for the court?
Well, we could do Monday, but what I'm going to order is if it's continued all the way until Monday, the testing that he outlined that you were contemplating or were going to do, that has to be done by then. So we can do it Monday, but that testing has to be done by then.
What does that have to do with?
Okay, we'll make every effort to make that happen. I don't have a status on some of the shipping components that they need for the testing.
Okay.
So I think we'll do the best for it.
All right. So that'll be done by Monday. We'll do this Monday. I don't want to devote a whole day where, I mean, Friday was easy to devote a whole day because the jury thought they were only going to be here a half a day. Can we do this just in the afternoon?
Your Honor, I am unclear as to what the subject matter of the voir dire is going to be.
So I am indifferent to this voir dire. All right. I'm trying to help you out by having the witnesses here because I found a violation of your reciprocal discovery. So I don't know how long this is going to go. I would assume I'm giving you the opportunity to put them on and the Commonwealth an opportunity to cross-examine them.
First, in terms of time, we can do it within a half a day.
All right. Do you agree with that, Mr. Brennan?
Regarding an afternoon voir dire of ARCCA on Monday,
Yes.
we'll defer to the court whenever is available.
I mean, I'd like to keep the testimony going. I've already told the jurors that they have a half a day Friday. So Friday we'll be back to where we were at the half a day.
Will we have a chance to be heard on rulings regarding ARCCA? Because I still have the same concern about new information.
Yes. What do you mean? Before, when?
Whenever it's convenient for the court, but I have concerns about these witnesses bringing in new opinions that we will not have an opportunity to consider.
All right. Can we do that the day of the voir dire?
Whenever it's good for the court.
All right. So maybe we'll break with the jury at 12 on Monday. Now they're going to have 2 half days in a row, but we'll break.
Will we still do the voir dire and I'll have witness testimony prepared for Friday?
Yes.
Okay.
Your Honor, I have one further follow-up question.
Yes.
Thank you. The reason I asked for, and I appreciate the opportunity for the voir dire, it's not lost on me. But what I'm trying to understand is I want to hit the target, whatever the target of the court
So
is.
one of the big concerns I have is that 105 or more text messages were deleted. And you said in due course. I have no idea what you mean by in due course. It's a pending case. I need to figure out that at least. And there, okay.
In Your Honor, the 30-day, if you may recall, the defense had this very same issue with a matter with District Attorney Morrissey. So you said, I'm unclear of what deletions are, and we're happy to have testimony. The ARCCA witnesses can discuss it.
There to bring them if they still have them.
Exactly. That is also very helpful. But this 30-day auto delete, a lot of attorneys do that. District Attorney Morrissey did that.
I need something in writing about that. That's not my understanding on how you keep records in a pending case. And remember, you still said out of the blue, months later, a bill came. This gives me pause about that, frankly. Okay?
We're happy to
So-
discuss that as well, Your Honor.
All right. All right. So,
Get a clarification.
all right. And there'll be more. I'm not limiting it to that, but those are my big concerns.
Appreciate it.
All right. Are we ready to start?
Judge, I just have a,
So let's figure that out. Do you want to, let's see counsel at sidebar about schedule.
This is such a mess. I'm going to be really trying to bust out something on Substack. If they're moving this hearing to Monday, then I can probably get it done before we have this hearing. This is such a mess. Bev has really tipped her hand here that she is looking for a reason to keep out ARCCA. She's looking for a reason to keep out ARCCA. Record retention is for the client's benefit. She cited the ABA rules. The ABA rules are guidelines. They are not binding in any jurisdiction, and they have nothing to do with discovery obligations. I'm going to talk about this in a little bit more detail because this is one of these issues, what a file is, what you have to keep, how long you have to keep it. This varies dramatically state to state. Depends entirely on the rules in the state that you're in.
All right, so are we ready to bring Ms. Roberts back in? I can take 5 minutes while we line the jury up if you want.
Ready, Your Honor.
Okay. All right, do you want me to get off to you?
All right.
So this is a very thin basis for finding a discovery violation because they didn't keep text messages. They didn't keep text messages. I don't practice in Massachusetts. I don't know what the norms are there. I'd be shocked if it's the standard practice of, say, your public defenders to keep and maintain text messages. That is not the normal practice. Text messages usually are meaningless. And if they aren't, if there's something like substantive in them, typically what you're going to do is you're going to document it in some other fashion. The old school way is the memo to file. Memo to file. Received text message from da-da-da-da-da. And in that case, if it's something like really important, I got a text message from a witness who gave me substantive information, yeah, then I might save that text. I might back up that text. I might screenshot it. I might make sure, I have some documentation of what's in it. The new school way is email to self. Just write yourself an email. You say, I got a text message and so. And that's maybe if it's less important, but you want a reminder. Got a text message from Dr. Wolf, says they won't be able to be there until 8:50. It is not routine. It is not routine to back up your phone and store your text messages somewhere. This is not standard practice. Maybe big firms do this. Maybe they have to. But I focus on what does the public defender have to do? Because that's kind of, one, we're in a criminal court. And two, you can't have different requirements for the people that are privately paid and the people that you, the public, are funding in order to do the job that they're expected to do. And I just don't think, honestly, the public is really interested in funding a whole bunch of irrelevant file storage for the public defenders. It's probably not what they want to pay for. I'd be shocked if that gets budgeted and that gets done. Because 99% of the time, texts are not important. They're administrative stuff. They're scheduling, they're, I'm going to be here. They're, hey, your witness is on the way. Stuff that really doesn't matter. So yeah, I'm going to go in and do a little bit of a breakdown of that Massachusetts rule. Because I think she's on very thin ice here, but she's looking to sanction ARCCA. She's looking for a reason. Nuttall was that ABA rule. ABA rule doesn't even apply. You don't even have a basis, so you had to go look for one to manufacture it.
Hear ye, hear ye, hear ye. All persons have anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, now holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
22-117, the Commonwealth versus Karen Reed.
All right, good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. Thank you for your patience. The lawyers and I got some work done this morning while you were waiting for us, and we do appreciate it. So I do have to ask you those 3 questions. Were you able to follow my instructions and refrain from discussing this case with anyone? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or should be. All right, thank you very much. Can we have Ms. Roberts back in, please?
I had a chance to go back over Kerry Roberts' testimony from the first trial last night. He has been very
Charles, I'll remind you, you're still
consistent
under oath. You can take the stand.
so far,
Good morning.
so I'll be interested to see if that continues.
Whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning, Mrs. Roberts.
Good morning.
Yesterday, you told us a little bit about when you went into John's home at Meadows to look for him.
Yes,
And I recall you said that you did not see him there.
correct,
At some point you left.
correct.
When you went into Meadows, who did you go into Meadows with?
Karen and Jen McCabe.
Have you ever seen any video from a ring camera depicting you and the defendant and Miss McCabe going into the home?
Yes, I have.
Your Honor, may I approach?
Yes.
Actually, I've moved to introduce a ring video. It has certification and then a smaller clip of that ring video if there's no objection.
Did you say if there's no objection or there is no?
If there's no objection. There's no objection. May I introduce Your Honor?
Sure.
Exhibits 12A and 12B.
Boy, there's 2 versions of it now. We saw this last time
Thank you.
because they had said Karen showed them the tail light when they went inside. The ring camera video clearly does not show that.
12C would be just fine, thank you.
So then they said it must be when we left, and there's no video of when they left. And we don't know why. It's a big mystery because Karen didn't seem to have access
Your
to
Honor, if I may
anything.
note, 12A is the ring video from 12 Meadows. 12B is the certification from Ring. And 12C is a clip of a piece, a portion of 12A.
That's accurate, yes, thank you.
Thank you.
But Michael Proctor and Kerry Roberts
With the
seem
court's
to have had
permission, I'd like to
John's
play
phone.
12C for the jury.
Okay.
Thank you.
That's all we needed to see.
Ms. Roberts, you've seen that video before?
Yes, I have.
Is that you and the defendant and Ms. McCabe going into Meadows?
Yes, it is.
When you came out of Meadows, did you have a chance again to look at the defendant's tail light on her Lexus?
Yes, when we left the house, she pointed it out to me.
Did you stop and get a closer look?
Yes, I did.
I want you to describe to the jury your best memory of what it looked like.
Karen pointed out and said, look, my taillight. And she said, do you think I hit him? And I said, no, I don't think you hit him. What are you talking about? Let's just go find him. But the taillight itself, the piece was missing. And as you got closer, there's a metal sort of square, and one of the pieces was sort of sticking out. And I only remember it because I thought if someone walks by that, they're going to catch their jacket on it.
How long of a time did you have to actually look at the taillight?
Under a minute.
How close were you to the taillight when you looked at it?
I was in front of it. I could see.
And when you talked about the taillight, you said a piece was missing. Is this the left side or the right side of the Lexus that you saw the piece of the taillight missing?
It was the right side, so it was the passenger taillight.
May I approach?
Yes.
Should I remain, Your Honor? Sure. Thank you. Ma'am, do you recognize what is in that photo?
That is Karen's SUV.
Is it similar or a fair and accurate depiction of how you saw the vehicle that morning?
Without the snow, I can't be positive, but this square piece was missing, as is in this picture.
The photograph you look at is not the car in the snow in the driveway the day you saw it.
Correct.
Putting that aside, is that a fair and accurate depiction of the damage that you saw to the right rear taillight of Ms. Reed's car that morning?
Yes.
I move to introduce this as an exhibit, please.
Any objection?
No objection.
This is the Sally port, car in the Sally port. So he's tying those together, that the
With the
car
court's
is in the
permission, I'd like
same
to
condition,
publish Exhibit 13.
according to Kerry Roberts.
Ms. Roberts, I'm going to ask you to take a look at the photo that you just described. Do you see the white area in that photograph?
Yes.
Is that where the taillight had missing part?
Yes.
And where was the metal in relation to that white part that you see?
If you look at the white part, it's the upper left. It's sort of like a rectangle, but it's vertical, sort of.
And that's the metal part that you were concerned about?
Yes, one of the side, it's almost like an encasement, but the right side, I think it was the right side, was sticking out a little bit, like out from the car toward me.
Did you express any concern about the metal sticking out?
Yes, because I thought at that height, it could clip someone's coat or something if they were walking by.
You mentioned the defendant asked you if you thought she hit somebody.
Correct.
How many times did she ask you that?
She asked me that in the driveway. How many times? She said, do you think I hit him? Do you think I hit him? And my answer was, no, I don't think you hit him. I'm sure you hit something because your taillight's broken, but I don't think you hit him. Why would I think that?
Did you have any reason to think at that point that she hit anybody?
No.
Did she ever repeat that phrase or question in the same or similar manner again that night?
She did at the scene where we found John.
Before or after you found John?
After we found John.
Okay, so we'll get to that then. Could we please take that picture down, Ms. Gilman? How far of a ride is it from Meadows to Fairview?
I don't know, maybe 8 minutes.
So when you left John's house at Meadows and you traveled to Fairview, you said you were driving.
Yes.
Was there any comments or conversation from the defendant on that ride?
There was talk of Bella's mom, who lived near Jen's sister. There was talk, and I said, where is Fairview? And Jen said, it's off of Chapman, so it was near Spring Lane. And I knew of somebody previously that John had dated on Spring Lane, so I brought it up thinking, could he have gone there if he was walking home? I don't know. I didn't know where he was or why he was missing.
Describe the mood in the car.
Well, it was scary driving, and Karen was, frantic, and she was yelling. I don't even remember at this point what she was yelling, but she was yelling. She had an elevated voice. She was in between us while I was driving, and she would sit back in the back seat and be in between us.
Did you have any words with Miss Reed?
I told her to shut up several times because I was trying to drive and I couldn't concentrate. I told her to sit back and buckle up because it was bad driving. I didn't want to get into an accident and her not have a seatbelt on.
How often was the yelling on the way to Fairview?
Oh, several times. It was like you couldn't control her. And I was trying to drive in a blizzard.
You went down Spring Road before you get to Fairview?
No, Spring Lane is before Fairview off of Chapman.
And did anything remarkable happen on Spring Lane?
I'm sorry?
Anything remarkable happen on Spring Lane?
No.
More of the same?
Yes.
Now, you mentioned yesterday that when you got to Fairview, the defendant began kicking your door.
Yes.
When you looked out, you didn't see anything.
I did not.
And at some point, you ran over to where Miss Reed was.
Yes.
Tell us what your first observations are when you get close to the defendant.
Well, it was a shape of a body, like the length of a body, shape of a body. She ran over and I said, oh my God. I jumped out of the car. I ran over and she was lifting up his shirt to try and warm him, I guess. So I went over to his head and I began to dig his head out of the snow.
Can you take us back and describe for us what you're seeing?
His body was completely covered, but his head was completely covered. So I started to dig around his face and his eyes, and his left eye was fine, but his right eye looked like it was huge, like he had something happen to it. And after that, I told Karen to get off him. We were going to start CPR. I had been certified at work through the American Red Cross, so I knew chest compressions were more important. So I started to do chest compressions, and I yelled to Jen and told her to call 911. Karen was trying to do mouth-to-mouth. I don't know if she knew what she was doing, but I knew chest compressions were more important, so I concentrated on that. I yelled for Jen. I carry blankets. I have 2 kids, so I carry blankets in the car. So I yelled to Jen to get the blankets. I don't know what I thought I was doing with blankets, but I wrapped them around his head, just thinking we're trying to warm him up. He was covered in snow.
When you first ran over, you mentioned that his head was covered in snow. Was his head fully covered in snow?
Yes.
When you look down, could you see who it was at first?
At first, no. I had to dig him out.
When is it that you realized that this was your friend John?
When I cleared the snow off his face.
Did you feel his skin?
Did I feel what?
His skin.
Yes.
Okay. And could you tell us how it felt?
It was cold. Like he had been there in the elements for a while.
You mentioned that his head was covered with snow before you brushed off the snow. Was other parts of his body still covered in snow?
Yes.
Can you share with us what you saw?
His legs were covered. His arms were by his side. He was on his back. Karen had lifted up his shirt, so now his shirt was down, but I was doing chest compressions so you could see his clothing. He had blood coming out of his nose and his mouth. And when I put the baby blankets under the back of him, there was blood on the blanket, so I think he had a cut on the back of his head.
Was the blood from his nose and mouth frozen or running?
I don't think it was running. It was not gushing.
You said that you brushed off the snow from John's face.
Yes.
Did you brush it off from both sides?
Yes.
Did you brush it off to the extent that you uncovered his entire face and head?
Yes.
So did you have gloves on?
No.
Bare hands?
Yes.
And that's how you felt the temperature of his skin?
Yes.
When you brushed off both sides of his face, did you ever feel any pieces of glass sticking out of his face?
No.
Did you ever see any pieces of glass sticking out of his face?
I did not.
How long did you give chest compressions for to Mr. O'Keefe?
Oh, I can't be sure. I would say 4 minutes, 5 minutes while we were waiting for the EMTs. I had Jen take over at one point. And then the EMTs came. So however long it took for them to get to us, 6 minutes.
When you were trying to save your friend John, did the defendant say anything?
She was just running around screaming, Kerry, Kerry, Jen, Kerry, Jen.
Was anything said at that point about her taillight?
About what?
Her taillight.
No, when the EMTs were around and they were working on the body. She was running around and saying, did I hit him? Did I hit him? Is he dead? Is he dead?
When you were waiting for the police and EMTs, just briefly, what was the temperature like and the visibility like?
The temperature was freezing because I remember at one point I couldn't feel my knees, which is why I had Jen take over. And the wind was still whipping and the snow was still coming down.
At some point, did help arrive?
Yes, they did.
And when help arrived, what did you do?
I stood back and watched them work on him.
Did you see first responders trying to give first aid to Mr. O'Keefe?
Yes.
How long were you outside for that morning?
At that point?
Well, the entire morning.
Oh, maybe a half hour.
When the first responders were trying to save John, what else were you doing?
I was calling my husband. I called my mother. When they put him in the back of the ambulance, I then made a call to Mrs. O'Keefe. I think I called Mr. O'Keefe first, but he didn't answer. So I called Mrs. O'Keefe and told her John had been in an accident. And she screamed, I can't do this again.
What did you do after that phone call?
The police put Jen and Karen in the back of a cruiser. And I was looking in the ambulance to see what was going on with my friend. So I was standing outside of the cruiser. They were inside. I was standing outside just watching. And Karen was saying, is he dead? Is he dead? Is he dead? And I said, no, they're working on him. I can see tubes moving. I can see them moving. Something, if he was dead, they wouldn't be working on him. She grabbed the front of my shirt and said, are they working on him? And I said, yes, they're working on him. At this point, I think I was in shock. I didn't know what was going on. I didn't think he was dead. I thought they could save him. I knew he was in the ambulance with the EMTs, and I was just hopeful that they were going to be able to do more than I could.
You said that at one point, Ms. McCabe and the defendant were in a car, and then you mentioned at some point the defendant grabbed you. Did she grab you when she was in the car or out of the car?
She was in the car. I was outside of the car.
At some point, did the defendant, Ms. McCabe, get out of the car?
Yes.
Did you go over to the ambulance before it left?
Did I go over to the ambulance?
Before it left?
No.
Did you watch?
Yes.
At some point, did you see the defendant get out of the car, the police cruiser?
No, I didn't see them get out, but they were out at one point.
They were what?
They were out of the vehicle, but I didn't watch them get out. I was watching the ambulance.
At some point, you saw them out?
Yes.
And did they watch, or were they near you when you were watching the ambulance?
Did what?
Were they near you when you were watching the ambulance?
I don't know.
No.
I wasn't concentrating on either one of them. I was concentrating on my friend in the ambulance.
When you were trying to save Mr. O'Keefe, did you ever see any signs of life?
I did not. And I checked his pulse. No, I did not.
After the ambulance took John to the hospital, tell us what you do next.
I left. I told Mrs. O'Keefe, I said, I'm going to come get you. She said, well, I'm going to have Braintree Police take me to the hospital, which was in Brockton. And I said, they're not going to take you to Brockton. I will come get you because neither of their cars had four-wheel drive. So I asked if I could leave, and they said, give me your number and we'll follow up with you. And I took Karen with me. We drove down the street. At some point, she was on the phone with Erin O'Keefe, John's sister-in-law, and Karen was saying, I think he's dead. I think he's dead. I grabbed the phone and I said, I don't think he's dead. He's in an ambulance. He's been in an accident. At this point, I didn't know what was going to happen. At some point in the car, as we're driving, she was on the phone with her mother. And I think when we were driving, we got all the way to the elementary school. And Karen said to me, if anything happens to John, I'm going to kill myself. You're going to have to take care of the kids. And I said, nobody's dying. Nobody's killing themselves. Let's not think about that. And then one of the officers called me and said, do you have Karen Reed with you? And I said, yes. And he said, could you please turn around and bring her back? Her parents are saying that she's suicidal, so we're going to take her to the hospital and section her. I said, okay. I didn't get far, so I turned around, went back. At some point, she was on the phone with her mother, and I got on the phone with her mother and said, I'm going to be heading to the hospital. Let me give you my phone number. It's the same hospital John's at. I'm assuming they're going to the same. That's where Canton takes everybody. And her mother said, please make sure that they don't let her have her bag. There are things in her bag, medicine I don't want her to have. So I said, okay, I will. So we got back to the house, and she got in the ambulance, and one of the EMTs asked me for her phone. So I handed that over, and I said, the mother wants to make sure that she does not have her purse because there's medication in there that they don't want her to have.
Did you see the defendant leave with medical personnel?
Yes, I did.
Before we move forward, I want to step back for just a moment. Did you see when the medical personnel, the first responders, lifted John from the ground and then put him on a bed?
Yes.
Shortly after they moved John from the ground and brought him to the bed to bring him to the ambulance, did you go back to where John lay when you first saw him?
Yes, I did.
Why did you go back to the spot where John was lying when you first saw him?
When they lifted him up, there was grass underneath him, and I could see his phone. So I went over and picked up the phone and the 2 baby blankets that were left on the ground.
So let me ask you, when you went back to where John was lying on the ground, you said you saw grass. There was not snow under him?
No, there was not.
Was there many inches of snow around that area?
Yes.
But none where he was lying under him? You said you picked up a couple of items?
Yes.
Could you repeat that again, what you picked up?
I picked up John's phone and 2 blankets, the blankets that I had Jen get out of the car.
What did you do with John's phone when you picked it up from the ground?
I put it in my pocket and gave it to a first responder when they came over, or I handed it off to a first responder.
And the blankets you picked up, were they in the ground area or on snow as well?
They were, I don't remember.
Okay. How long after you put the phone in your pocket, do you remember when you gave it to a first responder, how long you had it for?
I don't remember.
Do you remember the time that you picked up the phone?
I do not.
Have you seen video of that event?
Yes.
And does that video have times when you went over and picked up that phone?
Yes, but I don't remember, somewhere around 6:12, 6:19.
And you don't know how long you kept it in your pocket before, until you gave it to a first responder?
I do not.
At some point, did you get in your car during that morning before you left and drove from the scene?
Yes.
Do you know if John's phone was still in your pocket when you first got into your car?
I don't know.
Was your car heated that morning? Did you keep
Yes.
it running?
Yes.
And was the heat
I
on
think
it?
I kept it running the whole time. I don't even think I shut it off.
I see. I want to now step forward to where you left us when you said that you had spoken to John's mother, Peggy. And did you decide what you were going to do next?
After I dropped Karen back off at 34 Fairview to get in the ambulance, I then made my way to Braintree, barely. I was on the highway. I was the only one on the highway. I spun out a couple times.
Can you describe
right
what you mean by spun out?
near- the driving was, no one else was on the road. The driving was horrible. So I spun out almost at the Braintree exit to get to their house. And then I got to the O'Keefe's house and I said, we are not taking the highway back to Brockton. We're going back roads, which is a much longer way, but there was no way I was putting us in the car and that treacherous.
When you went to the O'Keefe's house, you mean Peggy O'Keefe and John O'Keefe Sr.'s house?
Yes, John's parents.
That's different than Meadows Road.
Correct.
When you got to the home, did you go in?
Yes, for a second. They were ready and waiting for me. They wanted to get to the hospital.
When you say they, can you tell us who was waiting for you?
John's parents, Mr. and Mrs. O'Keefe, were waiting.
What happens next?
Mr. O'Keefe said something about a Dr. Rice and that they were trying to warm John up. We got into the car. Mr. O'Keefe got in my passenger seat. Mrs. O'Keefe got in the back seat. Mrs. O'Keefe's niece worked at Good Samaritan, so we were trying to get in touch with her to see if we were going to be allowed in because there was still COVID restrictions. John's brother was already on his way there. And Mr. O'Keefe at some point said, "He's gone, Peg," and he slammed his hands on the dashboard. But they didn't actually know if he was gone yet. At one point, Karen called me from the ambulance, and on the phone, Mrs. O'Keefe said, "Karen, what happened?" And she said, "I left him at a party." And Mrs. O'Keefe said, "And you just left him?" And Mr. O'Keefe said, "All right, that's enough. She's been through enough." Then we hung up with her. I said, "We're on our way to the hospital."
Let me ask you a question. When the defendant said that she left him, did she say whether she left him outside or inside?
No,
Was the question, follow-up question, never asked?
no.
Okay. Was there any other conversation with the defendant at that point?
Not in the car, but when I got to the hospital, she called me multiple times from the hospital room.
We'll get to that.
Okay.
How long did it take for you and the O'Keefes to get to the hospital?
I would say maybe 45 minutes to an hour.
You share with us the mood in that car.
I think I was in shock, and I think they were in shock. There wasn't, other than talking to Mrs. O'Keefe's niece, trying to find out if we could go in for COVID reasons, there wasn't much talk.
When you finally get to the hospital, take us through your first steps. What happens?
We finally get to the hospital. We walked in. Paul, John's brother, was there. We went over to him, and then Susanna, Mrs. O'Keefe's niece, came out from her office and offered to take me to the bathroom to wash up because I had blood all over my hands. So I went into the bathroom, and I asked her afterwards if she could take me to the chapel so I could say a prayer. So she did. She took me to the chapel, and then when I came out, she took me into her office and explained to me that a Dr. Rice was going to come talk to the family and take him into an office and talk to the family, and then the family would be able to go see John.
Did you get a chance to see John?
I did.
Would you be willing to tell us a little bit about what you saw?
Objection.
I waited in the waiting area. I spoke to my mom. Phone calls were coming in because people had heard what happened. And Mrs. O'Keefe, the family went in to see Dr. Rice. I watched them go in. I watched them walk down a hallway. And then when they came back out, Mrs. O'Keefe told me he was gone.
Strike that statement, folks.
Without telling us what anybody said to you, please just share with us what you saw.
I went into the hospital room, and John was in a neck brace. At this point, there was a trail of blood going toward the gurney or the bed that he was on. This time, both eyes were filled with blood. They looked like raccoons. That's the only way to describe it. I thought he was going to look better seeing him in the hospital because he had been worked on, but he was not. There was much more blood.
Were there any other ways that John looked different in the hospital than when you first brushed the snow off his face in the front of Fairview?
When I brushed the snow off his face, his left eye was fine. It had an ice cube on it that I pulled off, but the right eye was out to here, like a golf ball. When I got to the hospital, both eyes were swollen with, it looked like blood. They looked purple.
Your Honor, may I approach?
Yes.
May I quickly approach sidebar?
Okay.
She is very largely consistent, like almost scrupulously consistent. Wonder what's going on with court TV there. With her initial testimony, the main thing that's different is her demeanor. She was very, she cried a lot during the first trial, particularly when she's describing finding John, seeing him in the hospital and stuff like that. She has a much, dare I say, colder demeanor this time. Don't know if it's like she doesn't want to be there. Don't know if she's like, I mean, you know, part of me feels like these witnesses for the Commonwealth either perceive or maybe have been told, like, oh, hey, everyone's going to hate you because, you know, Free Karen Reed is gonna, you know, they're gonna be mean to you and so forth. So it seems like maybe there's a little bit of anticipation with that, and that kind of also is part of my read on Timothy Nuttall and why he was so anxious, because he's expecting he's going to be hated, and that you know, people are going to think he's a bad guy for showing up and doing his job, when he in his mind knows, like, he's a hero, man. He's there to help people, he's there to save people, which is exactly how you would know. Like, he didn't say, nobody said I hit him, because you, the hero, would have followed up on that. You would have tried to find out, what does that mean in terms of his injuries that I need to identify and potentially be able to treat. So I'm hearing, okay, court TV is broken. So I'm going to get us over to Boston 25 here. See if I can find where we're at when they went to sidebar. Okay. Let me just switch this over.
Yeah.
Recognize that.
Yes, I do.
Is that how John looked?
Yes, he did.
I asked that the camera not on that, please.
I'd like to mark this as an exhibit. I will not publish it. May I approach around?
Yes.
Thank you.
Are you ready?
Yeah.
Okay. After you last saw your friend John, what did you do?
After the hospital?
I'm sorry, ma'am?
After the hospital,
Yes.
I drove. Well, we went back into the corridor with the family. And Karen at one point called from the hospital asking me, she said her father was on his way and could I go over and greet him or bring him to the O'Keefes when he arrived. And she described him. Her father did arrive, so I went over and said, are you Mr. Reed, or something of that nature? And I said, Mr. O'Keefe would like to speak to you. So Mr. Reed went over and spoke to Mr. O'Keefe. And Paul and John's parents and I, we didn't know next steps. We were waiting to see if we could leave or if we have to give information. And eventually we were able to leave. So I drove Mr. O'Keefe home and Paul drove Mrs. O'Keefe home to John's house.
Before you left John, did you take a bracelet from him?
When Mrs. O'Keefe and I went in to see John in the hospital, there was a bracelet that was on his right wrist. It was a blue, like, rubber bracelet. And that bracelet was made when his sister passed away, and her husband, and he wore it all the time. Mrs. O'Keefe still wears it to this day.
Did you drive the O'Keefe back to their home?
I drove Mr. O'Keefe back to John's house, and Paul drove Mrs. O'Keefe back to John's house.
You went back to John's house on Meadow?
Yes.
When you arrived at Meadow with Mrs. O'Keefe, did you go in?
I arrived with Mr. O'Keefe, and no, I did not go in.
What did you do next?
I went home.
At some point after you went home, did you return to the O'Keefe residence or Meadows?
Not that day. The next day I did.
Where did you go?
Where did I go?
Yes.
I went to go to see the family the next day.
And where were they?
They were at John's house at Meadows.
So they were then staying at John's house at Meadows?
Yes.
Did you go and visit them?
Yes, I did.
Why did you do that?
Because my friend had just died and I wanted to be with the family.
Were there other people that were coming and going?
Yes.
Describe the level of traffic of people coming and going to Meadows that next day.
There were people coming from all over. John's friends, people from Canton, people we went to high school with. There was people coming in and out, dropping off food.
When you were there the next day, how long did you stay for?
Several hours. Maybe like 2.5, 3 hours.
Did you ever see the defendant there?
I did not.
Now, you had told us that you had only met Miss McCabe once before that night.
Yes.
And after that night, shortly after what happened, did you speak to Miss McCabe again?
Yes.
How often?
Very often. We wanted to know what happened to our friend, so she would call me.
I'm going to allow that. Not what you said. Next question, please.
Would you speak to her on the phone often?
Yes.
Regularly?
Yes.
And so things changed
Yes.
after that moment.
Yes.
Did you start to see her in person?
Yes.
Spend time with her?
Yes.
For somebody who was not your friend, why did you, at this point, form this close bond?
I think because we went through something horrific together. We bonded over it. Mrs. O'Keefe at one point did say, you two need to sit.
Did you ever write down a list of things that had happened to try to remember?
Yes.
When you were spending time with Miss McCabe, did you become friendly?
Yes.
Friends?
Yes.
How close of friends did you become?
She to this day is a close friend of mine.
To this day?
Yes.
When you were at the scene, when you were trying to help John, there were police officers and first responders?
Yes.
Now, you're from that area?
Well, yes. I'm from Canton, but not that side of town.
And you are active in the community at all?
Yes.
Sports, children?
Yes. Yes.
Do you know a lot of people from Canton?
Yes.
Did you know any first responders?
Yes.
Who did you know that you saw that night as a first responder?
That morning,
Yes, I'm sorry, that morning.
Mike Lank is my friend's daughter's father. No, my daughter's friend's father. I'm sorry.
Your daughter's friend's father. And
Yes.
does he have children that are friends with your daughter?
Yes, his daughter is friends with my daughter.
How close are his daughter and your daughter?
There's a group of 5 or 6 of them that are best friends.
Are you on a first name basis with Mr. Lank?
Yes,
When you saw him that morning, did you recognize him?
I did.
Did you speak to him?
I said, Mike, is that you? He said, yes. That was it.
Are you friends with Mr. Lank's wife?
I am.
How often had you been to their house with the children or on your own before that day, before that morning when you found John?
Well, often when the kids can't drive. So when they do sleepovers or whatever, you drop them off, pick them up.
Your children would sleep over each other's house?
Yes.
So you had a friendly relationship with Mr. Lank before you found John?
Yes.
And do you continue to have a friendly relationship with him?
Did what?
Do you continue to have a friendly relationship with him?
Yes,
Did you go to his house the day after you found John?
I did.
Who were you with?
Well, Jen and I had gone to the O'Keefe's house together with, I don't know if it was 1 or 2 of her daughters and both of my kids. And then when we were leaving, my daughter said, can you drop me off at Mike Lank's daughter's house? So I dropped her off.
And did you do that? You dropped her off?
Yes, I did.
When you dropped her off at the Lank house, did you speak to anybody?
His wife came out and got into the back seat just to find out how I was and how the O'Keefes were. And
How were you?
How were they?
How were you?
Oh, I was not well.
And did you have a long conversation with Mr. Lang's wife?
Yes,
Was Ms. McCabe with you?
yes,
After you left the Lang house, you left your daughter at the house?
yes,
You remained in the car?
yes.
Okay. At some point, did you speak to Mr. Lang's wife again?
Yes,
Are you friendly with her?
yes.
Did you ever try to get information, inside information about this case?
No,
After this case began, did you ever come to court?
did I ever come to where?
To court.
Yes,
And what was the reason you came to court?
to support the O'Keefe family.
At some point, did you stop coming to court?
I
Don't answer just yes or no.
Yes,
Okay. Were you aware or watching about any type of news or publication on this?
yes,
As you were watching and learning information, did you begin to contact people at the district attorney's office?
yes, I did.
Did that include victim witness advocates?
Yes,
Did it include law enforcement assigned to the case?
Objection.
The form of the question, I'm sustaining the objection.
Who did you contact?
specific names?
Yeah.
Steve Nelson, my victim advocate, Yuri Buchanan, who was a state trooper, and at one point I contacted Michael Morrissey's office.
Do you remember at any time being interviewed by police officers or state police about this case?
At my house on January 29th.
So that same day you found John, you were interviewed?
Yes,
Do you remember who interviewed you?
I do not.
Do you remember your mental state at that time?
I was not well. It was in the evening at some point.
Were you interviewed at a later time by any other law enforcement?
Yes,
Okay, and where were you at that next interview?
I think I was at Jen's house. We were making a timeline together when two law enforcement showed up to question her. But I happened to be there, so they took us in separate rooms and questioned both of us.
Were you sober at that point?
Yes.
And what was your mental state then?
Still, we hadn't even had a funeral. So I was still, I couldn't believe what was happening.
And after John's passing, did you still continue to help out with the children?
Yes.
With the court's permission, I would like to play an exhibit that's already in evidence.
Okay,
It's Exhibit 4.
all right.
Before you start it, ma'am, I'm going to show you a video from the scene that night, okay? Ms. Gilman, is this sound? Thank you. Could we start at 6:09:50, please? Could you stop there, please? Ms. Roberts, do you see yourself in that video?
Yes,
And where were you in that video?
I'm over near the flagpole.
What were you doing in that video before you stood up?
I think I was picking up the phone and the blankets at that point.
You see the first responders getting there?
Yes.
Okay. Continue, please.
She did stick something in her pocket right there.
Is that you with the fur on the hood?
Yes.
That's you in the middle of the street?
Yes, I'm to the right of the car.
Somebody needs to teach Canton PD how to change wiper blades.
Could you stop for one moment, please? Ma'am, you see the other two people in the middle of the screen right now? Do you know who they are?
That's Karen and Jen McCabe.
Do you see the proximity or the closeness between them?
Yes.
You are not close to Jen McCabe in this video.
No,
Is there a reason why?
I didn't really know her. And Karen was running around like you saw. I didn't want to be near her. I just found my friend.
Okay. Could you continue, please, to 6:15? You can let it run, please. Stop, please. Thank you. Ms. Roberts, is this when the first responders were moving John from where he was laying?
Yes.
Please continue. Could you continue to watch the area near the flagpole, please?
Oh.
Stop, please. That last 15 or 20 seconds of video, did you pay attention to that, Ms. Roberts?
Yes, that was the moment that I picked up the phone and blankets, not before. I don't know what I was doing before when you asked me.
And that location where you picked up the phone and blankets, was that where John was lying?
Yes, it was.
And is that where you saw the ground that did not have snow?
Yes, it was.
At that point, had you put the cell phone in your pocket?
Yes.
If there's no objection with the court's permission, I'd like to watch a little more of the film, but if we can double speed it so we get an opportunity to view it, I want to get to another moment in it.
Okay, any objection?
No objection.
Thank you.
Around 16, 17 would be fine, Ms. Gilman. Stop, please. The person in the blue jacket, do you know who that is on the right side of the screen?
That's Jen McCabe.
And you can't see you now. Do you know where you are at this point?
I don't know where I am.
Continue, please. What are you doing, Ms. Roberts?
Cleaning off my car.
Could you please stop? Did you mention at some point you went back and the defendant, Ms. McCabe, were in a car?
They were in a police car at some point.
Did you do anything with them when they were in that car?
At one point, Karen asked us to say a prayer, to pray, so we said a prayer.
Was it before or after this moment on the video? Do you know?
I don't know.
Okay. If you could continue, please.
That dysfunctional wiper is like killing me. Change your wipers, dude. You know you had a blizzard coming.
Stop, please, just for a moment. Do you know where you are at this point, Ms. Roberts?
No.
Okay. If you can continue, please. Was that you walking by, Ms. Roberts?
Yes, it was.
Note the time is 6:21:22. Do you know where you walked?
No,
Are
I do
you
not.
behind this car, this dash cam view?
Say that again?
Are you behind the view of the dash cam?
I think it looks like I went over to the right of the vehicle.
Okay. Stop, please. This is, for the record, 6:23:08. At 6:23:08, are you still beside or behind the view of this car?
I believe so.
And do you know where Ms. McCabe is at this point,
No,
or the defendant?
no.
Please continue. Ms. Gilman, when it reaches 6:24:18, if you would stop again.
Well, this is kind of boring to watch the whole thing all the way through. I kind of appreciate it. Instead of jumping all around piece to piece and you don't necessarily see how everything connects. Kind of hope they do this with all the dash cam video.
At this time, 6:24:18, are you within view of this camera angle?
No,
Where do you think you are in relation to this camera angle at this point?
I'm still either to the right or behind the dash camera.
And do you see the defendant or Ms. McCabe in this view?
No,
And this is at 6:24:18. Could you continue to 6:26:25, Ms. Gilman? Did you notice the first person that came from the right and the second person that are not law enforcement?
That was myself, and I think that's Jen McCabe.
62625. Continue, please. And do you know who that is on the right with the police officer?
That was Karen.
Do you know where the cell phone is at this point, Mr. O'Keefe's cell phone?
I don't know. I could have handed it to a first responder at this point, or it could still be in my pocket. I'm not sure.
Ms. Gilman, if you could next stop at 63448. Was that you walking by in the street?
Yes.
Very long conversation Jen is having with everyone.
Do you know who you're speaking with?
I don't know. Mr. Brennan, at this point, can we pause this and take our morning recess, please?
Yes, Your Honor. Pause, please. Thank you.
Folks, why don't we take 15, 20 minutes?
Court, all rise, please. Jurors, close your notebooks, leave them on the chairs, and follow me.
You are muted.
So that was, since that was so riveting. Okay, so what we are going to be keeping our eyes open for as we hopefully get more dash cam video is that time frame between about 6:21 when Kerry is walking kind of past her car back to behind the patrol car, up to around the 6:23, 6:24 kind of time frame, because that is when, according to Jen McCabe, they were sitting in the back of the car, and Karen asked her to search, told her to search, Haas long to die in cold. Obviously not that, but just, asked her, Google how long it takes for somebody to die in the cold. And according to her, that is when she did so. And that is what, revived the tab that she had previously opened at 2:27 a.m. to search for Hockomock Sports that then got picked up in Celebrite, according to their theory, under the browser state.db database, and was marked as deleted. This is the whole dispute about the Hoslong to dying cold, the search, when it happened, how it happened. So this time frame is important because that is what that is when, Jen McCabe says that's when the search actually took place. And it was, according to her, when she and Karen were in the back of the patrol vehicle. So we'll see. You can't see anything from this particular angle, but there is other dash cam. So I know this is a little bit excruciating, guys. Honestly, I really do. I like it. I appreciate being able to see the entire thing through from beginning to end, instead of just kind of chopped up and having to keep track of, what's the timestamp of this and the timestamp of that. I hope he does it with the other dash cam video. I really do. I know it's not the most riveting. Really isn't high entertainment TV, but it's just helpful, I think, in terms of getting a better picture of what happened. So going back over Kerry's previous testimony. So once again, she cried a lot in the first one. And that's kind of my read on why the defense chose not to cross-examine her. You have to be very, very careful with handling a sympathetic witness. And she came across, I thought, in the first trial as very sympathetic, very affected by, remembering that morning and seeing John in the hospital and all those types of things. I don't think she is coming across nearly that sympathetic this time. Now, obviously, she had a few moments where she did, have her quiver and had to wipe her eyes and stuff like that. But just overall, it's a different impression because now when she's kind of not in that mold, she is in a much, icier, almost haughty kind of attitude. Now, remember, Kerry Roberts is not necessarily a nice girl. Okay, we learned about this from the first trial. She describes herself as John's very good friend, and and she's focused on him, and she missed him, and that's what she's affected by, and so forth. Karen, not really very close to. I think there's a decent indication from the first trial that she definitely does not like Karen. And not only doesn't like Karen, potentially has contempt for Karen. And the reason why is because Jen McCabe had outed her during the first trial as making this comment about Karen being a babysitter with benefits. She was just a babysitter with benefits. John didn't really care about her. And she'd also made some other comments in the first trial that they just kind of give the impression that, yeah, she has contempt towards these women that John dated. And so when she described it in the first trial, she said he dated lots of women. Some of them were very nice. And then she described when he was going to introduce her to Karen, when he said he was going to bring Karen over. And she makes a comment, I didn't know if he was going to surprise me with some random. So, I mean, ladies out here, we know how we talk about each other. And we know how, how other women talk about other women. When you're talking about a guy with his randoms, okay, these are not women you have a high opinion of. You don't think much of them. And so it just read to me like, Karen never really kind of got out of that random box with Kerry. She was a babysitter with benefits. She wasn't anybody important. She wasn't anybody to be respected. Why? I don't know. I don't know their relationship that well. But I definitely, I know what they said. And I have some thoughts about what that means. Okay. When you call somebody, oh, she's just a babysitter with benefits, you're not being complimentary. So this is not somebody who has a good opinion of Karen to begin with. And why do I bring that up? She's already started to hint at uh, how much communication she and Jen had immediately after, like ongoing, trying to figure out what had happened because they just lost their friend. They went to lengths together. They were at the O'Keefe's together. They had that long conversation in Lank's driveway with his wife. In the last trial, she testified, didn't know exactly how long they were there, but she said she's a talker, so it could have been like 45 minutes. It does not take 45 minutes to cover how you doing. How you doing? Well, things are a little bit tough. Oh yeah, I can only imagine. It's so terrible what happened. Yes. Where do you go from there for 45 minutes? And then they're at Jen McCabe's house. She's at Jen McCabe's house. This is going to be what, the next day or very soon thereafter. And they are making a timeline together when the police show up to interview Jen McCabe. So they've had a lot of opportunity to talk about what happened. And this is exactly why you need to keep the witnesses separated. You need to not, have them communicating with each other, because you have the possibility of tainting their recollection. Remember, every time you retell it, every time you remember it, you are rewriting it. And so the reason I bring up Kerry's antagonism towards Karen is because, to me, that explains how and why she would be receptive to remembering things in a way that don't put Karen in a very bad light, in a very good light. Because that's kind of consistent with what she already thinks of Karen. I don't like her. She was crazy. And in hindsight, it seemed sus. She tells us at the time, didn't seem suspicious. Karen says, did I hit him? She's like, no, of course you didn't. Nothing about it at the time seemed suspicious. Didn't seem to tell law enforcement at the time. Yeah, nobody could see him, but she could, and it's almost like she already knew he was there. No. No, she didn't tell anybody that at the time. Didn't put together the pieces. The taillight's broken, piece sticking out. Karen seemed to already know he was there. Karen's asking, did I hit him? Didn't put any of that together at the time, did she? Report any of that? So these are the kinds of things that can coalesce and build as you have time to reflect and as you're trying to reconcile it with your pre-existing worldview. So you already think Karen's kind of contemptible. You're going to see things in that light. John's phone. It's interesting to see Mr. Brennan following up on John's phone like this, because John's phone, it is an important piece of this puzzle. And part of the reason why we saw the Ring camera footage from when they went into the house, we didn't see the Ring camera footage from when they left. And that's because it doesn't exist. It's been deleted, we're told. This is what we're told in the first trial. And so then the question is, how did it get deleted? The Commonwealth has tried to suggest Karen did it. And it's part of the consciousness of guilt. Because if the story that they're telling is correct, they came out of the house, she showed them the taillight. Don't necessarily want to see police to see that. So she went in and deleted it to hide it. That's the Commonwealth's theory. The problem is they can't prove she ever had access to be able to do that. The way to access the Ring camera is through John's phone. John had a desktop computer in his house. They spent some time at the last trial trying to establish, like when Karen went back to the house after the hospital and she was alone in John's room, maybe then she got in. They're never able to prove that Karen had access to John's computer. It's password protected. They testified about downloading or getting a search warrant for records from Ring. And you think there'd be a log, right? You think there'd be a log of who accessed when, at what point, actions that were taken. This is fairly routine information that software programs will store. But no, seemingly didn't get it. So who had John O'Keefe's phone in order to be able to delete the Ring camera footage? That's kind of the million-dollar question. Kerry's putting it in her pocket for an indeterminate amount of time. But she doesn't remember when and who she passed it off to. It's a problem for the chain of custody, because certainly that person should have documented it. It should have been in their report. It's evidence. You secured it at the scene. You took it back to Canton Police Department or, Norfolk County District Attorney's Office, wherever we're making the kind of headquarters for the investigation at this point, because that's all a little bit messy. You took it back. What did you do with it at that point? Did you put it in the temporary storage at evidence? Did you book it into evidence? Did you give it directly to Proctor? Did you give it to somebody else? We don't have any kind of record of that. All we know is that Kerry Roberts claims it's in her pocket, and then at some point it shows up in Michael Proctor's possession. So it's kind of an important question. Who had John's phone when? Because John's phone seems to be the access point to go in and delete that Ring camera footage. But there's no indication Karen ever had that phone. I don't think they can put that phone in Karen's hands. So where has the phone been? Who had it? Michael Proctor, I believe we're told he had the password. Was he given the password? I'm gonna have to remind myself about that one. So it is kind of interesting to see Mr. Brennan going into all of this in the detail that he is, because these aren't necessarily, the strong points for him. But the question is going to be, does the defense have this put together and organized enough that they're going to be able to present it as the problem that it is? Is that going to be clear to the jury that this is a problem? And the problem is, when your cross isn't real targeted and it's a little bit all over the place, you kind of lose track of what's really important and what isn't. I know I keep harping on this, and it's, of course, easy for me to sit at my desk, not doing the cross-examination of any of these witnesses and say, oh, here's how I do it better. Yeah. Please don't get me wrong. I'm not saying that. I'm just saying there are different styles and different things that people find work for them. Mr. Jackson's style would not work for me. What I find most effective when I'm watching a cross-examination, it's short. It's short. The best cross-exam, 5 questions, maybe 10 at the max. And that's because you know what matters. It's very, very short. You don't have to kind of sort through, okay, all of the combat. What am I supposed to be taking out of this? Is this an important point? Are we getting sidetracked by how the witness is answering the question and quibbling over that rather than what the answer is? It's just my perspective. 5-question cross, generally speaking, far more effective than a 1-hour cross. But it's not, doesn't seem to be the style of this team. So that's just part of my kind of background concern that I have about is the defense really going to be able to get these points across effectively to the jury? Because there's so much here to work with. There's so much here to work with. That phone, John's phone, who had it, when, how'd the Ring camera footage get deleted? This is all very important stuff. Now, it kind of seems like maybe the reason why Brennan is going into it a little bit more is because, of course, we have a little bit more evidence now. We have the temperature data. We have the temperature data. When was that long drop? That long drop he described? Let's just go ahead and go back to his opening and check the timeline. He doesn't get into the timeline in the morning. It's just down to 1:14 in the morning. It's at 50 degrees. So that's where he stopped in his opening, his story of the temperature of the phone. So what we would expect based on Kerry's story, I would think, is that the phone was extremely cold until, what's her timeline now? Uh, 6:09 is when she initially said, it's like right when they first arrived, and she's over by the flagpole, and you can kind of see her stick something in her pocket. It looks like you see her stick her hand in her pocket. That's when she originally identifies. That's when I got John's phone. So that is early. That's at like 6:09 on dashcam. I'm going to try to flip over here to 10 because I hear the sound maybe a little bit better. And there's a big cobweb on the light up there that is also going to drive me nuts. So then, we'll keep working through this at the break.
Yes.
Thank you.
It's about 6:13. when she changes and says, that's when I picked up the telephone. When you see
Ms.
her
Roberts,
picking
we
up
have
the
about a minute and a
blanket.
half left. I want to watch the video until it reaches 6:35, please, Ms. Gilman.
So you'd expect at that point the phone starts to warm up, and it really should stay consistently warm. Maybe change a little bit from body heat to room temp. But the point where the phone starts to warm again should tell us when the phone was picked up.
Do you know where you are at this point, Ms. Roberts?
No.
Could fast forward just a little bit more, please.
Even Kerry can't watch this video and track what's going on. She's lost attention.
Were you in the car?
I just got out of the car.
And do you remember if your car was warm?
Yes.
Stop, please. 6:34:36. Do you see yourself?
Yes, I just got in the driver's side of my car.
And at that point, do you remember whether you still had John's cell phone or you had given it to a first responder?
I don't remember.
Between you having it in your pocket and giving it to a first responder, did you put it or place it anywhere else?
No.
Did you take it out of your pocket and place it in the elements at all?
No.
So it was either in your pocket or in the hands of a first responder?
Yes.
Thank you for your time.
So did it get cold? Is that the problem? Did the phone get cold again? Didn't place it in the elements, you're sure? So another Mr. Jackson Cross.
Your Honor, may I? Thank you. Good morning, Ms. Roberts. How are you?
Good morning.
Under questioning by Mr. Brennan, you talked about the number of times or a number of times that you have spoken to the DA's office or some member of the DA's office. I'd like to ask you a couple of questions about that.
Hang on,
Sure.
something's going
How
on
many
here.
times
Sorry.
in total do you think you've
I think I got a background tab open or something. Yes, that's that annoying noise. Oh my gosh, we fixed it.
spoken to a representative of the district attorney's office?
I don't have a number.
Would you say it's more than a dozen?
Yes.
Would you say it's more than 50?
Maybe around there,
Okay.
maybe less.
And who are the folks, Ms. Roberts, that you have spoken to at the DA's office?
Steve Nelson,
Okay.
the victim advocate, Yuri Buchanan, who's a state police officer, and the DA, Michael Morrissey.
And what was the, I want to take those in order, and two of those are at the DA's office. One of those is not. Yuri Buchanan is not at the DA's office. He's actually a Massachusetts State Police officer. Is that right?
Yes.
Okay. Let's take those in order. How many times would you say you've spoken to Mr. Nelson? Just if you can give me a thumbnail.
I don't know, maybe 30, 40.
Okay. Have you received what you would consider to be updates on the progress of the case?
I would ask questions and he would give me very broad answers.
Okay. Were your questions ever prompted by conversations that you had with your friend, Miss McCabe, Jen McCabe?
Sometimes Jen would say, could you ask Steve this? Because I had a rapport with Steve.
Okay. Were those conversations by text message or phone calls or both?
I would usually text him.
Okay. What about the conversation with, or conversations with Mr. Morrissey, the elected district attorney? What were the circumstances under which you contacted Mr. Morrissey?
Well, during the course of this trial, the witnesses have been harassed,
That's not my question.
Objection.
but I'm answering your question.
Hold on. I'm going to sustain the objection. Next question.
Thank you. Were you phoning him? Were you meeting him? Were you texting him? That's my question. The circumstances of the communication itself.
I phoned the office asking for a meeting, had a meeting, and then he left a voicemail at some point and texted me and said, I just left you a voicemail.
Okay. Was that the extent of your conversations with Mr. Morrissey, the elected DA?
I had one other meeting with other witnesses
Okay.
and the DA.
And turning to Yuri Buchanan, what were the logistics? I'll use that word instead of circumstances. What were the logistics of you contacting Yuri Buchanan? Was it by phone? Was it in-person meetings, text messages, or all of the above?
All of the above.
How many times would you say that you've spoken with Yuri Buchanan?
Spoken or communicated?
Sorry, good point. Communicated with.
Probably 20.
Okay. When was the last time? Actually, let me ask you a different question. Have you ever met with Mr. Brennan before your testimony today?
Yes.
What was the circumstance of that meeting?
Going over my testimony from the last trial.
Okay.
And sort of just asking questions on what might come this time. Would I be cross-examined? I wasn't last time. Just sort of, all the things went through my testimony.
Okay. When was that meeting?
I don't know, in the last couple of weeks. I don't know.
Okay. Where was the meeting?
At the DA's office.
Who else was there?
Different times that I would meet with him. Steve Nelson would be there. One time, Brian Tully was there. Mr. Brennan's assistant.
I'm sorry.
Mr. Brennan's assistant.
Okay.
I don't know.
She's been there multiple times now.
Adam Lally and Laura McLaughlin.
Were those meetings, you said there was 2 meetings? Or did I misunderstand you?
Yeah, I think there were 2.
Okay. Were those close in time to one another? You mentioned 2 weeks ago. Were those both 2
I
weeks?
said a few weeks ago, but the other meeting was just before I was going to testify.
Meaning, what, yesterday, the day before?
Last week.
Was that also at the DA's office?
Yes, it was.
Were you shown anything at that meeting?
Was I shown anything?
Videos, testimony, transcripts,
No,
reports?
no,
A couple weeks
Nothing?
ago. No, last
I
week.
don't think so.
Okay.
We went over my testimony on the screen. And then I just talked about my testimony from the last time.
So your
Okay. When you say
testimony
you
was
went over
on a
your testimony
screen.
on screen, what do you mean?
You were
You
shown.
watched my testimony from the first trial on a TV screen.
Okay, so you were shown something. You were shown a video of your prior testimony.
Yes.
So I'd like to see counsel at sidebar for just a minute, please. You are.
What's up with Bev needing to break this up? Already shifty, having a hard time keeping the story straight. She met Brennan before the testimony today. When a couple weeks ago to go over her testimony from the last time, what might happen this time. But then as soon as she's asked who's there, she now it's not just one meeting a couple weeks ago. It's at different times. At different times, Steve Nelson was there. Once Tully was there. Brennan's assistant was there. Lally and McLaughlin were there. And that was just last week, right before she was going to testify. That's not the law of primacy and recency, right? What is going to be the first thing you remember? Often it's going to be the most recent thing. It's not necessarily going to be the most recent thing if there's something like more significant, you know, the more important one or the more recent one. Just kind of noticeable how things are slipping. Things are slipping. Trying to keep it confined, but it grows. But it grows. Who meets with the prosecutors 50 times? 50 times. That's a lot. That is a lot. And yes, sometimes Jen would say, could you ask Steve this? And I'd usually text him. Okay, guys, pretty sure another thing I remember from the last trial is that they have her phone extraction. She also gave her phone over just like Jen McCabe did. But that would have only been
Yes.
Thank you. Other than watching your testimony, were you shown anything else? Transcripts, videos that you may have seen today, dashcam videos, anything like that?
I don't think so.
Okay.
I don't think I was shown anything.
Okay. Did you discuss other parts of your prior testimony?
Yes.
Okay. What was discussed concerning your prior testimony and how it would impact how you testify today on direct examination?
Mr. Brennan had just asked me, can you just tell me what happened? So I told him the story verbally.
Okay. Anything come up about specific instances of how you were going to testify today?
No.
Or yesterday?
No.
Okay. I want to talk to you a little bit, Ms. Roberts, about the video that you were shown by Mr. Brennan. It's the dash cam video of Officer Seraph. I'm not sure if you know which officer that is.
No, I don't.
It's the one that you've been watching.
Okay.
That dash cam that shows your car in the foreground.
Yep.
I'd like to ask you a couple of quick questions about your memory of that incident and then perhaps show you the video depending upon what the answer is.
Sure.
Do you remember when the officer first arrived, you and Miss Reed specifically were at Mr. O'Keefe's body?
Yes.
Where was Miss McCabe at that moment?
She was there too, but she was waving down the first responders because it was dark out and he couldn't see us. He had a spotlight.
You and Miss Reed were both providing some level of CPR, some level of life-saving efforts.
Yes, as was Miss McCabe.
What was Miss McCabe doing?
When I was doing chest compressions and Karen was doing mouth to mouth, Jen was either on the phone with 911 or handing me baby blankets.
Okay.
At some point, she did take over doing chest compressions because I asked her to.
Okay. So Miss Reed was focused on Mr. O'Keefe's head, face area.
Correct.
You were focused on the chest.
Correct.
Miss McCabe was, at some point at least, she had called 911 or dialed 911.
Yes.
When Miss McCabe dialed 911 and was on the phone with 911, isn't it true that she was actually in a vehicle at the time?
That is not true.
She was outside?
She was outside.
That's your memory?
Yes,
Okay. Have you heard the 911 tape of that call?
yes,
Okay.
When?
You're aware that that tape was also captured by an open line on Miss Reed's phone?
yes.
That open line that phone was dropped inside the cab of an SUV?
It was in the back seat, I believe.
Right. So in order for that for that open line to capture sort of the background of Miss McCabe's side of the 911 call, Miss
Yep.
McCabe would have had to have been either at or in the cab of the truck.
The back of the SUV was open. She was standing there.
Got it. Okay. So she was right next to or adjacent to the cab of the SUV.
She was in back of it with the back was up.
I see that back hatch.
Yes,
Okay. Do you remember Miss Reed's statement, her initial statement to Officer Seraph when he got out of his
I
patrol?
do not.
Do you remember her saying something to the effect of, "My boyfriend, I left him, he never came home"?
I do not.
Okay. Have you listened with audio to that dash cam at the moment that Officer Seraph arrives at the scene and y'all flag him down?
We just watched it.
Right. Have you listened to it for the audio side? I mean, in other words, instead of focusing on the
no.
video.
No.
Okay. I'd like to ask you to do that with the court's permission. This is it's been previously marked as Exhibit 4. And with the court's permission, I'd like to play that from runtime about 3:50 and ask the witness to concentrate most readily at about 4:07, maybe
Okay.
10 seconds into it. I'm going to give a little run up and then ask you to listen very
Okay.
closely to the audio.
Yep.
With the court's permission?
Yes.
Okay, Evan. Stop. Do you recognize the video as being the same video that you saw and you looked at on direct examination?
Yes.
Okay, in just a quick second, the door to the car, you're going to hear it open. I'd like to ask you to pay special attention to the audio portion and Miss Reed's voice,
Okay.
if you can hear it. Go ahead. Stop. Did you hear that last statement?
No.
Did you hear a woman's voice kind of faint in the background?
I heard a voice, but I didn't make out what she was saying.
Okay. Did it sound like she said, "My boyfriend, I dropped him off and he never came home"?
Objection.
Could you hear that, Ms. Roberts?
No.
Okay.
Next question.
That's all I have for the video. We can take that down.
I do not find that effective. You know she was going to say no.
You talked about, on direct examination, some of the injuries that you saw Mr. O'Keefe having suffered, both what you observed at the scene and then what you observed later at the hospital.
Yep.
And you noted those injuries, correct?
Say it again?
You noted those injuries. Those were,
Yes.
You made note of those,
Yes.
or at least some of them. You said you saw a hematoma of some sort over his right eye. Is that right?
Correct.
And there was some significant swelling to his right eye
Correct.
at the scene.
Correct.
Did you also notice a laceration just above his right eye, just under the eyebrow?
I saw it at the hospital, but I don't know if at the scene I saw it.
Fair enough. At some point, you saw that laceration to his right eye?
Yes, I did.
Did you also see a laceration to the left side of his nose, a smaller laceration to the left side of his nose?
I don't recall. I know there was blood coming from here, but I don't know if it was coming from inside his nose or from a laceration. I don't know.
When you said here, you're pointing to the left side of your nostril.
Yes.
And basically just above the nostril, correct?
Yes, right around the nostril, there was blood coming this way.
Okay, draining to the left side of his cheek?
Yes.
Okay. You also saw, once you got to the hospital, that his left eye had swollen as well.
Now, both eyes were swollen and filled with what looked like blood.
And his left eye was black as well as his right eye.
Correct.
Okay. You also indicated that you saw, well, actually, I don't know if you did or not, so I don't want to put words in your mouth. I apologize. Did you see his right arm?
I did.
Did it appear to you that he had some abrasions or lacerations, parallel abrasions and lacerations and punctures on his right arm?
They were scratches.
Scratches. Ms. Roberts, you've previously testified that when you arrived, let me take you back instead of jumping right into it. After you met up with Ms. Reed at Jen McCabe's house that morning, so this is just after 5 o'clock or so, the three of you arrived back at One Meadows, correct? Is that right? I'm sorry.
Correct.
Okay. You're trailing the Lexus SUV, correct?
Correct.
The Lexus pulls in to the driveway and you pull in directly behind Miss Reed and Jennifer McCabe is driving.
Correct.
You're driving your SUV, correct?
Correct.
You've previously testified that when you arrived at One Meadows at that moment, that once that SUV, the Lexus SUV had pulled in and you pulled in behind the Lexus, you got out of the Lexus, sorry, you got out of your SUV, they got out of the Lexus, and that's a point at which Karen showed you the back of her taillight and said something to the effect of, do you think I hit him? Do you think I hit him? Oh my God, do you think I hit him? Do you recall that?
I recall saying I didn't know if it was when we were coming or going, but she did point out the taillight.
Okay. When you previously testified under oath, your quote was, quote, Karen pulls in and I pull in behind her.
Mr. Jackson.
Siren.
Page and line numbers when
Yes.
offering statements.
Sure. It's the SGJ, the grand jury, page 58, lines 14 through 19 for court and counsel.
Thank you.
Did you testify, quote, Karen pulls in and I pull in behind her, period. When we get out, and Karen is now showing us the back of the car saying, my taillight, do you think I hit him? Do you think I hit him? Oh my God, do you guys think I hit him? Question mark. End quote. Is that how you testified?
May I see it?
Sure.
Oh, she learned from Jen. May I see it? Can I see if that's what I said? Give me some time to think about how to explain
I've
it.
already got it up here.
Does it have a date on it, Mr. Jackson?
It does.
She last time just acknowledged that she was wrong, but she was a little snotty about it. She's like, well, obviously, because we just watched it and it didn't happen. It happened when we came out.
426:22. May I approach?
Yes.
Thank you, sir.
Thank you. Do you have the pages after this?
I'm sure I do.
Because in the pages after this, I say,
My question, Ms. Roberts, is that a quote that I just said, is that accurate? Do you see it in the,
yes, it is.
okay. May I approach?
Yes.
So definitely doubling down on the Jen McCabe strategy. What else is in there?
Your Honor, may I approach?
Yes.
What redirect is for? John Mayer is going to approach. Subtitles are hilarious sometimes.
I'm going to show you both pages. That's the page I asked you to look at, and then the following page as well. Please take your time.
Okay.
May
What
I?
I'm looking for is still not here because I did say I wasn't sure if it was
Yes.
before or after.
Ms. Roberts, you do have to wait for a question.
When you gave this testimony, you were in front of a grand jury, correct?
I'm not sure which one that is.
Do you remember testifying in front of a grand jury on April 26th, 2022?
Yes,
Okay, about 2 years ago.
yes,
3 years ago. You were under oath at the time. Is that right?
yes,
Things were fresher in your mind at that time than they are now, 3.5 years later, I'm guessing, right?
yes,
Okay. You were asked the question to describe the circumstance when you arrived at One Meadows. Is that right?
yes,
And the answer that you gave was, quote, we pulled into it's a driveway, there's 2 cars, and then 2 cars, and then a single, so John's car is there. Karen pulls in, and I pull in behind her. When we get out, and Karen is now showing us the back of the back of the car, saying, my taillight, do you think I hit him? Do you think I hit him? Oh my God, do you guys think I hit him? That was your testimony at the time, correct?
yes.
And just to be clear, I'd like to take a look at a quick video that you may or may not have seen before. We'll find out. Your Honor, I'd like to have this. Actually, this has already been previously marked as Exhibit 12C as in Charlie.
Okay,
Oh, this is
And
the
it's a
clip
short
of the.
clip, so I'll play the entire clip with the court's permission.
okay.
Let's go ahead and take a look at that video. Can you pause? Do you recognize what's depicted in the video?
Yeah, that's when we arrived at John's house.
Okay. And who's the person with the plaid red pants?
That is Jen.
And who's the person that's just rounding the back of the car in front?
That is Karen.
What is the car in front?
That's Karen's SUV.
That's the Lexus SUV.
Yes, it is.
Behind that Lexus SUV, Ms. Roberts, is there another car?
That's my car.
And who's getting out of that car?
I am.
Okay. And this is the point that you were describing in your, at least in the grand jury testimony at that time.
Yes.
This is the time that you're describing.
That I thought it was when we walked in.
This is the time that you were describing, right? When you arrive at the scene.
Yes,
Or, arrive at One Meadows.
yes.
Okay. Let's go ahead and play this through.
Guys, what I noticed is the snow. There's really not that much
Okay,
snow
you can
there.
stop it. And you can bring the lights up. You saw the interaction between all 3 of you and the vehicles, correct?
Yeah,
At any point, did anybody stop and take a look at the tail light or the rear end of the car?
not when we were entering the house like I thought, but when we came out.
Okay. And there's no video of that.
I'm sorry?
There's no video of that.
No, I don't believe so.
Right. So the video that does exist describes nearly exactly the time that you testified that y'all stopped at the back of the taillight and Karen said, look, my taillight's broken. Oh my God, do you think I hit him?
Correct.
Okay. And that obviously was incorrect.
He was incorrect.
So your memory was faulty about that incident, that part of that incident at least.
It happened on the way out of the house.
So your memory was faulty about that part of the incident that you testified to at the grand jury.
Yes.
Okay. You were interviewed on January 29th. You've already testified to that, correct? By
Yes.
Troopers Dunn and my memory's failing me now.
There were two. I don't know who they were.
Okay, I'm sure it's in my notes somewhere. 2 individuals that interviewed you on January 29th, correct?
Yes.
Obviously, things were very, very fresh in your mind at that point.
Yes, but I believe I was in shock. So,
The incident had just happened.
yes.
Okay, and you were asked to recount certain of the specifics about the incident that you had just experienced, not days or weeks, but just hours before, correct?
Yes.
Okay. And you did your best, I'm sure, Ms. Roberts, to be as full-throated as possible, to provide them with as much detailed information as you could and to be as honest as you could.
Yes.
I mean, you weren't going to lie to these police officers, right?
No.
Good setup.
In your very first conversation with those two troopers on January 29th, you didn't mention anything about a taillight or a cracked taillight, or
No,
you
I did
haven't
not.
seen a cracked taillight, did you?
No, I did not.
Okay.
I
You
didn't
then-
want to accuse anybody of anything.
You were then interviewed on February 1st, 2022, a few days later, correct?
I don't know.
Does that
I
sound
don't know
right?
the exact date. I was interviewed again, but I don't know the exact date.
Okay. During your interview, let me withdraw that and ask a different question. On February 1st, or whatever day it was, the subsequent time that you were interviewed just a few days later, you did then, for the first time, describe the taillight that you saw, correct?
I don't know.
Would it refresh your recollection if you looked at a report?
Yes, please.
Okay.
So that's her explanation for why she didn't act as though those were things that she heard at the time. She didn't want to accuse anyone. Is that a reasonable explanation for your friend is gone? You've positioned yourself as kind of the caregiver to his family, the comfort for his family. And you wouldn't want to accuse anyone. Might have something to do with it. Same person
Let me have
who
just a moment, Your Honor.
Sure.
goes to the prosecutors 50 times because, witnesses are being harassed. She really learned a lot from Jen McCabe. I'll bet she watched Jen's testimony
Yeah,
from the last
Yes.
trial.
I'm handing you a 2-page report, Ms. Roberts. I put a little dot on the second page just to direct your attention to the discussion related to the taillight, if you want to take a look at that.
Okay.
Okay. May I?
Yes.
Does that refresh your recollection that you were interviewed on February 1st, 2022 by a trooper by the name of Connor Keefe and a trooper by the name of Kathleen Prince?
Yes. Did Connor Keefe write that report?
I'm sorry?
Did Connor Keefe write that report?
Does it
Trooper
matter?
Kathleen Prince wrote the report.
Okay.
Does that matter? No?
Nope.
Okay. Does that refresh your recollection that you did discuss the taillight?
Which one did you
at that
see
time?
before?
And
Look
did you
at.
tell Trooper Prince and Trooper Keefe that you noticed the back right taillight in the middle, quote, in the middle, your words, was broken and a piece of the metal encasement was pushed forward?
Yes.
Okay. You didn't say that the taillight was completely shattered, correct?
Correct.
You didn't say that the entire lens was missing, correct?
Correct.
You said it was broken in the middle. Is that
Yes.
right? And then you described today that a square piece was missing.
Yes. That's the piece I was referring to in the middle.
Just in the middle of the taillight, though. That was how you described it.
Yes.
Okay. I'd like to shift gears for a quick second and talk about a March 7th, 2023 text message with victim witness advocate Steve Nelson. Do you remember communicating? You don't have to know the exact date, but if you do, fine. Do you remember communicating in March of 2023 with victim witness advocate Steve Nelson about the Ring camera at One Meadows?
Ooh.
I don't know the exact date, but yes.
Okay. Is it true that you contacted him to inform him that the O'Keefes needed to replace or wanted to replace the driveway ring camera, that same ring camera that we just literally saw through that perspective
Yes.
of you arriving?
Yes.
Did Mr. Nelson indicate that he believed that would be fine to replace that ring camera if the O'Keefes wished to do that?
I don't remember if he said it would be fine, but at some point they were told they could replace it. It had broken. It wasn't working.
Did he indicate that he would check with DDA Adam Lally and then get back to you?
I don't know.
At some point, you were informed that the O'Keefes had the green light or the go-ahead to replace that ring camera at One Meadows. Is that right?
Busy siren morning.
Yes.
Okay. And then ultimately, you then relayed that to the O'Keefes that they had the green light. You've talked to somebody at the DA's office, and they said, yeah, go ahead and replace the camera, correct?
Yes.
Okay.
She was the go-between with Nelson.
Did you ever receive any kind of a response from the DA's office either before or after you relayed this information to the O'Keefes to say, wait, hold on, we need to do a reconstruction, we need to make sure that the camera is in the exact same spot that it was at the time of the incident?
No.
Any communication like that?
No.
So the communication that you got was, yep, go ahead and replace it, it's no big deal.
Correct.
Okay. And ultimately, you learned that the O'Keefes did, in fact, replace that ring camera.
Correct.
You have already described your relationship, at least in part, with Canton Police Officer Sergeant Michael Lang, correct?
Yes.
He is friends with you.
His daughter is friends with my daughter.
Your friend Lee with the family.
Yes.
Okay. And you're aware that he's also friends with the Albert family.
No. Well, no,
Were you aware that Michael Lang grew up with Chris Albert?
I was not.
Have you ever been in a social setting with both the Lanks and the Alberts?
No.
You're aware, obviously, you were at the scene. He was the first officer to respond to the crime scene at 34 Fairview on January 29th after Officer Seraph and after Mulaney arrived. Right? And then it was Sergeant Lang.
I don't know which order. I did see Sergeant Lang there, yes.
Was he the, excuse me, sir. I was just reminded, you indicated that you don't remember the date of that text communication between yourself and Mr. Nelson.
No, I don't remember the date.
Would it refresh your recollection if you looked at a text message between the two of you about the subject of the ring camera?
Just making sure
Do I
she
need to know the
knows
date?
May I approach?
he's got the
Oh, okay.
text.
Sorry.
Thanks.
Because this doesn't matter. March of 23, more than a year later, they want to
March
replace
7th,
the
2023?
ring video. I don't know why that
Yeah.
matters. Is it going somewhere? We'll see. But otherwise, it seems like he's just letting her know he's got the text.
You indicated that you did recognize Sergeant Lang at the scene.
Yes, I did.
You had a conversation with him.
No, I said, Mike, is that you? He said yes, and that was it.
All right. Following that, the next day, you did go to his house. You've already described that.
I did.
You indicated that you went to his house to drop off your daughter for a play date. Is that right?
Yes.
But you also indicated that you took Jennifer McCabe with you.
Yes, because I drove Jen McCabe to the O'Keefe's house, so she was leaving to go home with me. So I was going to drop her off.
Okay, so your memory is you took Miss McCabe from where over to the Lanks house?
I think she was at home.
So you picked her up
Yes.
at her house
Yes.
with anybody else?
With my daughter, my son. I picked up her and either one or two of her daughters. I don't remember.
And then you drove over to the Lanks house, is that right?
No, I drove to the O'Keefe's house.
First.
Yes.
And what did you do with the O'Keefe's
Then
house?
left a couple of kids, and my daughter wanted to go to the Lanks house, so I drove my daughter to the Lanks house before driving home.
And Jen's child was with you on the way from Jen's house over to the O'Keefe's house?
Yes, 1 or 2 daughters. I don't know.
Dropped the 1 or 2 kids off at the O'Keefe's, is that right?
As well as my son.
As well as your son. Then you went to drop off your daughter for the play date.
Well, she was 13, so it wasn't a play date.
Whatever, I don't know what you call it.
I know.
I don't have a 13-year-old. What a date, whatever it is.
So she went over to her friend's house, yes.
Okay. But you took Jennifer McCabe with you
Yes, because I was driving her home.
back to her house without her kids?
Yes, she was going home.
Were you going to go back to the O'Keefe's and pick up her kids and then take all of them home?
I didn't have a plan. I mean, Patrick,
Okay.
nephew, is my son's best friend.
Got it.
So he wanted to be with him.
Okay. Did you, I think you just answered this, but I want to make sure I'm clear about it. You didn't take separate cars. You all went in the same car. Is that right?
Correct.
Okay. Did anybody stop by or go by 34 Fairview during that roundabout?
No,
Nobody stopped off at that 34 Fairview either on the way or on the way back?
no. I don't believe so. That wouldn't be the route in which to get to my house.
Right, exactly. You indicated
got
that you
location
stayed,
data.
even though you were dropping off your daughter, y'all stayed, you and Miss McCabe stayed at Sergeant Lank's house for some 45 minutes. Does that sound about right?
Yeah,
And Sergeant Lank's wife, you indicated, was in the backseat of your car?
yes.
Did y'all ever go inside the house?
Jen went in to go to the bathroom.
Was Sergeant Lank there?
I don't know. I didn't go in.
You didn't have any communications with Sergeant Lank?
I'm sorry?
You didn't have any communications with Sergeant Lank himself, Mike Lank, on that trip?
No, I did not.
But you don't know whether or not Jen did?
I don't know whether or not Jen did. She went in the house to go to the bathroom.
Okay.
Interesting.
You've indicated that there have been occurrences in which Jennifer McCabe has asked you to contact the DA's office on her behalf to ask a question here or there, get some information, correct?
To Steve Nelson, yes.
Okay. How many times, just a number of times, the volume, would you say that Ms. McCabe has asked you to reach out to the DA's office in one particular or another? On her behalf?
I don't think very many.
What does that mean? Of the 50 times that you've had
No,
communications?
maybe like 4, not many, to my knowledge.
Qualifying, very careful.
When you would, on these 4 occasions or 4 or so occasions, when you would reach out to the DA's office, gather information, whatever that information may be, would you then report that information back to Ms. McCabe?
Yes.
You obviously understand the importance of providing statements to law enforcement that are free of influence of other people, other witnesses. Is that right?
Say it again?
You understand the importance of providing information to law enforcement as a witness to law enforcement free of influence from other people.
Yeah,
In other words, you want to be as accurate and as independent as possible.
yes.
And that's because if your statement is somehow, or if your communications with law enforcement are somehow influenced by others, it might call into question the credibility of the person providing the statement.
Objection.
Can you answer that question, Ms. Roberts?
No.
Okay, next question.
Sure. A statement that's been colored by influence from someone else would lack credibility, right?
Objection.
Sustained.
I want to talk about the statements in the prior testimony that you have provided in this case, Ms. Roberts. There's been several of them. The first time you told your story to law enforcement was on January 29th. We've already established that, correct?
Say that again?
It was on January 29th, the first time you relayed your story to law enforcement.
Yes.
And that was to Trooper Dunn and Trooper DeChico. That's the name I couldn't remember.
I don't remember.
But you do remember Trooper Dunn.
I remember 2 troopers. I don't know their name.
Okay. Where did that interview take place?
In my dining room.
And who was with you when you gave that interview, if anybody?
My husband was home. I think my daughter was home at that point. My husband was home. I don't know if the kids were home.
Nobody else from outside the family?
No.
Okay. Who contacted you about doing that interview? How did they know to come to you at your home?
I don't remember. They may have just shown up. I don't remember.
Okay. Do you remember what time the interview was?
Maybe around dinner time, maybe around 5, 6.
Was it recorded?
I'm sorry?
Was it recorded in any way? Tape recorder running?
I don't think so.
The troopers were taking notes, obviously?
I believe so.
During your conversation with, and I'm jumping around a bit, so I apologize. During your conversation or conversations with Mr. Brennan and the members of the DA's office in preparation for your testimony, were any of those interviews recorded?
No.
Was anybody taking notes?
No.
No, none of the DAs were actually taking notes, the ADAs?
I didn't look around the table to see if anyone was taking notes, but I didn't see them taking notes.
No pads and pens on the table?
There was a lot of stuff on the table, but I didn't see anybody taking notes.
Okay. You received a phone call just before that interview started at 5:25 p.m., correct?
Around 5 o'clock, 6 o'clock. Is this the night of the 29th, you mean?
This is the night of, I'm jumping back to the night of the 29th.
Yeah, I'm not following you very well.
That's okay. On the 29th,
Yeah.
when you were interviewed around 5:25 p.m., maybe just a little bit before that,
Yeah.
you received a phone call just before that, correct?
I do not know.
Isn't it true that Jen McCabe called you and spoke to you just before that?
I spoke to Jen McCabe the entire day.
Okay. Including just before that interview?
I don't know.
Did you tell Jen McCabe that you were about to be interviewed?
No.
Did you tell her at some point did you text her and tell her that the officers had arrived?
I don't think so.
Did she text you back and say, call me right after?
I don't know.
Okay.
I don't know.
During the course of that interview, when the incident was still pretty fresh in your mind, you indicated that at about 5 a.m. you got a call from Karen Reed indicating that John never came home and that she was worried, correct?
Correct.
You also indicated that she was worried that John may be walking and may have gotten hit by a plow. You relayed that to the officers.
Yes.
You indicated that you met up with Karen Reed and Jennifer McCabe at Jennifer McCabe's house, and Karen was hysterical and worried that something had happened to John.
Yes.
You also indicated that once you were at 34 Fairview, once y'all had made your way over to 34 Fairview, Karen saw John and ran to him, although you and Jennifer didn't see him initially, correct?
That's correct.
You said that Karen was repeating the phrase, is he dead, over and over. Is that right?
That is correct.
You also indicated that she said that if anything happened to John, she'd kill herself, correct?
That's what she said to me.
Object.
So the objection sustained.
Why? It's already in evidence.
Did you indicate at any time, I'm sorry, let me ask a different way. Did either of the troopers indicate to you after your initial interview that if there was anything further that you could recall that would be useful, please provide it? Please give it to at that time.
I don't know.
Okay. Would it refresh your recollection to look at that January 29th report?
Sure.
He's confronting her with very specific text messages, which suggests that he has these text messages, but he left it as she doesn't remember.
Report, January 29th. And there, I put a little mark by paragraph 5. If you could take a look at that.
And that's going to potentially really irritate me because of what we talked about yesterday. Impeachment versus refreshment. He hasn't refreshed her, but he also hasn't laid the foundation for impeachment. If he's going to impeach her with it later, he needs to ask her, do you deny it?
Okay. Ma'am?
Yes.
Do you deny these texts?
During this interview with Trooper Dunn and Trooper DeChico, they indicated after you gave your statement that if you wish to provide anything additional, now is the time to do it.
Objection.
Sustained.
Were you informed that you were limited on time in that interview? Meaning, we got to get this done, we're leaving, we're out of time.
No,
They didn't cut you off, correct?
no,
They didn't tell you that they had a limited amount of information that they wanted and then they were just going to leave, correct?
I don't remember. I don't recall.
As a matter of fact, they told you that anything you wanted to provide to them, provide it. Give them as much detail as you could, correct?
I don't recall.
Okay. You just read the last statement that these troopers indicated, correct? If there's anything further she could recall that would be useful, please provide that information.
Object.
Sustained.
John, may we approach?
Yes.
This is, I'm not sure where this is going other than he just is building up a lot to the fact that her story, like everyone else's, has evolved over time and in the context of having a lot of communication with Jen McCabe. I don't like not setting up the groundwork to impeach her with this text. And I'll tell you why. Yes, I realize he might be trying to get it in with Jen instead. He might hold it for Jen. It's not a good idea to hold your cards at trial. You don't know what opportunity you're going to get or not get. And so when the opportunity presents itself, if this is something important for you to get in, you need to get it in. Get it in now.
May I?
Yes.
Thank you. Having looked at the report.
No, bring it to her and show it to her again.
She's just, it's the same thing that I just showed her. Having looked at the report, does that refresh your recollection about what Trooper Dunn and Jachico told you at the end of the interview?
I don't recall. It's not refreshing. I'm not remembering it. Even reading it, I'm not remembering it.
I see. Okay, fair enough.
So do you deny it?
So as you sit here, the details about what you told or what those two officers told you are not fresh in your mind, and nothing's refreshing your recollection about that.
Right.
Okay, but you do remember the basics of what I just described in that conversation with those two troopers.
I mean, they asked me what happened. I told them, but I was also in shock.
You never said during the course of that interview that my client called you at 5 o'clock in the morning just hours earlier and said he's dead and then hung up, correct?
No, I don't believe I said it at that point. I did not remember that until a couple of days later.
I see. And in fact, when you were asked about that particular statement, when you asked about that particular series of events, that never came to your mind.
No.
That literally the first words out of Karen Reed's mouth, according to you now, is he's dead and then hung up.
Correct.
When you heard that, you didn't take that to mean that she killed him.
No.
Of course not. She was panicked, correct?
Yes.
You did add that, one other thing that you didn't add in your initial statement to Trooper Dunn and Trooper Jachico is anything about the taillight either, correct?
Not.
Okay. And you also didn't say anything about any sort of a Google search or the praying that you talked about in the back of the patrol car, anything like that?
No.
Okay.
I don't know. I don't remember.
No, I don't know. I don't remember.
The second time you were interviewed, that was the February 1st interview. That was with Kathleen Prince and Connor Keefe, correct? And you just looked at that report, or at least part of that report. Is that right?
Say it again.
Connor Keefe and Kathleen Prince, that was on February 1st, 3 days after your initial statement, correct?
I don't remember the date, but I remember meeting with them.
Okay. I want to make sure I get the dates down, so I'm sorry to belabor this, but. May I approach?
Yes.
Would it refresh your recollection if you were looking at the report of that interview?
It might.
Okay. First paragraph.
Thanks.
You don't remember, do you deny it? I want him to start following up on every single I don't remember with do you deny it? Put her
Am I
on the
reading the whole
spot.
thing or just the part where you dotted?
Just if it refreshes your recollection
Oh.
of the dates.
Oh, for the date, yes.
May I approach?
Yes.
What date was it that you met with me?
February 1st.
That second interview was conducted at 12 Country Lane, correct?
Yes.
And who again lives at 12 Country Lane?
Jennifer McCabe.
So the second time you told your memory, your story to law enforcement, you were literally sitting in Jennifer McCabe's house.
Yes.
And you had met with Jennifer McCabe before your interview, correct?
Yes. We were putting a timeline together.
So you two were actually prepping, if that's a valid term, prepping for your interview, putting a timeline together, correct?
We were putting a timeline together at the request of Mrs. O'Keefe.
And Jennifer McCabe, was helping you with the timeline, and you were helping her with the timeline.
Yes, we were putting together the events of what had happened.
So she was helping you, and you were helping her, yes or no?
Yes.
Okay. So both of you were assisting in each other's memories, correct?
Yes.
I remember this, and you remember this, and okay, now I remember this, correct?
Yep.
Obviously, that would help influence your memory, going
Yes.
over the event with someone else, correct?
Yep.
So what's on that timeline, you would agree, is not completely independent, your memory. It's a combination of your memory and Jennifer McCabe's memory. Isn't that right?
Yes.
May I have just a moment, Your Honor?
Yes.
Thank you, Your Honor. So the two of you drew out some sort of a timeline for you to follow during the course of that interview. Is that right?
For me to follow what?
During the course of that February 1st interview, as you were interviewed in Ms. McCabe's house. I mean, that was the purpose of the timeline, to help you with that interview?
No, that wasn't the purpose of the timeline.
You used it for that purpose, though, obviously.
We did not. I was at Jen's house making a timeline, and the two officers showed up to interview her. I just happened to be there.
Right. And when they interviewed you, did you have that timeline in front of you? That's my question.
No, I did not.
Okay. But you had just created it along with Jennifer McCabe.
Some of it.
Okay. And then it was after that that this timeline was coordinated between the two of you, that you actually told your second story to Trooper Prince. And when I say second story, I mean the second time you were interviewed on February 1st as opposed to January 29th. Is that right?
Yes.
Did you ever become aware of text messages that Jennifer McCabe was sending to others in a group chat talking about you in that interview?
No.
You were never told or became aware that she sent text messages to a group as she listened in on your interview?
No, I don't think she could listen in. She wasn't anywhere near me.
You weren't aware that or are you aware as you sit here that she sent a text message that said she's telling them everything, all the stuff?
Sustained.
Have you ever been provided a text message or told about a text message that perhaps Jennifer McCabe was sending to a group?
No.
Listening to your suggesting that she was listening to your interview?
No.
The third time you told your story was later that night in a telephonic interview. Is that right? With Trooper Proctor?
I requested to speak to Trooper Proctor because I had remembered the very first time I spoke with Karen that morning, and I wanted to make sure it was recorded.
Okay, that wasn't my question. My question was, did you have another telephonic conversation with Trooper Proctor, yes or no?
You said that night, but it wasn't that night.
When was it?
I think it was earlier that day.
Okay. But it was after the interview with Trooper Prince.
I don't think so.
I think it was beforehand?
I think it was beforehand.
You were still with Jennifer McCabe when that call took place, correct?
I was in her house. I was not with her. I stepped away to speak to him by myself.
in her home at 12 Country Lane.
Correct.
Who else was with you other than Jennifer McCabe in the house?
Her sister was there writing down the timeline for
Who's
us.
that?
Her sister,
Nicole?
Denise.
Denise? So she was scribing the timeline as you and Jennifer McCabe were creating
She
it?
was writing it down as we were remembering things.
Right. And the three of you were doing this together, sort of communally.
Yes.
She would say something, then you would say something, then it would spark something that she would say, and back and forth, correct?
Yes.
How is it that Trooper Proctor got a hold of you? Did you call him or did he call you?
I think he was on the phone with Jen and I asked to speak to him.
So Trooper Proctor got a hold of you through talking to Jen McCabe.
Well, I asked to speak to him, but yes.
Right. Was that interview recorded, to your knowledge?
I don't know.
The fourth time you met with police was February 2nd, the very next day, at about 12:08 p.m. Is that right?
I don't remember.
Do you remember signing a consent form for your phone?
Yes.
Was that the next day after this interview with Trooper Prince and Trooper?
I don't know what day it was. It was right after Karen was arraigned for the first time. Jen and I met with them and both handed our phones over willingly.
So you just answered my question. So when you met with police, whatever the date was, it was a few days later, you met with police yet a fourth time, you were still in the presence of Jennifer McCabe when you met with police.
Yes.
And handed your phone over, is that right?
Yes.
And she handed her phone over, is that right?
Yes.
And the two of you were together when you signed your consent forms, is that right?
Yes.
The fifth time you told your story was in front of a grand jury, is that right?
I don't know.
Do you remember testifying in front of a grand jury?
I do.
Okay, let's talk about that for a second. Before you testified at that grand jury, just physically, you were brought into an anteroom where you waited to be called by ADA Adam Lally, correct?
Yes.
Who was in that anteroom with you just before you gave your testimony?
My husband and Jen and Matt McCabe.
So Jennifer McCabe was with you yet again.
Wow.
Just before you gave
Yep.
official testimony under oath concerning this case and concerning the incident.
Correct.
Ms. Roberts, when was the last time you've spoken to Jennifer McCabe before you testified in this trial?
In this morning.
Did you discuss your testimony?
No.
So you and Ms. McCabe, who became friends because
Correct.
of this incident,
Correct.
talked as recently as this morning before your testimony.
Correct.
And your testimony now is that you did not discuss anything about what you're doing here
No,
or what you're
I
going to
did
testify
not. She
to.
called to wish me good luck today.
When did you talk to her the last time before this morning?
I don't know, maybe a couple days ago. I don't remember.
Within days of you taking the stand yesterday, correct?
Yes.
Did you ever? Can I have this one?
Yes.
Ms. Roberts, I'm going to ask you. To take a look at, actually, let me ask it a different way. Did you say that you did or did not recall texting with Jen McCabe during the course of that January 29th interview with state police? Do you recall that or no?
No.
Okay.
During the interview, I didn't text anybody.
Okay. Are you saying you didn't text anybody or you don't
Yes.
recall?
Are you
whether-
I don't
denying it?
recall. I don't think I had I wouldn't be texting somebody if I was being interviewed by the state police.
Right. Okay. Would it refresh your recollection to take a look at a report of text messages?
Sure.
May I approach you?
Yes.
You don't know or you don't recall is getting a little bit closer to what I'd really like him to do, which is a good old Alex Sparrow. Are you denying it? Do you deny it? Put her right on the spot. Do you deny it? Are you entertaining the possibility that this happened? Oh, it is possible that it happened.
Take a look, there's two tabs. Take a look at the tabs and the data across the two tabs, if you don't mind.
Okay.
Absolutely, absolutely. I'm in a rush. So, Matt,
Yes.
with that. Well, for information, Mr. Brennan,
Okay. Jurors, feel free to stand up and stretch if you'd like. And I forgot to tell you, anytime we're at sidebar, please feel free to stand up and stretch, okay?
That was quicker than we thought, Judge. May I
Okay.
proceed?
Yes.
Okay. Did you take a look at this document?
Yes.
Does that refresh your recollection that there were two text messages at around the time of your interview with those two troopers?
No.
Do you recall
deny
as
it?
you sit here texting Ms. McCabe that the state troopers were arriving or they're just getting there?
No.
Do you recall Ms. McCabe texting you anything back about calling me after?
No.
Okay. Did you, in fact, different question, did you, in fact, call Ms. McCabe right after the interview and talk to her?
I don't know.
Do you deny it? If you can prove it, Alan, do you deny it?
Have you ever testified that at the scene, Miss Reed was seated in the back of a patrol car along with Jennifer McCabe, and you were standing just outside the car, and there was an interaction among the three of you?
Yes.
Have you ever testified, or have you ever stated in any particular, that during that interaction, Karen asked the three of you to pray?
Yes.
Have you ever said or testified that during that interaction where you're seated, where they are seated in the back of the patrol car and Ms. Reed asked you to pray, that Ms. Reed said to Jennifer McCabe, Google hypothermia?
No.
You've never said that.
I've never said that.
You testified at the grand jury on April 26th. Is that right? April 26th, 2022?
I do not
Is that
know.
right? Does that sound right? April 26th, 2022?
I have no idea.
Late April 2022, does that sound right?
I don't know. It was 2022.
You testified under oath, correct?
Yes.
Swore the same oath that you swore here.
Yes.
To tell the truth, the whole truth, and nothing but the truth, but guilty of perjury. Is that right?
Yeah.
Is it your testimony that you have never said that Karen told Jen to Google hypothermia, or that you don't recall saying that?
I don't recall saying that.
Would it refresh your recollection to look at portion of your grand jury testimony from that day?
It might.
May I approach?
Yes.
I hope he gets to, are you denying it this time? If she says, it doesn't refresh me.
Sure.
And if you could read on to page 83 as well.
Yep. I testified. I didn't hear it, but I was told that she was asked to Google it.
Told by who?
You testified under oath at the grand jury that at some point Karen was in back of the police cruiser, correct?
Yep.
Objection.
No, I'll allow that question.
Does that refresh your recollection as to what you told the grand jury?
Yes.
And isn't it true that at some point during the course of your testimony under oath, you said that Karen was in the back of the police cruiser?
Yes.
And then you went on to describe that Karen and Jen and I were standing outside and she made us all start holding hands and starting to pray.
Yes.
I mean, what the she being Karen Reed, correct?
Yes.
And at this point, they had lifted John up and taken him onto the gurney, correct? That's
I don't
what you
know.
described.
I don't recall.
Okay. I'm going to do this again, just so we're clear. May I approach?
Yes.
Sure. Thank you. Just a portion of the bottom of the page.
At the bottom?
At the bottom, last couple of paragraphs.
Okay. Yep, I say I think, so I'm not
I have
positive.
a question for you.
Okay.
Does that refresh your recollection?
Yes.
Okay, thanks. Thank you. And you testified basically that you think, at least that's what you were telling the grand jurors, that you
Yep.
think that was the point at which they lifted John up
Yes.
and moved him into the ambulance, correct? Is that right?
Yes.
And then you were asked a question, what, if anything, did she, Ms. Reed, ask Ms. McCabe while they were sitting in the back of the cruiser that you heard, correct?
Objection.
Do you recall that?
I did not hear the question about Google being asked.
That's not my question. May I ask? May I inquire?
Just repeat that question.
Sure. Isn't it true that you were next asked by Mr. Lally in front of the grand jury, quote, what, if anything, did she, Ms. Reed, ask Ms. McCabe while they were sitting in the back of the cruiser that you heard, end quote? Remember being asked that question?
No.
May I approach you? Yes. Thank you. Thank you. So we're going to look at lines 16 through 18.
Okay.
May I?
Yes.
Does that refresh your recollection? That was the question that you were asked?
Yes.
Okay. And in response to that question, you stated, quote, at one point she asked her to Google hypothermia and how long Google hypothermia, correct?
Mhm.
I'm sorry?
Yes.
That was very detailed. You'll agree that that's a very detailed and specific recount of an event. You recounted where you were, back of a cruiser, or they were in the back of a cruiser, correct?
Yep.
You recorded or reported the time. It was right around the time that you thought they were lifting John up and scooped him up onto the gurney, correct?
Yep. I thought it was about that time. I wasn't sure.
Location,
I'm sorry, I didn't get that answer. You were talking over each other.
That's my mistake.
What was your answer, Ms. Roberts?
I thought it was about the time they lifted him up, but I wasn't sure.
You were very detailed about who was there. It was you. It was Jen. It was my client, Karen
Yes.
Reed, correct? Is that right?
Yes.
You're so detailed that you talked about where you were standing next to the cruiser open door, correct?
Yes.
What the others were doing, holding hands and praying, is that right?
Yes.
And the actual words used, you were as detailed about all of that as the actual words used. She asked her to Google hypothermia and how long, and then you stopped, Google hypothermia, end quote, correct?
Correct.
You will agree, at least for that purpose, you painted a very, very detailed picture in front of the grand jury, didn't you?
Yeah.
Except it's not true, is it?
I did not hear her ask that. I was told she was asked that. In
The
the
answer to my question, Ms. Roberts, and I'm not a trick question, what you told the grand jurors was not true. You never heard her, my client, ask anyone to Google anything, did you?
I did not.
And yet that's what you testified to under oath, under penalty of perjury in front of the grand jury, didn't you?
I did.
And the reason you did that, the reason that you said that false statement was because someone told you to say it, correct?
Object.
Is that, I'm going to let her answer.
Nobody told me to say it. I knew it happened at that time.
How did you
which
know
is
it
why I
happened?
said it.
How did you know it happened, Ms. Roberts, if no one told you it happened?
Because we wrote a timeline. We already spoke about
So
that.
the timeline that Jennifer McCabe helped you with, that influenced your testimony in front of the grand jury, correct? Obviously.
I was telling what happened in the back of the cruiser.
The timeline
You can answer.
you wrote,
So when you ask a question, let her answer, okay?
the timeline you wrote with Jennifer McCabe's help influenced your testimony to testify in front of the grand jurors to a statement that you never heard, correct?
Yes.
You were later asked about that statement in another investigation, by another investigator or set of investigators, correct?
I don't know.
Were you interviewed by a different law enforcement agency, a separate law enforcement agency from the Massachusetts State Police at any time?
Yes.
And you were told that to lie to those agents would be a crime, correct?
Yes.
Punishable by prison, correct?
I was not told that.
They
He's got
asked
the
you
Brio too.
whether or not you heard Karen Reed ever say anything to Jennifer McCabe about Googling anything, correct?
I don't know.
Isn't it true that you told them what you've just now told us, which is, I did not hear Karen Reed ask Jennifer McCabe to conduct any Google searches?
I don't recall.
Would it refresh your recollection to look at a copy of that interview and that report?
Sure.
Can I approach?
Yes.
I'm going to ask you to take a look at the entire document, familiarize yourself with it if you don't mind, including the front page. And don't answer anything about the document until I ask you a question, if you don't mind, please.
Sure.
Thank you.
Yeah, she has that habit of spitting out her response as soon as she's read it before there's a question pending. Yeah, this is the Feds 302. That's the report that they write up when they take a witness interview.
Ms. Roberts,
We're
do you
obviously
recognize that as
talking
being a
about the
report of an interview that you conducted?
I've never seen this before, but
Understood. You may never have seen it, but does it remind you that that's
Yes.
a report of a conversation you had with another law
Yes.
enforcement agency? I'm going to ask you to turn to page 7 of that report. And if you look, there's a small paragraph, about 2 paragraphs up from the bottom. I think I may have put a little blue dot by it, but I'm not sure. Please read that to yourself.
correct.
Done?
Yep.
Thank you. May I approach?
Yes.
Thank you. Ms. Roberts. Ms. Roberts, does that refresh your recollection about what you told these investigators?
Yes.
And what you told them was you, quote, did not hear Karen Reed ask Jennifer McCabe to conduct any Google
That is
search.
correct.
And you went on to say you saw McCabe on her phone.
I'll allow it.
You saw McCabe on her phone, but you did not hear Karen ask Jennifer to Google anything.
Correct.
So what you told the grand jurors was in fact false.
I misunderstood Mr. Lally's question.
Got it. Thank you.
Okay. Mr. Brennan, any questions?
Thank you. Thank you.
Which in fairness is very easy to do.
When you spoke to the grand jury about your memory, were you trying to fool them in any way?
No.
Were you trying to,
Objection.
Watch the form of your questions.
were you trying to mislead them in any way?
Objection.
Sustain. Watch the form of your questions.
When you spoke to the grand jury, were you honest?
Yes.
When you were asked the question, what, if anything, did the defendant ask Ms. McCabe? Did you begin your response by saying at one point?
You can show her her response.
May I approach?
Yes.
Page 83, line 19.
She didn't understand Lally's question, and that's so fair because Lally's questions were terrible. They were terrible. They were so convoluted and hard to follow. Sometimes he would like say every word on his mind in his question.
When you were asked that question by Mr. Lally at the grand jury, did you ever say you specifically, personally heard that statement?
I'll allow that.
Did you
No,
ever
I
tell the
did not.
grand jury you actually heard that statement being made?
I did not.
And when you spoke to the people in that report that you looked at on page 7, did you ever tell them you specifically heard that statement being made?
No.
Were you consistent in both of those statements?
Objection.
Sustained.
Did you say anything different as
No.
far as what you personally observed between those statements?
Objection.
I'll allow that.
No.
And when you were asked about what the defendant may have said to Ms. McCabe or Mrs. McCabe, did you generalize your answer?
Objection.
Sustained.
Did you begin your answer with at one point?
Yes.
When you chose the words at one point, what were you trying to convey to the grand jury?
I'll allow that.
I didn't know at what time it was done.
Was that a topic of conversation around the time you were brought to the grand jury?
Around the time what?
that you were brought to the grand jury to testify? This is Google search.
Was it? I don't know.
Okay. Were you asked here in front of this jury whether or not you personally heard that statement?
Yes.
By me. Did I ask you that question?
No.
Did you personally hear that statement?
No.
After this happened, you discussed what had happened with people, didn't you?
I'm sorry, say it again.
After you found John lying in the snow, did you discuss what had happened, what you saw with other people?
Yes, of
Did
course.
anybody tell you that you couldn't discuss this trauma that you had been through?
Objection.
I'm going to allow that.
Say it again.
Did anybody tell you that you couldn't discuss what you had just seen?
No. Didn't say it again? I'm
Yeah.
sorry.
After you found John that morning, did anybody, civilian or law enforcement, ever tell you you weren't allowed to discuss what you had just went through?
No.
And that's the problem, isn't it?
Did anybody ever tell you that you couldn't have support of other people?
No.
I'll allow that.
No.
Was this a traumatic event?
Yes.
Have you spoken to it to a number of people about it?
Yes.
Tell us why you would want to speak to somebody about what happened that morning.
Objection.
I'm going to allow that.
I've spoken to many people, obviously, that we all grew up with. But Jen in particular, I do speak to her. I am friends with her. We went through a really traumatic experience together.
Did you ever confide in other people other than Jen McCabe about what you endured that morning?
Yes, many people,
Why?
because it helps me get through. And it's whether John's family, friends, whoever, I've talked to a number of people about it.
You're friends with John's parents?
Parents?
John's parents, the O'Keefes.
Yes.
You still friends with them?
Yes.
Do you ever discuss what happened?
Yes.
You were asked by law enforcement if they could have your telephone?
Yes.
Was there a warrant?
Objection.
Sustained. Ask it differently.
Did you feel like you had any obligation, legal obligation, to give your phone to law enforcement?
Objection.
I'll allow it.
No, they asked for my phone. I handed it over willingly.
Did you think you had to?
No, but there was no reason not to.
When they went through your phone, do you know whether they saw all of your phone calls that were on that phone?
Objection.
Do you know that?
I don't know. They cloned my phone, so I assume they saw everything.
Objection. Please.
I'm going to strike that answer. So the answer is I don't know.
What type of information did you have on your phone when you voluntarily gave it?
Objection.
I'll allow that.
Text messages, phone calls, call logs, pictures.
You said that you stayed friendly and still are friendly with Peggy O'Keefe and John Sr.?
Yes.
Okay. At some point, at times, do you try to help them with things?
Daily.
Do you try to help them with the children?
Objection.
Sustained.
Well, you were asked about contacting the district attorney's office about replacing a Ring camera.
Yes.
Whose Ring camera was that?
It was at One Meadows where Mr. and Mrs. O'Keefe, John's parents, are now living.
What motivated you to call the district attorney's office about the Ring camera?
Because we knew the Ring might be some sort of evidence that they didn't want to take the camera that was not working down without permission.
Do you have a Ring camera?
I do.
Do you know if there's a difference between the actual physical camera and the iCloud storage that keeps the actual video on it?
I don't know the difference.
Okay. Did you ever ask to replace any hard drives or storage, or were you asking to replace the camera itself?
Just the camera.
And that was in March 7, 2023?
I don't know when.
You were asked questions about what the defendant said that morning when you were trying to help Mr. O'Keefe.
Yes,
You were asked whether you heard any comments from her about dropping John off.
say that one more time.
You were asked whether you heard any comments about her saying she dropped him off.
In the car on the way to the hospital.
Okay.
She said it to Mrs. O'Keefe.
When you were outside trying to help John, were you ever told where the defendant dropped John off?
No,
Were you ever told where he was left?
no,
Was it ever suggested that he went into 34 Fairview?
no,
Was it ever suggested that he went into any house whatsoever that morning?
no,
Were you ever asked to go into the house to look for him?
no,
When you
Well,
were
why would
being when you were being interviewed by law enforcement, did you ever refuse to be interviewed?
no.
Were the interviews all the same or different?
They were all different. They were all different.
Were you ever asked to give a complete review and detail of everything that you knew?
I was just asked to tell me the story of what happened that morning.
And at some point when you were interviewed, you were asked about the phone calls that the defendant made to you that morning at 5 o'clock.
Yes,
When you received those phone calls, Jennifer McCabe was not on the line, was she?
no,
Was she a party to the calls?
no,
Did she influence your memory in any way about the words that the defendant spoke to you that morning?
Objection.
I'll allow that.
no,
Do you have a clear memory of what the defendant said to you on the morning of January 29th, 2022 at around 5 in the morning when she first called you?
yes.
Is it your independent memory?
I'm saying,
Is it
Sorry?
your independent memory?
yes,
How well do you remember it?
Vividly?
Sustained.
Tell us what you remember her
Remember it
saying to you.
vividly?
Objection.
I'll allow it.
when she first called, she said, John's dead, Kerry, and hung up.
And she called you back.
She called back.
When she called back, was there any other party on the line other than you and her?
No,
What do you remember the second time that she called you?
yes. She said, John, I think he got hit by a plow. He did not come home last night. He would never not have come home. I wasn't supposed to stay in Canton, and Kaylee was here. He would never leave Kaylee by herself.
Did anybody ever ask you to lie
No,
or exaggerate?
no.
Would you?
Say that?
Would you?
No,
Sustained.
You were asked whether or not you told people on January 29th about the missing pieces to the defendant's taillight. And you began to say you didn't tell anybody that morning.
I didn't think it had anything to do with John. I didn't want to point fingers at anybody
Why not?
So which one is it?
because I had no idea what had happened to him. I wasn't going to point fingers at his girlfriend.
Was it in fact broken with missing pieces that morning?
Yes,
You saw the ring video of you and Miss McCabe and the defendant going into John's house.
yes,
Had you seen that video before today?
yes,
Had you been shown it before in
Yes.
other proceedings?
yes.
When you went into the house with Miss McCabe and the defendant, did you do anything before you went into the house, actually in the house?
When
Take any-
we took off our shoes and
You took off your shoes?
Oh, we
Jen
got
and I
her-
both took off our boots
How
Why
Karen
did you take
didn't-
off your boots?
because you had to take off your shoes to go into John's house.
Well, you say you had to. Explain to us a little bit of the background on that.
John was a neat freak. You were not allowed to wear shoes in the house.
Had you ever worn shoes in his house?
Oh,
Had you ever seen anybody wear shoes in this house?
no,
You and
they
Miss
do
McCabe?
now. They do now.
Let's see. You and Miss McCabe took your shoes off?
Yes,
Did the defendant take her shoes off?
she did not.
How do you remember that?
Because Jen and I were standing there for about a good 2 minutes trying to get our boots off, and she had already gone in the house.
Do you know why you were called that morning?
No,
Did you volunteer to be part of this
yes,
after the call?
yes.
That wasn't the
You-
answer he was looking for.
Had said you thought that you looked at the taillight before you went into John's house?
Yes,
Do you remember actually seeing the tail light that morning?
I do.
Was it simply cracked?
No,
Do you know that the portion of the Ring video from when you came out of the house with the defendant, Miss McCabe, do you know that that portion is missing?
Objection.
Sustained.
Have you ever seen any Ring video depicting when the defendant was showing you her missing pieces of taillight that morning?
no,
Despite no video, are you certain that you saw it?
say it again.
Are you certain that you looked at it with the defendant that morning in that driveway?
Objection.
Sustained.
I'd like to play clip 3, please.
Okay.
Objection.
Okay.
So he did back up to bring in the didn't take off the shoes. I remembered that from the first trial. I really didn't fully understand what they were trying to get at then.
Quiet, folks, still on the record.
And I'm not sure I understand what he's getting at with it now. We already know Karen was frantic this morning. That's really all it sounds like. She was frantic, didn't take off her shoes. But it's like, what? So what are we trying to get? Are we trying to get at the, oh, she already knew he was never coming back? I mean, is that what it's supposed to be? So she didn't bother to take off her shoes. I don't know.
This now. All right, go ahead, Mr. Brennan.
When you first got to John and you were trying to save him that morning, do you have a distinct memory of it?
Yes,
Counsel had asked you if it was your story. Was this a story?
say it again.
Was it a story that you told?
A story?
Yes.
It's what happened.
Do you wish it was just a story?
Objection.
There's no further questions.
Okay, so recross.
You just asked, just a few minutes ago. Did you ever say that you actually heard that statement about that Google search? And you said no.
Correct.
The question that was posed to you by Mr. Lally was, what, if
I
anything,
knew he was going to
did
revisit
she,
this.
Miss Reed, ask Miss McCabe while they were sitting in the back of the cruiser that you heard,
Right.
correct?
I misunderstood the
And
question.
you misunderstood that question?
Because what did you hear
What did you
about?
misunderstand about that question?
I didn't know it was that you heard, so I was explaining what happened in the back of the car.
I see. So you just ignored the part, literally, the part of the question where he said, what did you hear her say? That's what your
The word
testimony
was
is now?
heard, and I didn't hear it. I obviously got the question wrong because I did not hear anybody ask about a Google search.
Well, I know that's what you're saying now. I get that. But when you were asked, what, if anything, did she ask Miss McCabe while they were sitting in the back of the cruiser that you heard, your immediate answer was, at one point, she asked her to Google hypothermia and how long dash Google hypothermia, end quote. Correct?
Correct.
That was your answer,
Yes.
correct?
To a question I misunderstood.
And that was a false statement, wasn't it?
Technically.
Technically?
Yes,
It's like being a
technically.
little bit pregnant, Ms. Roberts.
Okay, so remember, jurors, I said earlier, comments of counsel are not evidence and you're to disregard them. Ask a question.
And it's getting
Thank you, Your Honor.
argumentative.
What do you mean technically?
Technically, I was under oath and I did not hear Karen asked Jen to Google it,
And yet under oath.
but I
you-
knew it happened at that
And yet
time.
under oath, you said you did.
Correct.
And that was a lie, correct?
Objection.
Was that a lie? Did you lie?
I did not intentionally,
But you did.
And,
not intentionally.
okay, that's the end of
Understood
this.
the question, Mr. Jackson.
All right, is there any other question or is that it?
I didn't hear what she just said.
I said I misunderstood the question, Mr. Jackson.
That's what you're saying now, correct?
Jackson.
That's what happened.
All right,
Can I ask one more question?
okay.
In that quote, you said, at one point, she asked her to Google hypothermia and how long. Then you corrected yourself and finished with Google hypothermia. What did you mean by how long? What were you about to say?
I don't recall.
Had someone told you something about a phrase that started with how long?
I don't recall.
Hypothermia?
I don't recall.
Like, for instance, how long to die in cold?
I don't recall.
Okay. All right, Ms. McKay, I'm sorry, Ms. Roberts, you were all set.
Thank you.
Spent meeting after meeting after meeting talking with Jen, going over the timeline, but doesn't recall
May I?
Yes.
how long.
I'd like to play clip 3, please.
Your Honor, before this is played, is it possible to take a quick break so we can review this? There's a lot of clips. I'm not sure what this is. I'd like to see it before it's played.
All right, how long a clip is this?
Probably about 10 seconds, 15 seconds.
All right. Jurors, we're going to ask you to take a break, and we'll bring you back in, and we'll see you 10 seconds. All right.
Taking a 10-second recess.
That's fine. Thank you, Your Honor.
Court, all
How
right,
about-
please. Jurors,
You
close your
just
votes.
take it off the
Follow me.
screen and go look at it on the laptop, maybe. Maybe. Just trying to be efficient here. I knew AJ was going to come back and try to do that, and I don't find this effective. I don't find it effective. The jury already heard it the first time. All you're doing is giving her an opportunity to argue more and get more and more entrenched in the explanation she's already decided on. That's the problem with this combat strategy to cross-examination. Instead of focusing on the substance of what you need to get out. The substance of what you need to get out, it was already out there. Okay? She was asked a question at the grand jury. She gave an answer. That answer is false. She gave him all of that. She gave him all of that. And we already knew because she came up with the explanation, well, I misunderstood the question. Well, she's still on cross-exam. So there's really nothing added to this by the redirect. She just entrenched that further. I misunderstood the question. I didn't hear that part. And so then to go in and get argumentative with her about, is it a lie? What's technically false? Like that's argument. That is what you do in your closing statement. That's what you do in closing. The witness is never going to say, yes, I lied to the grand jury. The witness is never going to say that. They're just going to repeat and entrench their explanation. It wasn't intentional. I misunderstood the question with her kind of haughty queen. I misunderstood the question, Mr. Jackson. He just lets her get up in her righteousness on that. So I don't find that helpful. It added nothing to him. It gives the jury more opportunities. I'm gonna get that fan off to potentially find that they believe her. You were doing really good with yes, it was false, but I did say that to the grand jury. That's what you needed. That's all you needed. The rest is argument. And so by kind of going down this long road, extended cross-exam. Let me count. Let me count here. You guys know I like my notes. I take a lot of them. Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, and about a half. 9.5 pages across. Okay, I take a lot of notes. What out of that mattered? What out of that is what the defense wants me to remember? You can't say 9.5 pages because nobody is going to remember 9.5 pages. That's why you got to edit. And that's why you got to refine. If I only had half a page of notes here, I would know what mattered and I would know what was important. So it was just a lot of build up to stuff that I don't know if or why it matters. And the one thing that I can tell really clearly does matter, she testified falsely to the grand jury, whether intentionally or not. She testified falsely. It's been buried and it's been explained away. Is it just me, or do you find that this was helpful to the defense? This was largely helpful? Now I know people have different thoughts about being aggressive with witnesses, particularly sympathetic witnesses. Just talking about that before she came on. Last trial, that's maybe one of the reasons why they didn't cross her, because she came across very sympathetic. She didn't come across as sympathetic this time. So maybe it was a little bit easier to cross her. There's a big difference between being direct and being aggressive. Being aggressive is arguing about, well, you lied. That was a lie. No? What does technically false even mean? That's being aggressive. That's being aggressive. That's being argumentative. But simply asking somebody directly, do you deny that that's what you told the grand jury? Do you deny that you had those text messages with Jim McCabe? That's just direct. That's not aggressive. It's just getting to the point. So I don't think I'm saying anything here that's like, I need them to be more aggressive with the witnesses. No, and actually I kind of need them to be a little bit less, because I need them to be more fact focused. And facts don't have feelings. Facts don't care about your feelings, as the old saying goes. Facts are just facts. You can be very dry, very direct, even very sympathetic with the facts. Do you deny it? Do you deny it, Ms. Roberts? It's very different from, do you deny it? Just clarify for me. I want to be very clear that I understand exactly what you're saying. Because you're saying you don't recall. Does that mean it didn't happen? Or are you saying it didn't happen? Or you just don't recall? Okay, so it is possible that it did happen. Was that aggressive? No. No, it's just direct. So, we spent a fair amount on the replacing the Ring camera. I don't know why that matters. I don't know why that came out. I know folks are saying this is setting up. A lot of what he's doing is setting up for other stuff, but you got to remember, we watched the first trial. We watched the first trial. And we saw a lot of this where it seems like, is he setting things up for something else? But then it never happened. We never got a tying it all together follow through. So I'm very skeptical that all we're doing here is setting up other things. Number one, it's hard for the jury to remember that. The more focused you are, the more the jury is going to understand. You don't say very many things, so the things that you do say are important. So that's what I can focus on. And then, so if you say something that you don't immediately follow up on, I have a better chance of remembering that later when you finally get to it. So I don't know what's being set up here, if anything is being set up here. I don't know. I don't know what the point is. And part of the reason I don't know what the point is because it wasn't mentioned in opening. And since it wasn't mentioned in opening, I don't know why it matters to the case. It's tight, keep things tight. Keep things tight. If your opening was about telling me, here's the 10 top things that I'm going to hear in this trial that are going to assure me that Karen Reed is innocent and that I should vote not guilty. And then all of your cross and all of your direct are limited to establishing.
You are unmuted.
It's going to be a lot clearer, and I'm going to have a little difficulty following it.
Court is back in session. You may be seated.
All right, Mr. Brennan, whenever you're ready.
I'd like to play clip 3, please.
When my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jimmy Terry, look what I just did to my light, and I'm worried that there's going to be some kind of electric short circuit. There's the bulb is showing, and some of the red plastic's missing. So I picked pieces out of the light housing that had kind of collapsed within the light and dropped them in John's driveway.
I'd like to have that marked as an exhibit, please.
Okay.
No objection.
Right.
Continuing with the ipsi dixit theme from the Commonwealth. Karen said it.
All right. Rather than calling your next witness, who it'll take 10 minutes to bring a witness in and do all of that.
Yes, Your
Why don't
Honor.
we take the lunch and recess? I'm sorry, is the food here? Okay. Folks, we'll take a 40-minute lunch and recess, okay?
All rise for the court, please. Jurors,
40
close your
minutes.
books, put away your chairs, and follow me.
So that means we're at about 9:50 here, so it'll be about 10:30 when they come back. I am going to have to pop out to get my own little break this morning. So, don't get upset with me too much about just kind of my frustration. I am looking at this as a lawyer. I'm not necessarily looking at it the way a juror is going to see it, but I have talked to a lot of jurors and I've had to kind of get a feel for what works and what doesn't. Fully understand same strategy doesn't work for every person. But the problem is this didn't work last time. The strategy didn't work last time. They didn't get the acquittal. And The comments were about lots of distractions. They didn't understand the distractions. They wanted to focus on the stuff that mattered. Could John have been hit by the car? So I'm just afraid this is a little bit of a pitfall of just kind of falling back into, even though they're doing some different things, obviously cross-examining Kerry Roberts is different. They didn't do that in the first trial. Is what just happened going to be the game changer between last time and this time? I don't think so. Not if we take Juror Ronnie at face value and the feedback that he gave. This is not going to be the game changer. So it just concerns me, that in many ways we're still kind of in the same pattern of presentation as we were last time, when we already know it didn't work last time. Something needed to change, and I'm not seeing that change. Kind of following up on that, found it interesting too. When I went through Kerry Roberts's testimony from the first trial, it's like Hank followed the script. I mean, showed her the exact same exhibits that Mr. Lally showed her, the copy of the dash cam, both the distant and the close up, and then the photo from the Sally port to identify, yes, that's what Karen's tail light looked like when I saw it. Backing up to get in that point about didn't take off her shoes. Remember, last trial, they didn't acquit. Okay, they didn't acquit. And so for Hank, yeah, he wants to maybe try to get some stuff better this time. He wants to get some more stuff added, but he didn't necessarily lose last time. Okay, his goal is not to lose. An acquittal is a loss. It's not necessarily a bad thing for Hank to kind of rerun the script, because again, if we're taking the jurors at face value, we know that at least some of them were at least going to give him voluntary manslaughter. So if he can get just a couple more, if he can just get a couple more by boosting the ipsi dixit with, statements Karen Reed made in the interviews, that's not necessarily a bad thing for him. So I don't like the defense following the same script. That's really what I'm saying. I realize we're in the Commonwealth case. They get to do what they want with their case in chief, but you get to decide what you elicit from their witnesses and why. And I'm troubled, guys. That's all. I'm troubled because this is the stuff Juror Ronnie said doesn't matter. And we spent a lot of time on it, and we've kind of already lost track of what matters. Go back. Okay, let's remember the opening statement. Do we know right now in the chat, what do you remember Alan Jackson told me I need to look out for in the opening statement, fact-wise? What's going to matter in terms of proving Karen Reed was innocent? What do you got right now? Kind of hard to think of something right off the top of my head. It's kind of hard to think about it. I came out of it with a feeling, I felt like they have a good case, but what am I looking for? I don't remember. Remember, there was no collision. There was no collision. I remember that, but why? Why do I know there was no collision? What am I looking for? And I didn't hear, like I heard the first trial, Karen Reed was framed. Here's the people that would help me to tie together what just happened with Kerry Roberts and why is that important? We haven't pitched it this time as a big cover up. We don't know what Jen McCabe's role is in all of that. Now, it's not even really clear to me if the defense is arguing this is a confabulation. You talked with Karen with Jen multiple times. You worked together on the timelines. Possible your memory was affected. Are we holding open the possibility of good faith here or not? Because when you confront her and say you lied, and what do you even mean by technically false? Did she lie or did she confabulate? And why does it matter? Your opening didn't tell me. This is why I'm concerned. This is why I was saying direct, tailored, focused. We're not getting it. We're not getting focused. Doesn't mean, we're getting a bad case. Doesn't mean I'm right. Doesn't mean the jury is seeing things the way I am. We're just here because I'm telling you how I see this case as somebody who's, had to try cases myself. I'm going to take a chance to try to get through some of your comments before I jump up in probably about 10, 15 minutes here, so I can do my little morning rounds before court gets back into session. The rural juror, Andrea, I got my parents interested in this case and they're watching the trial with you. My mom loves you from the Delphi trial. Shout out to Connie and Ken from Missouri. Shout out to Connie and Ken indeed. Glad that you're interested in this case. If law enforcement corruption gets your attention, well, Delphi and Karen Reed, they got a lot in common there. Maybe not so overtly in Delphi because, they didn't get fired for their misconduct. They in fact got promoted and, get their commendations and shift their jobs around and things like that. Not a negative consequence for anybody at Delphi. But, same theme there in terms of, do you trust this investigation and why? So I'm glad that you're joining us. It is a very interesting case. A lot of twists and turns. I hope that I'm not making it uncomfortable or difficult for newcomers to this case to follow, just because of the fact I saw the trial before. I remember what happened before. It makes it, it is what it is. That's what happened. I can't look at this case as if I were seeing it for the first time. And so that's what makes it a little hard for me sometimes to evaluate, like the opening statement. How does it land? I don't know how it lands on fresh ears. I have such a context of information that the jury doesn't necessarily know about. So it can be difficult to try to shift that. And I hope that, if you are new to this case and coming on board, let me know. Let me know what you think. Oh, is it helpful to hear about the stuff that happened before? Is it distracting? Does it take away? It is what it is. I'm probably not going to stop, but I am just interested in how that hits people. Part of the reason this, comes up in my mind, first thing I was on YouTube talking about was Depp versus Heard. And the whole reason I kind of got involved in talking about Depp versus Heard when that was going on is because I was like the only one who had watched the UK trial. I'd followed the UK trial. I say watched it. There wasn't anything to watch. It wasn't on TV, but it was live tweeted every day. And there were transcripts released every day of what had happened. We had records of the witness statements and some of the evidence that came in and stuff like that. So I was very familiar with what had already happened in the UK before it went to trial in Virginia. And so that's why I knew when things were happening, oh, just wait, I know what's coming. But that may or may not be helpful for people to hear. So I definitely am interested in your thoughts about that. But again, yes, shout out to Connie and Ken from Missouri. Really appreciate you joining us. And hope you enjoy the coverage. Team YouTube, why can't the defense get other expert witnesses to testify to the same thing ARCCA would? Do you think they have witnesses on standby to do that if Bev denies ARCCA? No, I mean, all of that would have had to have been disclosed. It would have had to already be done. So no, I don't think they have a backup accident reconstructionist on hand in case they lose ARCCA. Why would they do that? A couple of reasons. Number one, I think they would not expect to lose ARCCA. I think that, that would be something you wouldn't normally predict. But the other big piece of it is simply the cost. Okay. Experts are expensive. They're expensive. And Karen she lucked out so much with ARCCA because so much of the foundation, she didn't have to pay for that. She didn't have to pay for them to initially review it. She didn't have to pay for them to do their testing. She didn't have to pay for them to write their reports. She didn't have to pay for any of that. You hire a new expert, you're going to have to pay for all of that. And it's expensive. I don't remember, did we ever get a final bill on how much? I don't think we did because that was like confidential with the Fed stuff. I've just seen numbers floating around, but I assume that they're speculative, 250,000, 500,000, something like that. I'm pretty sure it's speculative, but that's going to be in the ballpark. It's going to be in the ballpark for guys with these types of qualifications, doing this type of work, putting in this kind of time on a case. It's going to be in that kind of ballpark. So, I mean, that is the most practical answer to your question about why wouldn't they get other expert witnesses to testify to it. You're paying two now. You're paying two people to do what only one should have to do. And you don't foresee that you're not going to be allowed to do it with the one. Why wouldn't you? They haven't foreseen that Hank is going to be able to, flip the script and blame shift and point the finger at them as being, the delayed discovery producers in light of the Commonwealth's own history. Producing a PowerPoint this morning, and they're supposed to get in their objections tomorrow. Yeah, that's the standard. That's how it works. You can have overnight during trial to review new evidence from the Commonwealth. But is it Commonwealth you can have tonight during trial to review new evidence from ARCCA? No, we'll talk about actually booting ARCCA entirely. We'll hold that possibility out there. Have to do this voir dire. We're going to give him that free bite at the apple so that he can find out what the new opinions are. And he can ask about them, and he can ask all those questions. Remember, Alessi said yesterday they can ask all this on cross about the communications if he thinks something is there. Yeah, but he doesn't want to do it in front of the jury because he doesn't know the answers, and the answers might make him look stupid. He wants to be able to do all that outside the presence of the jury so that he knows, am I going to look stupid if I ask these questions or not? And she's giving him that. So they haven't foreseen it. You normally don't foresee it because you don't foresee judges acting so erratically and arbitrarily when it comes to stuff like discovery obligations, sanctions, presenting your case, so on and so forth. And it would be enormously expensive for them to duplicate it. You try to minimize duplication as much as you can. So I think that's probably why. Botanist Gaming, wait just one effing minute. This sounds like an attempt at impeachment evidence, which the defense was inexplicably forced to turn over. WTF. I'm not sure what exactly we are referring to there. Are we talking about the issue that was raised at the beginning with what the Commonwealth hadn't produced? Or Are we talking about location data, Lank's house, text messages, prepping, kind of like we saw with Jen McCabe? Jen, we learned about how they had that meeting with Lally and Tully in the prosecutor's office, and they were shown the location data, asked to explain it before they were cross-examined. The defense had to turn over their rebuttal testimony, their rebuttal evidence before rebuttal. And so they had an opportunity to prepare for it. Dare I say, maybe coach for it. So maybe we're talking about the same thing kind of with Kerry in the location data. I'm not sure. Sorry that I missed this when it came up, but it does happen sometimes. It does help because I don't get to super chats in real time. And so just depending on what you say, sometimes I might not be totally clear on what you're talking about. So just word to the wise. Ian Kelly, Bev is a joke. Bias, Commonwealth can do no wrong. Defense bad no matter what. Commonwealth late discovery, here you go, Bev, I'll allow it. Okay, so context-wise, I guess this tells me we're talking about they received, okay, so Ms. Little says we received 19 exhibits and reports from Gorino. They were not previously disclosed. They include data that has never been disclosed. It's a Rule 14 violation. Brennan says all of this is from the phone discovery that they already had since 2023. For example, John O'Keefe's phone log, they separated out and consolidated things. They used more updated software on the texts. The only difference is it shows emojis. They put the text in the PowerPoint so that it's in order. It's different. A different PowerPoint that has the old data that wasn't presented in the last trial that tracks Jen McCabe's heart rate data. So he's admitting there's a brand new PowerPoint with new data, Jen McCabe's heart rate data. And again, with the blame shifting, okay, Jen McCabe was never ID'd as a third-party culprit, but defendant said 227 in opening. Yeah, saying 227 in opening isn't saying she murdered John O'Keefe. They're allowed to say that in opening. Here we are again with the shoehorning, anything I don't like, anything I want to use. I'll try to shoehorn this as third-party culprit. So he's trying to pitch like, oh, I was caught off base because of how they presented their opening. No, you weren't. You knew perfectly well. They were going to talk about 227 and Hoslong to dying cold. Then what? He could have waited to cross until to disclose it? You mean that's the norm for when you disclose? For when you disclose your non-case in chief evidence is right before your cross or perhaps your rebuttal? That's the standard for you? At the same time, you're demanding that they disclose their rebuttal evidence and the judge is giving it to you? Pretty wild. Pretty wild. And so then Ms. Little says this information is not from the Celebrate report. And then we just get to, I don't need to read these to the jury today. Bev says, I want to see a copy. And then give me your objections tomorrow. Give me your objections tomorrow. So magnanimous. A whole evening over the course of the trial to review what's apparently a new extraction. Because now this one shows emojis. Hank Brennan tells me that's the only difference. Rule number one, rule number two. Rule number two. Rule number one is never believe your client. Okay, trust but verify. Never believe your client. Rule number two, never believe the prosecutor. Never believe the prosecutor. Hat tip to Mercy for stating that recently on X so compellingly. You never believe what the prosecutor says. It's your duty and your obligation to investigate and verify it or not. You don't take the prosecutor's word for it. So I don't know if that's the only difference. If I'm the defense lawyer, I need my expert to review. What's this new extraction? What's the new information? Is that the only difference? And are they going to be able to do that overnight during trial? I doubt it. And then a whole new thing on Jen McCabe's heart rate data? Yeah, I might need some time to review that. Where did that come from? What's the source? Is it accurate? Is that from the same information I've been previously provided? Is it new data? Is it also a new extraction? I mean, I doubt it, but I don't know. You can run the existing extraction through updated versions of the analyzer. That was something that we heard about in Delphi. That was fairly common. And so sometimes they can get new information from the same original data, the same extraction, just because the tools to be able to analyze and parse that and put it in a understandable form for a viewer, those software programs can get updated. Is that what they did? I don't know. I would need to see what my expert told me. I just feel like, in some respects, the defense is continuing to get hammered by Brennan on the double standard. Like they're just not fighting back. They're not calling him out on what he's doing. The blame shifting. You weren't surprised about 227 when we mentioned 227. That's not third party culprit. And you knew perfectly well from the first trial and our evidence and witness list in this case that was going to come up. See Richard Green on there? Yeah. We had a whole motion about him and his qualification to be able to testify. Yeah. You knew he was coming in. You weren't surprised by any of that. So that's not an excuse for your not disclosing it. I'd like to see him hit back a little bit harder. All right, one more, guys, then I'm going to take a quick break and get back. The rural juror, is this something the Mass Defense Bar could reach out to say keeping text is not mandatory or standard practice for the defense? If they were so inclined, I mean, I guess. At this point, yeah, I mean, the defense can still make a record. And it's probably a good idea for them to do that. I want to say more about this, but I don't have my thoughts 100% organized around it yet because I just kind of started looking at it last night. I looked at the rules. I kind of looked at, how these pieces are fitting together. What caught my attention was simply Judge Cannoni saying, but the ABA rules, the ABA guidelines, what about those? And I don't know why the answer isn't, what about them? ABA guidelines are not binding in any jurisdiction unless they specifically adopt them as rules. So the issue here is, are those the rules in Massachusetts? Are they, Judge? Is there some reason why I should think the ABA guideline is mandatory in Massachusetts? Because if you can point that to me, I'd be happy to check it out. But it's not. Massachusetts has their own rule. They have their own set of rules. And so, like I said, it's state by state. Massachusetts has a little bit more specific guidelines in terms of what's supposed to be in the file, but it's got exceptions, and exceptions include things like what's, customary, not customary. And the whole kind of deeper problem with all of this is that these are rules that are there for the client's protection. It's if the client wants them. So there's nothing in the rule that says client can't waive this. You have to retain each and every text message, regardless of whether your client wants you to do that or not. And there's a whole lot of reasons why your client may not want you to. Number one being, if I got to store and track all this stuff, I got to download my phones. I have to back it up into the system. I have to maintain the file storage. I have to have some way to organize and identify it. It's going to cost money. And you know what that's going to do? It means people are going to have to pay more. We're going to have to pay more for your representation so that you can save some scheduling text messages. I don't think most people want that trade-off. Some might, but I really don't think most people are going to. You want to pay your lawyer to have to save every single text about court's going to be a little bit late today? Download it and organize it and all that? I really doubt it. So lawyers are professionals. They have some judgment that they get to exercise about what do I need? What do I actually need to keep? Like what's important to have in a file? What is a file anyway? A file is, it's a tool. It's a collection of stuff. In Washington, we distinguish between what is property of the client, things that I have to safeguard because the client has entrusted me with them. I have it like as a trust of the client, so I have a duty to return it. But things that I compile for my own purposes as part of doing my job, I get to decide what's important and what isn't. I get to decide the manner in which I keep it. If text messages aren't important to me, I don't have to keep them. And I don't. And I wouldn't. Unless, like I said, it's one of those things that comes through that's actually significant. And then you probably like memo to file or email to self or whatever, screenshot it. Maybe if it's like a super big deal, okay, we'll go and like download it. But that's just not the normal practice. So none of that translates into because you should have it for the client's benefit, therefore you must disclose it. It gets incorporated into the discovery requirements. These are completely separate obligations because one is about what's good for the client and one is about what's fair process in terms of disclosure and in advance notice of stuff. So I don't know if they could or if they would, but I think it's probably not a bad idea. If that's possible, by all means, make the record of what is standard. Okay, guys, I am going to go ahead and take a quick break here. I did discover, yesterday we had that nice little music that left us. That was just Court TV's music. But we do have little background music I can play here. And I kind of liked it because, then I don't necessarily jump scare you when I come back and all of a sudden there's sound on the mic again. So you'll know because the music comes off and I come back on. So I'm going to go ahead and give you guys that. You can mute it if you want. But I will be stepping away and I will be back shortly. Okay, guys, I'm back. That was the cue. I'm about 2 minutes late, but I did figure court was going to be significantly later than that. If past history is anything to go by here. So let's get back to your comments. I just want to make sure I'm at my right place in my notes when we get back to it. God, just going to show you guys. Do you deny it? There in my margin. I was really starting to get on that. Do you deny it? God, it's just such a good way that Spiro does it. So effective. I would like to see more of that. We get what we get. Let's go ahead and continue with some of your comments and questions. Edward Kirkpatrick, do they have to re-up motion to recuse since it's new case for appellate issues, or will the one from the first case count for this case too? So they can appeal the denial of the first motion to recuse, but that means the only basis that they would be able to argue on appeal for why she should have been recused was everything they put in that first motion. That's what they would have to rely on. They can still appeal that because there hasn't been a conviction, so there's no final judgment for them to appeal from. You don't have to appeal things on an interlocutory basis. You can, like permissively sometimes, but it's not an obligation. So they have preserved that issue by filing it the first time. They don't have to refile it. It's just that if they want to add in any additional grounds, any additional reasons since back then, why they think she shouldn't be the judge on this case, they have to file a new motion to bring that in. Otherwise, they're stuck with what they raised the first time. Edward Kirkpatrick, Kerry Roberts was on a taped from Monday, but aired today's segment on GMA. No kidding. Oh, what timing? What timing? I'll have to check that out sometime in my abundant free time right now. I'm going to try to make it to the gym tonight. I've been kind of off the horse for a little bit. Yesterday when we wrapped up, I ended up going outside and thinning some apricots. We've got a very heavy set of apricots this year, which is wonderful. I love it. But it does mean it takes a little bit more work because you got to go through and prune, thin them out so that they don't crowd each other. That's how you get bugs and just bad fruit and stuff like that. So better quality, a lot of work. You got to have your hands on like pretty much every apricot that you're going to harvest 2-3 times over the course of the season. And these are some big trees. The two biggest trees I have are, they're, much older, been there much longer than I've had this house. They're probably, 20 some years old. Very established trees. So lots of fruit to get my hands on. I got one big tree mostly done. But anyway, yeah, I'll check out that GMA when I get a chance. Maybe not tonight because I am going to try to go box. Samantha Teresa, Andrea, please tell me she will allow ARCCA in. I'm breaking out in upset hives. I think she's going to let ARCCA in, but I think there's a very decent chance that she's going to say they can't introduce anything new. She's going to look at that and see that as kind of a compromised position. She's laying the groundwork already. I've found there's a discovery violation. Now we're going to do the voir dire. So I think she's holding that door open. She's holding that door open. It's late. There's been shenanigans. She seems to be, buying into the same suspicion that Brennan has. There's shenanigans here. Never mind the missing videos and the 100 billion explanations and Proctor sticking it in a file in his desk not to produce it, et cetera, et cetera. That stuff, that doesn't matter. But ARCCA, the feds, accident reconstructionists, yeah, it matters. It matters with them. So no, I don't think ARCCA is going to be excluded entirely. She's already kind of signposted that when they addressed the sanctions motion before from the Commonwealth, and she said, she nodded to Karen Reed's right to present a defense. She has a right to defend herself. but, potentially going to have an issue with the sanctions. Remember back then she had that sidebar conversation with Karen and then told us in the course of her ruling that that sidebar conversation was her asking Karen if she wanted to stick with her existing lawyers, as if Karen is going to say, nah, fuck these guys. I'll get some new ones like right now. I suspect, of course, we don't know, sidebars are impounded, but I suspect that that wasn't the only thing that was said at that sidebar. I suspect there may have been some kind of caution, some kind of warning to Karen that if I have to do something at trial, you might get stuck. You might have a problem. You might want to think about that. And that, frankly, might be part of the reason why they brought Victoria George in. Victoria George is another local attorney, and they just submitted permission for her to basically be pro hac vice stand in for Mr. Yannetti if he's not able to be there. Might be a little bit of a backup plan in case, I don't know, something happens with this defense team, something is necessitated later on. Just really feel like a lot of this groundwork has kind of been laid. She's starting to eat it up. Go ahead and take what Mr. Brennan is feeding her. Edge it a little bit closer and closer and closer and closer towards doing something problematic. But because of that, no, I don't think she's going to eliminate ARCCA altogether. She recognizes Karen has a right to present a defense, so you better be on your top game if you're going to do some kind of sanction that impairs her right to present a defense. You better be really super justified. So, new information, late disclosed. She's on stronger footing throwing that out than she is throwing ARCCA out altogether. But also the possibility that she's looking for a reason to boot with the mess around with the defense team. Karen, you sure you want to stick with these lawyers? Because it might end up just being Mr. Alessi and Ms. George. Don't know that, of course. Just hypothetical. Just kind of anticipating based on what I would expect in terms of an advisement, because she needs to be able to say later on if she does something to this defense team, I warned you this could happen. So you have knowingly assumed the consequences of continuing with this team. That's what I would expect happened. KRM 944. What if ARCCA destroyed their phones a day before the preservation order? That's fine, right? That's a good one. I mean, right. The difference, of course, here is that Brian Albert and Brian Higgins are not lawyers and they are not experts in the case. They're witnesses. They're witnesses. They're non-lawyers. They're not subject to the rules of responsibility, whichever ones Judge Cannoni is under the impression applies in the case. Commonwealth doesn't have control over them in the agency kind of way that an attorney is expected to have, some sort of control over your expert. So I understand the point perfectly well. I really do. But that's why the different treatment in that particular case. But not so much when it comes to the law enforcement shenanigans, the video, the logs, et cetera, et cetera. So the rural juror, that isn't a piece missing. There's only a piece left. Yeah, that's the Sally Port video. I mean, who knows? They get to say what they say, and it's up to the jury to decide if they think that's credible or not. Both parties seem to not want to push this too far. Same thing happened last trial with the Officer Barrows. He said it was cracked but not entirely missing. The defense has, seized on that like it's very, very helpful to their position. It could be, but is it for sure? I don't know that we know that, because we don't know what tracks did not completely miss. And nobody put that photo in front of him and asked him, is this what you saw? Kerry said just the middle piece was missing. You can look at that photo and see, yeah, that's the middle piece. There's some other stuff over to the left. There's some other stuff over to the right. It's the piece in the middle. It's not inconsistent with what she said. So, it's going to be for argument. It's going to be for argument. That Southern blonde lawyer put on X but haven't had a chance to dig in. Mass rule of PR 1.15a. Yes, all correspondence matter in physical electronic form. Impractical for PD, but we do see often in civil private. Sorry if you discussed popping in and out. No, this is kind of ongoing. This is exactly the rule that I was looking at. This is the rule that applies to an attorney's obligation to preserve stuff, not the ABA guidelines. ABA guidelines are just guidelines. The actual rule in Massachusetts is this one. And again, this is for the benefit of the client. This establishes what are the contents of a client's file.
All right. Thank you, jurors. Thank you. All right. Your next witness, please, Mr.
Thank you, Your Honor. The Commonwealth calls Peggy O'Keefe.
Peggy O'Keefe did not testify in the first trial, so this will be new. New approach.
You solemnly swear the evidence here before the jury in the case now hearing should be true, the whole truth, and nothing but the truth, so help you God.
So, good afternoon, Mrs. O'Keefe. Yeah. All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good afternoon, Mrs. O'Keefe.
Good afternoon, Mr. Brennan.
Could you kindly introduce yourself to the jury?
My name is Margaret O'Keefe. I am John O'Keefe's mother.
Are you married?
Yes,
Who are you married to?
John O'Keefe Jr.
How long have you been married for?
Too long. 53.
I'm sorry, ma'am, I didn't hear you.
53. Long enough?
How long have you lived in the area?
We moved to Canton 3 years ago.
Before you moved to Canton 3 years ago, where did you live?
Braintree.
How long had you lived in Braintree for?
50 years?
Did you begin your family in Braintree?
No, we lived in Mattapan first, and that's where my daughter was born. And then we moved to Braintree.
Your daughter was born when you were in Mattapan?
Mm-hmm.
Your daughter's name?
Kristen.
How many children did you have?
3.
You, Kristen and John?
And Paul.
Is Paul the youngest, the baby?
The baby.
Did you raise your children, how long were you in Mattapan before you moved closer to here?
I'm sorry, repeat that?
How long did you live in Mattapan before you moved closer?
2 years.
And then the rest of the time you were in the area?
In Braintree.
And tell me a little bit about your immediate family.
My daughter. My daughter Kristen had a tumor, a cancerous tumor that she had for 5 months. And she died in November of 13. She had 2 children. And then 2 months after she passed, her husband passed from a heart attack. And then you all know about John. And then my son Paul is over there
Then Paul is
That was
over there.
2013, ma'am. Could I ask you about her children?
She had 2 children, Kaylee, who's now 17, and Patrick is 14. He's a run for my money.
Do you remember how old the children were when your daughter passed?
3 and 6.
When that happened, was there any plan for the children?
As far as
Or what was going to happen with the children?
when she passed
Yes, ma'am.
and when he passed,
Yes, ma'am.
we decided, my son decided to be the head guardian, and then we had I was the other guardian, and there was Steve's brother and sister were the other 2 guardians. So there's 4 of us.
May I approach you just the microphone?
Yes, please.
Thank you.
Talking too soft. Okay.
Did I understand that there was a decision that John would be the primary guardian?
Yes.
Can you share with us how that decision came about?
Well, he was single. The other 2 guardians were married, and they didn't have children, but he decided to do it himself, and then I was the second one in case he needed me. So I was over there most of the time, like when the kids get home from school or, take them places, and then have them on weekends so he could have a break. So that's what I did.
Did other people help out in addition to you and John?
Yes, my husband was there, and Paul and Erin were there, and the other members of Steve's family.
I understand at some point John worked in law enforcement.
Yes.
Besides that, could you just share just a little bit about him with us?
He was a police officer at headquarters. And when he first started, he was in Hyde Park, and then he moved to Dorchester, and then into Boston itself, and that's what he did.
I was hoping if you could tell us a little bit about John besides his work.
He was enthusiastic with sports. He was wonderful with the kids. He took care of them and did everything for them. Take them places on vacations and everything. He was their number one, and they called him JJ.
Would you mind if I showed you a photograph?
No.
May I approach?
Yes.
I'm showing you a photograph.
Okay.
And could you tell us what you see?
That's my son.
Thank you. May I introduce this as an exhibit?
Yes.
Exhibit 16.
Thank you. With the court's permission, I'd like to publish.
Yes.
Ms. O'Keefe, do you know when this picture was taken?
Oh. I really don't know. It was in the summer of I don't know what year. I really don't know the year. But is that one he probably took him to a fair or an amusement park, and he had his picture taken there with it. And then the kids were with him too. So.
Do you know how old he was in that picture?
43, maybe.
Okay. What year was John born?
75.
Ms. Gilman, could you take the photo down, please?
Would be 50 this year.
How old was John when he passed?
45. My mind's not working right now.
I understand. It's okay. Can I ask you a few more questions? Okay. You let me know. I want to go back to the morning of January 29th, 2022. Is that okay?
Yeah.
Were you home?
I was home in Braintree.
In Braintree?
Mm-hmm.
Who were you with?
My husband.
Did you receive a phone call?
Yes, from Kerry Roberts. It was about 6:15, between 6:15 and 6:30 in the morning.
Did you know Kerry Roberts?
Yes.
How did you know her?
She lived in Braintree for a while. John and her were friends. They went to the junior prom together. And then we found out that she moved. She lived in Canton, and she was around the corner from us, and she helped us out with the kids.
And when you were helping take care of the kids, would you often see Miss Roberts?
Yeah, because she'd take Patrick and her son Ryan places. And yeah, so I saw her all the time.
Often?
Yeah.
When she called you that morning, do you remember the conversation?
Yeah, she said John was found in a snowbank. And I didn't understand, which I said, what do you mean found in a snowbank? She said, they found him in the snow. They don't know what happened. She says he's brought up to the Good Samaritan Hospital. So she says, I'm going to come get you and Papa because I don't want you driving. And I says, we can drive there. We both have four-wheel drives. So she says, no, I'm coming. So she came to get us. And it took a while to get there because the snow was bad. And in the meantime, I had called one of my nieces to find out because one of my other nieces worked at Good Samaritan. I just wanted to know if she could find out anything about it. And I just couldn't get a hold of her. So when we get up there, they told us to sit in this room and they would bring us down shortly. So finally they said, okay, you can go down. So we started walking down the corridor. And as I'm walking down, I hear Karen Reed yell, Peg, is he dead? Is he dead, Peg? Peg, is he dead? And I just kept walking. And then I asked, I don't know who it was, a nurse or a worker at the hospital. And I said, what is she doing here? And she says, oh, she's being psych evaluated. So then they brought us down to the room where my son was. He's bruised up. His eyes were closed. It's just not a good scene.
Okay. I'd like to go back, if I may.
Okay.
May I?
Yeah.
When Kerry Roberts picked you up in the car, did anybody go with you and Miss Roberts on the drive from your home in Braintree to Good Samaritan Hospital?
No, we were the only three in the car.
Who was the third person?
My husband.
During the drive to Good Samaritan Hospital that morning,
Yep.
did you ever have a chance while you were in the car to speak to the defendant?
Yes.
Please tell the jury about that conversation.
She, I asked her what happened, and she said, we went to a party. I left him there. I said, you just left him there? She said, yes, I just left him there.
Did she say whether she left him inside or outside?
No, she just said, I left him there.
Did she tell you whether or not she left him in the driveway or the street?
She just said, no, I just left him there.
You told us that when you got into Good Samaritan Hospital, you were walking down the hallway and you had another interaction with the defendant.
Yes.
And you told us that she was asking if he was dead.
Mm-hmm.
Can you describe a little bit where in the hospital you had this interaction with her?
When they took us down to the emergency room, the doors open, and there was a corridor to go down to the other rooms, and she was on the left-hand inside. And that's when she saw me come in. And that's when she started yelling, "Is he dead, Peg? Is he dead, Peg?"
So when she was yelling, could you describe her mood or demeanor? Was she animated?
She's loud, and I don't know. She was just loud, and as she was saying it.
And when she was asking you, "Is he dead? Is he dead?" Did you again ask her a question?
I just asked the nurse, "What is she doing here?"
Okay. And did you speak to Miss Reed herself?
No. No.
At some point, and you and your husband got to see John?
Yes.
And were you with Kerry at some point?
Kerry was there, and then my son Paul was there.
How did you get home?
I think I went home with Paul, and I think my husband went home with Kerry. We went back to Canton at the time.
Do you remember generally the time frame? Was it morning, afternoon, evening?
No, it was morning.
Do you remember getting home that day?
Yeah. It was snowy, icy.
Was anybody home when you got back?
No, it was just us. And then the kids started coming home. And that's when I was trying to, take care of them. And then there was a knock at the door. And it was Karen, her father, and her brother asked if they could come in. And I was just trying to calm the kids because Patrick was just out of control, yelling. And then they came in. And then he said, "Do you mind if we go upstairs and get a couple of her things?" Which I never should have let them go up there. But at the time, I just couldn't think straight. And I really didn't have anybody else to help me keep them down in the kitchen. So I don't know what they got up there, what they did up there.
How long were they, when you say upstairs, do you know what room they went to?
I assume the bedroom.
So I'm going to strike that, Mrs. O'Keefe. If you could just what you actually know. Okay, and Mr. Brennan can ask a better question.
Thank you. Could I lead a bit?
Yes.
Ma'am, how many rooms are upstairs in John's home?
1, 2, 3, 4 bedrooms and an office. And off the master bedroom, there's a bathroom, and then there's a closet. It's a big house.
Did you see the defendant and her father go upstairs?
I didn't really see them go up, but I knew they were up there because I could hear them.
You didn't follow them up or go to look?
No.
You didn't know which room or rooms they were in?
No, I'm assuming the bathroom and the master bedroom.
My question was poor. You didn't see which rooms they actually went in?
No.
How long was the defendant upstairs in John's home with her father?
I don't know, maybe 10, 15 minutes.
Did you see them come back down?
No, I did not.
When they were upstairs, what were you doing?
I was trying to calm the kids.
Both of them?
But yeah, well, mainly Patrick.
How was Patrick reacting?
He was very upset once we told him because he slept over a friend's house the night before, and he just said, "I'll never see him again." Sorry.
Would you like a moment?
Mrs. O'Keefe, would you like to take a short break?
No, that's fine. Thank you.
You can just let me know when you're ready. Take your time.
Okay, go ahead.
You ready?
Go ahead.
Okay. That morning, when the defendant and her father came into your home, did you personally interact with the defendant?
Nope.
Was there any hugs, condolences?
Nope.
Did you have that kind of relationship? What was she doing there
Did
in the
you
hospital?
ever
She should hug you.
confront the defendant with any accusations when she was in your home that morning?
I don't even remember her being in the house. When she went upstairs, that's the last I saw of her.
Did you ever lean over a kitchen island? Do you have a kitchen island in your house?
Nope.
Did you ever lean over the kitchen island and say, I think he looks like he got hit by a car?
No. I don't remember talking to her that morning.
Did you see when she left?
Nope.
Did you ever see her Lexus in the driveway?
Nope.
The children, who's their guardian and custodian now?
Well, there's still 4 of us. 4 of us.
Where do they live?
One in Boston, one in Stoughton, and Paul's in Bridgewater, and me.
Where do the children live?
With me. In Canton.
They live with you full time?
Yes.
You're their primary caretaker?
Yes.
Thank you.
Yeah, just a moment.
What you got, Mr. Jackson? Oh, it's Mr. Alessi. No, it's Mr. Jackson.
Okay.
Mrs. O'Keefe, I'm very, very sorry for your loss. I have no questions for you.
Oh, no questions.
All right, Mrs. O'Keefe, you're all set. Ready to court officer.
Well, guys, we're going to have a little tough conversation at the end of the day today. Yep.
I would like to introduce 2 clips, label 4 and 5.
Okay.
Get both on. Both,
Can you explain?
both clips 4 and 5 are on that zip drive.
Okay. 17.
There's no objection to these? I don't know what they are. Is there a second, please?
Gonna have a little sidebar about these clips because I guess they haven't been shown ahead of time either. We're dealing with this on the fly. Don't know what he's got. Mr. Alessi with his very tight looking face. Guys, I know that there's a lot of complicated feelings and opinions about Peggy O'Keefe. And so I want to say a couple things. I want to say I 100% believe in her pain. I absolutely believe that she grieves her son and that is still a very tragic day for her to sit back and remember. I don't think she's sitting on the stand faking or anything like that. People are complicated. People are complicated. They're usually not black and white. They're not caricatures. And so the thing we're going to have a chat about when we're done with today is going to be a hard conversation because this is a domestic violence case, the way the Commonwealth is presenting it. They are presenting a domestic violence case that Karen Reed killed her partner, John O'Keefe, intentionally. That would be an act of abuse by somebody against their romantic partner. And if there's one thing that we know about domestic abuse, it's that it's cyclical. People learn how to form their relationships from the relationships they see around them. So we're going to have a little bit of a difficult conversation about that. How that plays in this case. These are unfortunate dynamics. They're unfortunate dynamics, but they don't emerge out of nowhere. It's very rare that somebody ends up in and stays in a domestic violence relationship when they don't have already a prior history of being in that type of relationship. And it's not always consistent who's in what role, who's the abuser, who is the victim, but it does tend to be pretty persistent. There are some things that I saw during this testimony that gave me a little bit of pause, just because, you know, we got some impressions from the last trial about kind of who's who and you know, how this works, how they fit together. I don't know how long we're going to be at sidebar, so I don't want to get too far into my thoughts. Otherwise, I'll kind of lose track of where I was and what I was thinking. But the thing that stands out about John, the way, you know, Kerry characterized him from the very beginning, he's a bachelor, dates a lot of people, might bring some randoms over to the house, you know. She didn't say that this time. She said it in the last trial. This is somebody who doesn't form stable, bonded relationships with women. That's just a fact. It's just a fact.
There is another short recess. Hopefully you'll get to walk right through the first session. Thank you.
Court, all rise, please. Here's close your notebooks and follow me.
Not sure what's going on here. So John has not formed stable long-term relationships. Got to point out, Karen hasn't either. Karen is a single woman, no children, not married. Or never been married.
Jury is excellent. Please be seated.
We're going to have an argument outside the presence of the jury.
All right, so I'll watch the first one, then I'll hear your argument, Mr. Brennan and Mr. Jackson.
Thank you.
So, Ms. Gilman, if you play that first one, please.
They had pulled into the driveway before me, so I was presuming she saw my cracked tail and was thinking, did you hit my son? I could sense from her that she was looking at me very warily. And then when John's nephew came home, I just wanted to see him and squeeze him. It was quite uncomfortable. I said, Dad, come upstairs to the master bedroom. I said, I think I need to leave. I said, I think John's mother thinks I did something to John.
All right, so tell me why I should admit that clip.
You should admit this clip because it demonstrates consciousness of guilt. On the morning of John's death, Ms. O'Keefe sees her son at the hospital and goes back to Mr. O'Keefe's home. In the driveway is the alleged murder weapon, the Lexus with the broken taillight. It's the middle of a snowstorm, and a prelude to that is there is a phone call from the defendant's father to the Dighton police looking for a ride to go in and see his daughter at the Good Samaritan Hospital. He's looking for a police ride because the weather conditions are so terrible. When the Dighton Police Department declines that ride, He gets the assistance of his son, and his son's wife pick him up and bring him to the hospital. At the hospital, there are a number of comments made. I think I hit something. There is evidence we have where the defendant, her mother, and her father admittedly discuss in different ways the broken taillight. It is an issue that is primary on their mind. In this tumultuous, grieving moment, the taillight is central between these parties. Uninvited, the defendant and her father go to the O'Keefe house without invitation. They knock on the door and they ask to come in. They go into the house. There does not seem to be any interaction, at least with Peggy O'Keefe. And curiously, they go upstairs for 15 minutes. They stay at the house for less than an hour. This is a family that's grieving the loss of their son. Less than an hour, they go back outside. Instead of leaving in the one car, they take the alleged murder weapon, they get into two cars, and they drive away and remove the Lexus with the broken taillight from the scene. Mm-hmm. That is clear consciousness of guilt evidence, removing the murder weapon from an area where witnesses can see, photograph, identify the damage. In fact, despite the other evidence about the cracked taillight in the testimony, it is a centrally contested issue in this case. The defense is already questioned and confronted, as they have a right to do, about the shape, manner, and extent of that broken taillight. The removal of it is helpful for the defendant. And so the fact that they stay for less than an hour, remove the Lexus from the scene is important. This statement by the defendant is clearly an attempt to create an excuse, a ruse, for why they removed the murder weapon from the scene. It is an attempt to suggest that she somehow is targeted. She somehow on that morning is victimized. She somehow on that morning is the intent or the object of something that is abusive from Peggy O'Keefe. And so this evidence will demonstrate a key part of our consciousness of guilt evidence on this issue, that there was no viable reason to take that evidence from the scene other than to obscure it. It was not because Peggy O'Keefe yelled at her or intimidated her or threatened her. This was, again, a central conversation between her, her father, and her mother in those early morning hours. This is what was foremost in their mind. And so that's why it's not only relevant, it is an extraordinarily strong piece of the consciousness of guilt evidence. And inevitably, the defense may or may not try to provide some type of explanation or excuse, but we have a right to the full force of our proof, and this is part of it.
Thank you, Mr. Jeff.
Thank you, Aubrey.
It's her car. She's supposed to leave it there indefinitely?
With
when is it okay?
To the first clip, which is clip 4.
That's the only one we're discussing right now.
Then in that case, now that I look at it and I see the transcript, I'll withdraw an objection. I don't care. It's not, I don't agree with anything Mr. Brennan just said. It doesn't go to consciousness of guilt. As a matter of fact, I think it very clearly shows the opposite. But
okay, so there's no objection. So there wasn't an objection until I said, is there any objection to this? And then you all came to sidebar. I mean, they were just going to play. So there's no objection to the first clip, right?
yes, correct.
Okay, so let's hear.
I made an objection to sidebar from withdrawing it.
Okay, so Mr. Brennan, play the second one, please.
Yes.
And his mother leans over the kitchen island and says to me, I think it looks like you got hit by a car. It looks like you got hit by a car.
Okay. So tell me how this comes in.
Similarly, in consciousness of guilt evidence, the defendant making what we allege is a false statement to try to excuse her conduct of removing evidence of a crime from the scene. This has additional import. It has two facets to it. One, equally as important for consciousness of guilt in the first part, as I supported for clip number 4 or 5. Secondly, it is important because we've heard testimony from Peggy O'Keefe that this claim never happened. So we now have direct testimony.
She didn't say that
she did not have a conversation with the defendant, did not make these claims to the defendant. And so while also consciousness of guilt evidence, it has additional support from the previous clip.
No, she didn't. She said, I don't
Mr.
remember
Jackson,
talking to her.
This video clip, Your Honor, it's very different. It has absolutely nothing to do with consciousness of guilt. The argument is baffling. How could that possibly be consciousness of guilt if my client is simply reiterating something that she believes somebody else said? This clip is obviously, very obviously, and strategically being used to try to vilify my client with something that's completely irrelevant. In Massachusetts, you can't call a witness just for the purposes of impeaching them. What this clip would be doing is purporting to impeach Mrs. O'Keefe, who just testified, I never said that. I never said it. I never leaned over the island counter. Never happened. So bringing this in would be used to impeach their own witness.
You are allowed to impeach your own witness.
And that's what can't be done in Massachusetts. With regard to consciousness of guilt, how does my client reiterating or stating that something that the victim's mother may or may not have said, how does that relate to consciousness of guilt? It doesn't. This is simply a wolf in sheep's clothing. They're trying to get it in because it makes my client look bad. They just put on a very, very sympathetic and empathetic witness, John O'Keefe's mother, and they're trying to make my client, Ms. Reed, look bad by saying something what they perceive to be pejorative, in a tone that's pejorative about that very same witness. He's trying to, at this point, there is no issue about whether or not Peggy O'Keefe leaned over and said something about the car, being hit by the car. He's trying to create the issue so that he can put this video clip in. It has nothing to do with consciousness of guilt.
That's not a good argument.
It's not for impeachment of Peggy O'Keefe.
Because it's for the jury to decide.
We don't take the position that Peggy O'Keefe is lying. This is a statement of the defendant. It's in the form of an admission or a statement, which qualifies for admission substantively, not for impeachment purposes. The defendant should not be able to pick and choose which of her statements do not look good for her and do not look bad for her. She made the statements, they're relevant to this case. It's not unfairly prejudicial. It's a statement that they embraced and they chose and they publicized, and it goes directly to the issue of consciousness of guilt. Just because it hurts, just because it's incriminating, just because it's difficult for the defense is not a basis to preclude it. It is an admission, a statement of the defendant. It's admitted substantively.
If that were true, Your Honor, then they would simply put in the transcript. They wouldn't need to play the video. Transcript is one line. And his mother goes to the kitchen island and says to me, I think he looks like he got hit by a car. He looks like he got hit by a car. Sorry. I think he looks like he got hit by a car. It looks like he got hit by a car. They just put that statement in. They want to play this because of its prejudice, because of the tone that it sets. It's not an evidence at this point. The witness who supposedly said the statement has denied having said it and said it never occurred. This is far, far more prejudicial than it is probative. If they want to simply use the transcript, that's one thing. But playing this video is simply being used to vilify my client because of the tone of voice she used in the clip. That's it. That's what's not allowed. That's overly prejudicial. and it's not relevant.
All right. So what I'm going to do is I'm going to think about this. And if I decided to let it in, you can let it in first thing tomorrow morning. I'm not going to let it in now.
May I ask for a ruling in the morning?
Yes.
May I introduce the one that was not objected to?
Yes. Do you want a consciousness of guilt instruction, Mr. Jackson?
No, we don't believe that
So you're in agreement that that statement just comes in?
we're not objecting. I'm not trying to introduce it. Don't put words in my mouth. I'm not trying.
No, I said you're, okay.
But I'm not objecting that it at this point that it shouldn't come in.
Okay. We'll bring the jurors back and we'll do that.
I remember the
Tony,
consciousness
can they
of
come
guilt
right in or is
instruction.
it going to
I
be
probably
5
would
minutes?
never request
Can they
it.
come right in? Thank you.
I probably would never request it if I was in because number one, it just draws attention to the evidence, and number two, it tells them what you're supposed to maybe be thinking about
Put
on
this
it.
under consideration and just admit the other one?
Yes, and give it to me so I can look at it, please.
It tells them you might want to look at this as consciousness of guilt. Now you don't have to.
I'm sorry, Your Honor, do you want me to
For you
leave
to
that on there so
decide.
you can look at it tonight? And if we decide to take it off in the morning?
Yes. Thank you. Because you can just single it out and play one, right? Okay, thank you. Chrissy.
Guess we're waiting for the jury to come back. He's not gonna win that argument. Yeah, Massachusetts does allow you to impeach your own witness very specifically. Here's the statute. The party who produces a witness shall not impeach his credit by evidence of bad character, but may contradict him by other evidence and may also prove that he has made at other times statements inconsistent with his present testimony, but before such proof of such inconsistent statements is given, the circumstances thereof shall be mentioned, and he shall be asked if he made the statements, and if so, shall be allowed to explain them. You're allowed to do it. You don't get to do it solely for the purpose of impeachment, but they didn't do it solely for the purpose of impeachment. They got out evidence about what happened that morning, her version of events, what happened at the hospital, the in-life, memory of John. So, no, that's not a winning argument, and Ellen is kind of wrong on the law in that one. I mean, unless he's beyond what is court.
Court is back in session. You may be seated.
Hey,
Yes, please.
Your Honor, I'd like to introduce clip number 4.
They had pulled into the driveway before me, so I was presuming she saw my cracked filling and was thinking, did you hit my son? I could sense from her that she was looking at me very warily. And then when John's nephew came home, I just wanted to see him. And Teresa, was quite uncomfortable. I said, Dad, I went upstairs to the master bedroom. I said, I think I need to leave. I said, I think John's mother thinks I did something to John.
May I call my next witness, Your Honor?
Please.
The Commonwealth calls Nicholas Gorino.
Follow me, please.
Okay, thank you. Do you solemnly swear the evidence you give the court and jury in the case down here and should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Hey, she can take.
Hi, you stand or sit however you're most comfortable, okay?
Your Honor.
Here we have the guy who missed 35,000 text messages between Matthew Farwell
Yes.
and Sandra
Good
Birchmore.
afternoon.
Good afternoon, sir.
Could you please introduce yourself to the jury?
Yes. My name is Nicholas Gorino.
Mr. Gorino, where do you work?
I work at the Massachusetts State Police at the Norfolk District Attorney's Office.
How long have you worked for the Massachusetts State Police for?
This is year 10 now.
How long have you been assigned to the District Attorney's Office for?
Since November of 2019, so about 5-ish years, 6 years.
I want to go backwards a little bit. Can you tell me a little bit about what you did before you began working for the Massachusetts State Police?
Yes, sir. I was a Norwood police officer for almost 11 years.
So how long have you been in law enforcement between being a Norwood police officer and a Massachusetts State Police officer?
February of this year, started my 20th year in law enforcement.
Did you go to school before you became a law enforcement officer?
Yes, I went to Westfield State College, Westfield State University now.
Did you graduate?
Yes, I did.
Can you remember what year you graduated in?
Yes, it was 2003.
Did you have a particular degree from Westfield State?
Yes, I double majored. I've got a major in criminal justice and mass communications.
When you began as a police officer with the Norwood Police Department, did you have to go into any type of specific training?
Yes, I went to the police academy.
And how long is the police academy?
6 months.
Generally and briefly, what was taught at the academy?
How to conduct investigations, respond to calls. They did a standard field sobriety testing week, physical training, Massachusetts law and criminal procedure.
When you began as a Norwood police officer, were you a patrol officer?
Yes, I was.
And did you remain a patrol officer for the 10 or 11 years you were there?
Yes, I was also part-time in the detail office. But
what does that mean?
Handling jobs when we're off, so filling details like road construction, I'm sorry.
When you left Norwood and began working with the Massachusetts State Police, based on your prior training, did you have to go through further training or were you ready to just begin?
No, I had to go to the State Police Academy for 6 months.
After you got out of the State Police Academy, were you assigned to a barracks?
Yes, I was assigned to the South Boston Barracks for my training. And then once my break-in training was done, I was assigned to the Holden Barracks near Worcester.
At some point during your time in your career with the Massachusetts State Police, did you start to receive any type of training in the specific field?
I'm sorry.
Did you receive any specialized training at the Massachusetts State Police after the academy?
Once I got into the district attorney's office, yes.
And can you tell us a little bit about what type of specialized training you received when you were assigned to the Norfolk County District Attorney's Office?
Yes. So I was hired by the district attorney's office. I do cell phone and computer forensics, as well as I'm a sexual assault investigator. I had prior sexual assault investigator school done, and I went for digital forensics classes as part of my now daily duties.
In order to work
That's
with cell phone
ironic.
forensics, did you have any particular background in it at that point?
I had taken some classes when I was at Norwood PD, but I didn't have any of the Cellbrite or Axiom classes that I do now.
We'll talk about those in a minute so you can give a little more explanation. Did you ever receive a specific advanced degree in data forensics?
No, I didn't.
Did you ever receive any specialized further degree, a master's in data forensics?
No.
So your training came while you were a Massachusetts State Police officer through the Massachusetts State Police?
Yes, that's correct.
What type of courses did you take to learn about forensics?
The first one I took was Cellbrite certified CCO CCPA is their intro course that teaches you how to use the program and how to extract cell phones using Cellbrite program.
There's a couple words I want you to help us understand.
Yes.
The first is an extraction. What is, as simple as you can, a cell phone extraction?
Yes, quite literally is plugging the phone into specialized hardware or software, and it pulls the data from that device to make a digital copy of it, so that way we can load it up later to look at it.
Guaranteeing
So when
you
you
don't plug it
extract the
into
phone
software.
through a download, it basically mimics the content of the phone, but it's in a different shell. It's in a different form than inside the actual phone itself.
Yes, exactly. That way we're not manipulating or changing any data while looking, because if we were to open the device, it would change data by going through the phone itself or computer.
When you plug it in, can you explain a little bit about what you're plugging it into?
Yes. So the main program and hardware that we use is GrayKey. It is, again, specialized software and hardware that once the phone's plugged into it, the software is able to extract the information if we have the passcode. If we don't have the passcode and the phone is supported, it's able to guess that passcode depending on how long, like for an iPhone, if you have a 4-digit, it could take months. If you have a 6-digit, it could take up to 35 years.
So does the phone have to be accessible to actually do that download through GrayKey? Do you have to be able to open the phone with the passcode?
No. So if we don't have the passcode and it's supported, it can guess the passcode without making the phone useless after, say, for an iPhone, I believe it's 10 passcodes.
Is it a quicker process if you do have the passcode?
Much. It would take hours to download the device, depending on how much information's on it.
How do you ensure that the information that you extract from the actual device is accurate and the same when you're making a copy? How do you ensure the integrity of it?
So with GrayKey, it produces a progress report as it goes through its process. The only two fields that we can sort of amend in that PDF that it spits out is the ID number and then the investigator name. So after the data is pulled out, it creates a hash value, which is like a digital fingerprint for that specific information. So if you had gone in and to edit or change it, that digital fingerprint would change. It would change the big long string of numbers that it attaches to that file.
The digital fingerprint, is that the same thing you're referring to as the hash value?
Yes, exactly.
And how do you ensure that the hash value of the product, the copy, is the same as what's on the phone?
You print out.
You can run the zip file that it creates with the information into a hash calculator, and it will give the same hash as what is produced from the GrayKey PDF report. So if something had changed or there was an error with it, the hash would not be the same as what was given from the PDF. And that's how we know that the data was not the same.
So if you download a phone and it has a hash value, this digital fingerprint, and then someone was to manipulate the phone and remove anything, even a period, from that data, if it's run again, will the hash value change?
Yes, it would not be the same because it will show.
Even if it's just a period?
Yes, any alteration to that initial extraction with that number, it immediately would change.
So if you have an item, a computer or a phone, and you put it through the GrayKey program, and you do an extraction, a copy, where do you store that copy of information if it's not on the phone that you originally have? What do you do with it?
So once the program pulls that information, we have to place it onto our secure server at the office, and we'll take any of the files that were given via the extraction process, and it's saved there for us.
And so you copy it on another link or another digital file?
Yes, we'll save it to the server at the district attorney's office.
Can it be put on a physical item, like a zip drive or a hard drive?
Yes.
If you put that download onto a zip drive or hard drive, how will you know if that information on the hard drive matches the same information you originally downloaded from the phone to the server through GrayKey?
Again, like I said, you could run the hash value of that file again to correlate it with the PDF that we were given once GrayKey has given us the information. So that's how you would know all the information is the same, nothing has changed.
So for example, if you download an iPhone and it has that digital fingerprint hash value attached to it, and you make a copy or multiple copies, is the way to test whether or not those copies are exactly accurate is to look at the hash value of each copy?
Yes, and copying the zip file would not change the hash value. The only way it would change is if you physically went into it and deleted information somehow.
So now that you have the item, say for example, an iPhone, and you've downloaded it through Graykey, which is hardware and software, and it's on a digital file, can you just open it up and start reading it like a report or a book, or do you have to do something else to it?
No, once it's pulled into that zip file, it has to be opened into another program, which there are many forensic tools, but the ones at the office we use are Cellbrite or Axiom. They're two brands, and then those programs make that information readable so we can actually look at it.
So if you were to download a forensic copy and you were to open it up without using that subsequent software, would you be able to read or see anything that's on that data?
To be honest, I don't know because I've never opened one of those zip files to know what's actually in them.
After the extraction happens, after there's that copy made, did you mention this further software you would use to be able to actually read the data?
Yes, so that's Cellbrite and Axiom. They're two different programs, but those programs will make the information readable.
Are those the programs that you typically use?
Yes, they are. And there's other programs out there, but those are the two that we normally use at the office.
Are they commonly used in the Massachusetts State Police?
Yes, they are.
Are there other programs beyond Axiom and Cellbrite that can be used to decipher the information so you can read it?
Yes, there's many.
He's getting Lally-ish
In your
now.
entire time with the Massachusetts State Police, have you used any other programs other than Axiom or Cellbrite?
To look at cell phones?
Yes.
We have Sanderson forensic software that can look at databases that are in the phone to look at information. I don't normally use those because I don't want to say, I'm probably not proficient enough that I would know this exactly means this, or I wouldn't want to confuse anything that I'm looking at.
When you look at the information after it's been through the extraction and then the analysis through the software, is the data still available if you want to look into the data?
From the zip file itself, sir?
Yes.
Yes, it's always available. It's, like I said, the data in the zip file that Graykey gives us is never changed. It's just being loaded into another program so we can see it. That's all.
The software that you use, whether it's Cellbrite or Axiom, does that do the work for you as a forensic examiner?
Yes, so it runs, as the program runs, I should say, it will bring up different tabs. So it'll say phone calls, chats, photos, the databases, all different things that Cellbrite, their software, has run to pull this information out to make it easier for investigators to find what they're looking for.
Beyond the initial report that you can look at and look for the information, if you wanted to as a data forensic examiner, could you look deeper beyond the production of those software programs?
Yes, you could.
Forensic data analysis, when you look at these tools that provide these initial reports, is that the beginning or does it dig deeper when you're a digital forensic analyst?
No, these reports are finding the low-hanging fruit in the proverbial tree. So it's showing you the stuff that the program is set that most people are looking for. As I said, the phone calls, the chats. If you need to go deeper into it, as I said, there's other software out there where you can pull these databases and try to go through the code to find what you're looking for. Once you find something, you would have to corroborate it with other evidence or data to make sure what you're looking at is exactly what you're looking for.
Have you been involved in the download, extraction, and analyzing data on phones as your role with the Massachusetts State Police?
Yes, that's my primary role in the DA's office currently.
And how many years have you been in that role?
Since November of 2019, so 5 years now.
Have you worked on a number of different cases that involve forensic data?
Yes, I have.
Is there a routine or a practice in your present role when you make a copy about what process you use and how you produce it in a case?
I wouldn't say there's a normal process. It's all case dependent. A lot of cases we get, people want PDFs of the information, portable cases that we can create. So it's basically the portable program that I'm using. That way someone could find the information they're looking for, or I give the raw information if requested.
What's the difference between PDF form and raw information?
So Cellbrite can create a PDF form of every bit of information in the phone. It could be like a 10,000 page PDF. It literally just lists everything that's in there. If I create a portable case, as I said, that is basically like me giving you the thumb drive and it's showing you exactly what I'm seeing, and you can click on the tabs yourself from your own computer. And then if I give the raw file, that means someone has to go in and load it themselves to look for it.
Typically, when you are producing evidence of discovery in a case, do you produce PDF or the raw file?
As I said, it's all case dependent. Not all cases have forensic experts to come in to look at the information. So I'll supply whatever is requested. Normally the PDF or the portable case is what I give, but if more is requested, that's readily available.
And so the raw data, if requested, do you provide that as well?
Yes, if requested.
In this case, were you involved in any type of forensic data extraction?
Yes, I did the extractions of multiple phones and analyzed multiple phones in this case.
You mentioned that there's a software and hardware, the gray key unit. Where's that located?
That's located in the Digital Forensics Laboratory, which is keycard access and alarmed. Excuse me, at the Norfolk DA's office.
Are there other cases or the multiple cases that are occurring at the same time?
Yes, we constantly have phones coming in and out and being worked on.
What if you have a phone and the gray key unit's being used? What do you need to do?
We need to wait for that phone to finish, because if we say we unplugged it, it would interrupt that data transfer and we could lose it. So we wait until the phone's done and then the next phone goes up.
Did you become involved in some way in this case?
In the meantime, with the phone.
Downloading devices, sir?
Well, I'm asking generally first.
Oh, yes, sorry, yes.
Were you involved in investigating this case as far as speaking to witnesses or going to the scene?
No.
Can you describe the best you can what your role was relative to this case?
Yes, so I was brought, as I said, phones from this case to have the data extracted and then have it ready in our Cellbrite program for the investigators to look at.
At some point, were you provided a phone that you later identified as a phone belonging to Mr. John O'Keefe?
Yes, I was.
Do you remember when you were provided that phone?
Yes, it was January 29th, 2022, about 7:30 p.m. that night.
Do you remember where you received that phone from?
Yes, I was at the DA's office. I got it from Sergeant Mechanic and Michael Proctor.
Do you remember about what time of night that was?
As I said, about 7 to 7:30 p.m.
Thank you. When you received that phone, did you have the passcode?
No, we didn't.
Without the passcode, what were your next steps?
So the phone was placed in our digital forensics lab until we could get the passcode. I was told that a family member was going to be bringing it in so we could download the device.
Did you ultimately get that passcode?
Yes, we did.
And do you remember when you received it?
January 31st, 2022.
After you received the passcode for Mr. O'Keefe's phone, can you walk us through the process of what you did?
Yep. So once the passcode's obtained, we'll unlock the phone and then plug it into GrayKey, and then it's able to pull the full information from it without having to guess the passcode.
How long does that take?
Again, depending on the size of the phone, a few hours.
After the information was downloaded, then what happened?
We place on our digital evidence server at the DA's office, and then if the phone is evidence, it would go into evidence. If it was a consent, we'd give it back to the person who gave it to us immediately.
Did this phone go into evidence?
Yes, it did.
When you downloaded the information through GrayKey, which you said was the hardware and software, does it produce a report with that digital imprint?
Yes, it does. It produces a report from the time you plug it in to the process it completes, and then the amount of data, and then, like I said, that digital fingerprint hash value at the end.
And did you do that with this phone, Mr. O'Keefe's
Yes,
phone? May
I
I
did.
approach, Your Honor?
Yes.
Is this the PDF of the hash value?
Highlight. I'm going to show you a document, sir.
Okay, sorry. Yes, thank you.
I'm sorry.
Did you show it to Mr. Alessi?
I'm sorry. My apologies. Sorry.
Thank you, Mr. Brennan.
Yeah,
Yes.
I'm showing you a document. Can you look at both pages, please?
Okay.
Do you recognize that document?
Yes, this is the,
I'll just ask you a couple more
Oh, sorry.
questions if you don't mind. What is it?
it's the GrayKey progress report that they give once the phone extractions are completed.
Do you recognize that as the report that is attributed to John O'Keefe's phone?
Yes,
And does that document have that digital imprint, the digital fingerprint that you were talking about?
yes. So it's in, yeah, so it's here on the back. I just want to see if it was in two places. But it would be here for the, sorry, it's got cut off,
Why
but,
don't I put it up for an exhibit so that you
Okay.
can show the jury?
Okay.
I'll ask you some questions.
okay.
I'd like to introduce this as an exhibit, please.
No objection, Your Honor.
Okay, thank you.
Oh, Rusty is going to do the cross.
May I show that exhibit to the jury? May I approach the witness to show him the pointer?
Yes.
On this top button will be the pointer, the middle button will change the screen, so
Oh,
it's the top button, please. Can you walk us through what this report means?
yep. So here at the top, here it is. Again, it says GrayKey progress report, and then it gives the report generation date and time, and it is in UTC, which is, I forget the exact definition, universal time coordinates, I believe. So you'd have to minus 4 or 5 hours depending on daylight savings time. So this one would have been January's -5. 16/10 will be 1 noon, 12 o'clock for the actual time on the 31st. As we go down, device
11.
name is Johnny. The software version is the Apple iOS that was running at the time. Model number, iPhone 11. And then if you were to look up the N104AP is also a model number. The unique device ID. This one is what GrayKey assigns to the zip file that it creates. Serial number of the phone, the unique chip ID, the Wi-Fi address, the Bluetooth address, and then the phone number. And then there's more information underneath.
Could we scroll that, please? Thank you.
This here is the IMEI, which is the International Mobile Equipment Identifier. It's not uncommon now to have multiple of those identifying numbers. The data partition size of the device, which is 83 gigabytes. The lock state, if the phone was locked, it would say locked. This one is unlocked because we had the passcode. This was the GrayKey agent version for the software. And then this is the last time that the phone was backed up via iTunes or iCloud. This is the owner's name. You can have anything in this, but his phone had John O'Keefe set as the iPhone owner name, and then the different accounts attributed to the phone.
Okay. Can you show us where the digital fingerprint is?
Yep, it's down. So that, the top part here is literally every time when it's plugged in to every process that it completes until the progress report is generated. Here, there's the full file system was created on this date and time. And then even though the partition size was 82 gigabytes, it actually pulled 125 gigabytes of data. Underneath this, if you're on the next page, is that unique fingerprint right here. So it has two, a SHA-256 and an MD5. They're just two versions of hashing to show that the file, the unique fingerprints, and that's what these numbers are here. So there's one for the image of the extraction, and then one for the keychain for the other documents that Gray Key creates.
And you mentioned that if anything has changed, even a period, that number and letter sequence will change as well?
Yes, that's exactly right.
Did you have an opportunity to download and extract any other phones?
Yes.
At some point, did you have an opportunity to download and extract a phone from the defendant?
Yes, I did.
Do you remember when you received that phone?
I got the phone the same time as I got Mr. O'Keefe's phone on the 29th at around 7:30 at night.
And so you received both phones at the same time?
Yes.
From the same people?
Correct.
Trooper Buchanan?
Yes.
Trooper Proctor?
Yes.
What did you do with that phone?
Again, that was brought down to the digital forensics lab for holding until we could get into it, or a warrant was written, or whatever legal process was going to be done, so we could get that information.
Do you secure it?
Yes, that room is locked with keycard access that only myself and two others have, and it's also alarmed.
Do the case officers or investigators that aren't part of your unit have access to those items?
No, the only ones that had access were myself, Trooper Connor Keefe, and then the director, Samantha Vogt. She's a civilian that runs our lab.
Okay. And at that point, were you able, after there was process, were you able to get into the phone at first?
No, it wasn't supported by Gray Key, the phone model and number.
What do you mean it wasn't supported?
So the software, even if we had a search warrant, we plugged it in, Gray Key wouldn't be able to recognize it because it just wasn't supported at that time.
When you say it wasn't supported, does this have anything to do with a passcode?
For both. So we didn't have the passcode. So because we didn't have it, it wasn't supported for us to download that information from the device.
If you had a passcode, would it have been supported?
Yes, it would have been.
So is there a process when you have a phone that you don't have a passcode for to be able to access the content of the phone?
Yes, that's correct. We have to wait until we either have the passcode or the software and hardware is supported for the device where it can try to guess the passcode.
So let me ask you some questions about software. In forensic data analysis, does software change frequently?
Constantly.
When the software changes, does it advance?
Does the software get better?
Yes.
Yes, it does.
At the time you first had the defendant's phone, the software you had was unable to access the contents?
That is correct.
What do? Do you look for other software or do you wait for updates? What's the process?
If there is another software out there, we will use it to try to get the information. If not, we are at the mercy of waiting for the developers to come up with the information for us.
Did you wait in this case?
Yes, we did. We had to wait.
Ultimately, did software advance so that without a passcode, you were able to access?
Yes.
How long did you have to wait before you were able to access?
I believe it was July of 2022 that the software had been upgraded enough that it was able to brute force or guess her passcode for the device.
And where does the device remain until you're ready to try again?
In that locked digital forensics lab.
So when the software updates, in advances, do you know that it will be successful, or you plug it in and you try?
No, so on Gray Key, they have like a link where you can click and it brings up a whole matrix. So it shows every make, model of phone and then the software associated with it. And it says it can do a partial download, a full download, a password guess. And it tells us, so when there's a new update, we'll check that to make sure that the devices we have can be accessed.
Did you make an attempt to have the software access the phone without a passcode?
Objection, Your Honor. Move me approach, please.
Okay. So they had to wait. I remember this. They had to wait until July 2022 to brute force the phone. That was the explanation, that they couldn't search it right away. For those of you asking about how was Michael Proctor searching for nudes, he wasn't searching for nudes until August. The dates of the texts that he sent with his coworkers were back in August. So it would have been after they brute forced the phone. He would have gotten in and got it out of evidence, I guess. Definitely some things on my mind with all of this. Of course, we have this big gap. Last we heard about it, Kerry had it, handed it off to some mysterious unknown first responder. And now somehow it has ended up with Michael Proctor and Mary Duknick be given to him at 7 o'clock. There's the chain of custody. By the way, there's the chain of custody of it being in the locked part of the lab, like he's saying. Normally, when you have locked areas for access, you have logs that are associated with them. So you know when something is brought in, the fact that it's there, who accessed it, who brought it in, et cetera, et cetera. Like that.
Thank you. Did you use software inevitably to open the defendant's phone?
Yes.
And how many times did you download?
So there was 2 downloads. One, thank you. One of the partial part of the phone, and then we, in the same time that we had it plugged in, we had the password brute force guess software installed onto the phone, so we would try to guess the passcode. So there were 2 downloads, one with very limited data, and then one with the full file system extraction, which is everything on the phone that it can get.
May I approach?
Yes.
I'm going to show you 2 documents, sir.
Dismissal, yes.
Did you need a copy? Thank you, Mr. President. Give an extra copy of the phone. I'm going to show you 2 documents that actually, the first one, do you recognize that document?
Yes, I do.
Is that a result summary from Gray Key for a search of the defendant's phone?
This is the initial extraction that we created before the password guess process went through.
I'd like to introduce this as the next exhibit, please.
Okay.
No objection, Your Honor.
That's the original.
Yes, this is the first one.
Thank you.
Yep.
Exhibit 19.
I showed you a second document. Do you recognize that?
Yes, this is essentially the same information, except it goes further of all the password guess attempts longer until we actually get all of the information from the phone.
I'd like to introduce this as the next exhibit, please.
All right. No objection, Mr. Leslie?
No objection, Your Honor.
Exhibit 20. Somewhere.
have the previous exhibit as well, please? Sir, I'm handing you back Exhibit 19, which was the partial download.
Okay.
Exhibit 20, which was the subsequent download. You mentioned hash value changes with the content of each download.
Yes.
Is there hash values specifically assigned to each download?
Yes, there is.
Are they the same number and digits in digital fingerprint?
No, they're not.
And explain again why they would be different.
Again, the first one was the partial. It was only 45 gigabytes of data. So it has one number. The second download was 109 gigabytes of data once it got the passcode. And again, that number is completely different again. And again, like I said, the information is not the same, so the hash values won't be the same.
Were there two other phones that you inevitably analyzed?
Yes, there were.
Let's start with the first one. Did you have an opportunity to create a file on a phone that came from Kerry Roberts?
Yes, I did.
Now, you said it's a two-step process. First is the extraction, the copying, and then it's creating the file.
That's exactly right.
With Kerry Roberts' phone, did you make the extraction? Did you plug it into the gray key?
No, I didn't.
Who did?
Trooper Connor Keefe.
How do you know Trooper Connor Keefe?
He went to meet with Kerry Roberts, received the device from her. He brought it back to the office and did the extraction. His name is also on the extraction gray key progress reports as well. And he wrote 2 state police reports regarding it.
Do you work with Connor Keefe?
Yes.
He works with, I'm sorry?
Yeah, I would say we do the same, essentially the same job working together.
So he's in your unit?
Yes, he is.
In the digital forensic unit?
That's correct.
That phone, did it come with any paperwork, any forms?
Yes, he had 2 signed waivers of consent from both parties for each device, one for each device.
And so as far as the copying, the extraction, you did not do the extraction on Kerry Roberts' phone?
No, I did not.
After it was plugged in and a copy was made, did you then access it?
Months down the road.
Were you assigned at that point to analyze or look at any of the data on that phone?
Initially, no.
At some point, did you create a file so that you could provide it to the parties?
Yes, I did. Was
that upon request?
Yes, it was.
And separately, did you know, or did you, let me ask it a different way. Was a phone from Jennifer McCabe extracted?
Yes, it was.
Did you do the extraction?
No, I did not.
Was the information after extracted again provided to a digital file?
It would have been, yes.
Did you, at some point later, did you make a copy to provide to the parties?
Yes, I did.
Can you tell us what a USEF reader is?
So the UFED reader is a portable case that I can create through Cellbrite. Again, like I said, it's the exact same program that I would be viewing if I was sitting at my desktop, and said it can be made into a thumb drive to give to defense, prosecution, investigators, whoever. And there's no chance for the data to be manipulated because it's just a reader.
When you have the digital file that's been extracted and then created into a PDF or a form that can be read, can you print the entire file on paper if you'd like?
Yes, you could.
Would that include, could you print it so it includes the entire content of the phone?
Yes, it would be thousands of pages, but yes, you could.
Is there any way to isolate particular things of interest that you might want? For example, if you wanted just the chats between 2 people, is there a way that you could have a program isolate just those chats and then give you all of them in a form that you could read?
Yes, so you can go in to cherry pick whatever information you're looking for to create into PDFs or other, it gives 5, I think, different mediums. You can have it output: HTML, portable cases, XML files.
If you wanted to create a a document that had a number of people in communications. Could you do that as well?
Yes, you could.
So you can pretty much set the parameters how you want if you want to search for particular items.
Yes, it's very generous that way of being able to search for keywords, phone numbers, whatever it is, and then you can export that out into a PDF so you can print it.
May I have a moment, Your Honor?
Yes.
Okay. Did you go through the program and create a number of documents that isolated specific information that you wanted?
Yes.
For example, did you go through and create a report for all of John O'Keefe's calls for a period of time?
Yes, I did.
Did you go through the program and create a report for all of the calls between John O'Keefe and the defendant for a period of time?
Yes, I did.
Did you go through the program and create a specific document that would show just the text messages between John O'Keefe and the defendant?
Yes, I did.
Did you go through the phone and create specific separate documents for communications, phone calls, and text messages between Mr. O'Keefe and other people, not the defendant?
Yes.
For example, Ms. Roberts,
Yes, that's correct.
Ms. McCabe.
Yep.
Did you go through any of the phones and create documents to show any text or conversation between parties not involving John O'Keefe?
If directed, I could, but I don't believe I did.
When you took on the task of creating these documents, was it something you did on your own or something that you would wait for a request from a prosecutor or another officer?
I would wait for a request. Again, my knowledge of most of the cases is very, very limited. So if they're looking for something specific, I can assist them. If they need some type of help, I can assist them. But normally I will open it up for them and they have a better knowledge of the case, so they know what they're going to be looking for. Everyone in our office is Cellbrite trained. Or if someone new comes in, that's the first thing they'll go to is to a Cellbrite training, so they know how to use this program. And it doesn't put the burden on myself and Trooper Keefe to try to find everything for every case.
Thank you. Your Honor, at this time, I'd like to conclude this witness's testimony to be recalled again.
You're in agreement with that, Mr. Lessie?
We are, Your Honor, subject to the recall.
Okay. All right, Trooper, you're all set.
Thank you, Your Honor.
We'll see you again.
So no cross on just that
Should I-
You
section?
could just leave them right.
Thank you.
Houston, we have a problem with Mr. Gorino's testimony. We'll get into it.
Do you have another witness, Mr. Brennan?
May I?
Yes, please.
Commonwealth calls Mr. Whitley.
Mr. Whitley? Mr. what Whitley?
You solemnly swear the evidence given to the court and jury in the case now and hearing true the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
May I?
Yes, please.
Thank you, Your Honor. Sir, could you please introduce yourself to the jury?
Hello, my name is Daniel Whitley, Whitley. I'm a paramedic with the Canton Fire Department. I've been a paramedic and firefighter there since March of 2006.
Before you became a paramedic firefighter with the Canton Fire Department, did you work anywhere else related to that field?
Yes, I had 4 years full-time as a EMT intermediate, and also a paramedic at American Medical Response in Brockton.
I'd like to take us right to January 29, 2022.
Yes.
Do you remember that day?
Yes.
Were you working?
Yes.
What was your role that day?
I was a field training officer working on the ambulance with my partner, Jason Becker.
Mr. Becker?
Correct.
That morning, did you know whether there was a call where a group of your colleagues went to and addressed 34 Fairview?
Yes.
Were you accompanying your colleagues on that initial call?
No.
Where were you at the time your colleagues left to go to that location?
I was at the Station 2, Ponkapoag Station, on the north side of town.
Different station?
Correct.
At some point after that call came in and was responded to you, did you receive a call?
Sometime after, I'm not quite sure exactly how soon or later it was, but we received another call to respond to that scene.
As a result of receiving that call, did you make your way towards that location?
Yes.
Who did you go there with?
Just me and my partner at that time was Jason Becker.
What type of vehicle did you use to get there?
It was an ambulance.
What was the weather like?
It was snowing pretty heavily at that point.
Do you know about how long it took you to get to 34 Fairview?
Not exactly, but definitely longer than usual. It should have been an 8-minute drive. I'm guessing 10 to 12 minutes. You could refer to my partner's report for exacts.
When you got there, what did you see?
We arrived on scene. Our engine was there before. We run on a response with an engine and an ambulance to medical calls. And then at least 2 police cruisers and another car parked on the street, a gray SUV.
When you got there, did you meet with anybody?
Yeah, usually we get out, we say hi to my lieutenant and the other gentleman, Sam Parker, was on the engine before we got there. They were up front of where we parked, and then we walked down further, or at least I did, to the gray SUV.
When you reached the gray SUV, did you see anybody inside it?
I believe at that point we were kind of, getting out. We were walking down, they were coming out to greet us. There were 3 women there.
Okay. Did you speak to any of them in particular?
Not at that point, no, not really.
At some point, did you have any interaction with any of the women?
Yes.
In fact, did you know any of the women who were there that morning?
I knew Kerry Roberts.
How did you know Kerry Roberts?
First we're neighbors. She lives about 200 yards away from me around the corner. And she helped organize a neighborhood block party, and I would volunteer every year to bring the fire truck to the block party and show the kids the fire truck for a little bit.
So you knew her well?
No.
Were you friends with her?
No.
Friendly?
I just would describe us as acquaintances.
Did you ever socialize with her personally, other than the block party?
No.
But you knew who she was?
I knew who she was. I don't recognize her, yes.
Did you talk to her that morning?
Not beyond probably a hey or hi or something like that.
Okay. Do you know whether she ever gave you any items?
I know at one point I had to exchange whether it was a purse or a cell phone or some object from Miss Reed.
At some point that morning, did you have an opportunity to meet with the defendant?
Yes.
Where did you first see her?
We were in the process of getting her to go to the hospital.
When you say we, who was helping you?
That would be, my partner, obviously, Jason Becker, and then my lieutenant, Greg Woodbury.
Where was she when you first saw her?
Just somewhere outside in the street.
Do you recognize her in the courtroom today?
I do.
And could you identify her, please?
Yes.
Please. You're pointing to a person.
Dramatic.
Can you give just a
Import
very
IDs.
limited?
The woman standing, sitting in between these 2 gentlemen here.
Did you interact with her that morning? Have a conversation?
Yes.
When you first started speaking to her, what was her demeanor?
Pretty upset, crying. we had a Section 12 in hand, which is a medical order or a police order to be taken to the hospital for a psychological evaluation.
Did you discuss that with her?
Yes. Yeah.
Did you ask her to follow you or to come with you?
Yeah, she did.
And did that happen?
To the ambulance, correct.
So you went to the ambulance with the defendant?
Yeah.
And was Mr. Becker with you?
Yes.
What happens when you get to the ambulance?
I mean, so it was snowing, and it was more to kind of just get everybody into a nice warmer location where it wasn't snowing or windy or anything like that. And we would discussing that, we have a Section 12 that states we have, regardless of if you want to go, we have to take you to the hospital. She was arguing that she really didn't need to go to the hospital. And we were trying to convince her to go to the hospital because once the Section 12 is written, it doesn't matter what the patient says, we have to get them there one way or the other, whether it's cooperatively restrained or chemically restrained with sedatives or anything.
It's not a voluntary order?
It is not a voluntary order.
Inevitably, did the defendant agree to go with you to the hospital?
Yes.
When you were going to return to the hospital, was the defendant placed in the back of the ambulance where a patient would be?
So how we operate for anybody that's a Section 12 or anybody that is under the influence of anything, we always operate with 2 people in the back of the ambulance. So myself and my partner, Jason Becker, were back there. And then we had to take somebody from the engine company and have them drive to the hospital, and that was Sam Bach.
Sam Bach?
Bach, B-O-C-H.
Thank you. Before you left, before you started to drive away from Fairview, were you having any conversations with the defendant?
Yes.
Can you share with the jury what those conversations were about?
So we were talking. She was upset. She kept asking if there was any chance her husband could be alive, and even sitting outside in the snow with no coat on for many hours. And
did she indicate what many hours meant? How many?
No.
How often did she raise the issue of whether or not, or how long he could be out for?
I'd say at least 3 to 4, maybe more.
Part of your job is to care for patients?
Correct, yes.
Was part of your job to try to get them to the location safely?
Yes.
And sometimes you treat patients with physical injuries, don't you?
Oftentimes it is physical injuries, yes.
Are you trained when you're trying to transport somebody on how to interact with them?
Yes. Well, sometimes if they're upset, in this instance, she kept asking if there was any chance that he could be alive, and that we really didn't know what was the patient that Ambulance 1 took. We really didn't know what his condition was, and but figuring that it was a hypothermia type case, being the conditions outside. We were trying to give her hope that, there is a saying in the medical field, you're not dead until you're warm and dead. And I was basically, there's stories of children falling through ice and falling into rivers and being underwater for multiple hours and coming out, being resuscitated and having no neurological deficits. So I was telling her those stories just kind of to say, look, let's be sure we'll get to the hospital. We'll find out more there. Just trying to give her any sort of hope that her husband would be alive.
Can you describe her demeanor when she was in the back of the ambulance with you during your interactions with her?
She would go from pretty upset, crying. One instance where she kept saying, I can't take care of these kids. I can't take care of these kids. They're not my kids, and they're not his kids. And at that point, I understood who Ambulance 1 had taken, because John was pretty well known in the town for taking on the care of his niece and nephew. So I said, listen, it's okay. It looks like you have a very strong support system. And then Miss Reed said, do you know Kerry Roberts? And she had been crying. And she picked her head up and said, do you know Kerry Roberts? And I said, a matter of fact, I do. And she said, anybody who knows Kerry Roberts wouldn't say that about her. And I said, well, she did come to out at early in the morning to look for your husband in a blizzard. And she just rolled her eyes and put her head back down. And I thought it was just bizarre.
Objection, move to strike.
I'll strike that last sentence.
Would you describe her demeanor as even through that ride?
No.
How long did it take to get to the hospital?
I mean, you can refer to my partner's ambulance trip report. I'm sure it has the.
Do you have it right with you, sir?
I do not know.
Well, let me ask you.
I would guess about 15 to 20 minutes, somewhere in there.
You don't have an exact memory?
No.
When you get to the hospital with a patient under these circumstances, do you leave them at the door?
No.
What do you do?
We have to hand off care. So we go in and we have to give a report to a nurse to let them know what their condition is, why they're coming to the hospital, and what we found taking them to the hospital.
When you got to the hospital with Miss Reed, did you interact with the hospital personnel?
Yes.
Do you typically, after you hand off a patient to staff, do you leave?
Typically, yes. This time, Miss Reed was, I'm going to say, not really cooperative with the nurse there. The nurse was asking her to get into a Johnny, give a urine sample. She was not cooperative. The nurse tried to work with her, had an ER tech go and ask the doctor if she had to get into a Johnny. She came back. She said, yes, she's a patient. She has to do all the normal stuff. We really didn't feel comfortable actually leaving the general area. I don't know if it was just shift change or what, but security wasn't there. And with her demeanor, we just didn't feel comfortable leaving the nurse by herself with Miss Reed.
You said that there was some difficult times. Was there some difficulty about the defendant accepting wearing a Johnny?
Yes, she was refusing to get into the Johnny, and the nurse kept saying, well, you got to get into this Johnny. The nurse did try to work with her and asked the doc if.
Objection.
I'll allow that.
And so the ER doc, the ER tech had to come back and say, yes, she has to get into the Johnny. And at that point she did. She seemed to have calmed down and was getting into the Johnny. Security personnel had shown up, and we felt comfortable being able to kind of leave the nurse and the tech on their own.
Before security came, was there difficulty in her providing a urine sample?
Objection.
Do you know the answer to that?
Can you ask the question again? I'm sorry.
Why don't you ask it a little differently?
Sure. Do you remember whether she was giving the nurses a hard time about a urine sample?
Yes.
Objection.
So break that down, Mr. Brennan. The objection sustained.
You said that she was giving nurses a hard time.
She didn't want to give a urine sample. And then the nurses kept asking her to, this is the cup, you pee in the cup.
Objection. Last one, please.
No, I'm going to allow it.
You were there and saw this, right?
I saw it, yes.
Okay. Thank you. I have no further questions.
Can I proceed, Your Honor?
Yes.
Good afternoon, sir.
Good afternoon.
Sir, you knew before you got into ambulance 2 that you were heading to Fairview Road for what is called a Section 12, correct?
We would dispatch for a Section 12, correct?
Right. And that was not your first call for a Section 12, right?
No.
You had been in that job since 2006?
Yes.
You've handled a number of them over the years, correct?
Correct.
the fact that the call came in as a Section 12 gave you some idea of the nature of the issue that you might be dealing with, correct?
We had an idea that it was for a psychological issue.
Right. It told you that somebody at that location was suspected of being in some type of either psychiatric or emotional distress, correct?
Yes.
And on your crew, or of your crew, I should say, you were the one to drive the ambulance to the residence, correct?
I drove to the address at Fairview.
Now, you've said that when you got to Fairview Road, you don't recall the time, but you do recall that there were still emergency vehicles on scene, correct?
I do.
There was nobody lying in the front lawn of 34 Fairview at that time, correct?
Correct.
And do you know how much later after 6 a.m. you would have gone there?
You'd have to refer to my partner's report.
You don't know if it was minutes or hours?
It was minutes. It was within the hour. I don't know.
Within the hour,
Yep.
Okay. And you said that there were, or you testified that there were 2 police vehicles on scene, correct?
At least 2.
At least 2. There could have been more than 2.
It certainly could have been.
And those police vehicles in such a situation, particularly with the snow falling down, would have had their blue lights flashing?
I'm not exactly sure if they did or they didn't. Sometimes the police shut off their lights when they arrive on scene. Sometimes they don't.
Okay, so you don't have a memory one way or the other?
No, nothing sticks out.
But those police vehicles certainly were not hidden. They were in plain view, correct?
I would say so.
Minimum of 2, maybe more. Correct?
Yes.
And there was also a gray SUV parked near that residence?
Correct.
And there was a fire engine there as well, correct?
Correct.
You called it our engine, right? That was from
well, it would be engine 3.
Engine 3 from
or at
your
least the Station 1 engine.
I'm sorry?
The Station 1 engine. So Canton Fire has 2 fire stations. We were coming from the second station. The Station 1 engine is the one that responded to Fairview.
Okay, and that was a typical large fire engine, correct?
Yeah.
And did the fire engine have its lights on?
I assume it did, only because we rarely shut our lights off on a scene.
Sure. And there were police officers walking about, milling about?
Yes.
Do you know how many?
I know I spoke with Officer Sarif and Officer Mullaney.
Okay. And
so at least 2.
And you know them by name?
Yeah, Canton's a fairly small town, so you run into the police on a regular basis.
Sure, and you work cooperatively with them, correct?
Yes.
Were there other police officers besides Sarif and Mullaney?
I'm sure there could have been, but I don't recall ever speaking with them or interacting with them.
Okay. Were there other EMTs or firefighters there when you got there?
Just my Lieutenant Woodbury, and then Firefighter Sandpock.
Okay, and they were in charge of Engine 1?
Well, the Station 1 engine.
The Station 1 engine? Okay. And there were also civilians on scene, correct?
Correct.
So you would agree that there was a lot of activity outside 34 Fairview, correct?
There was a fair amount of activity.
I mean, there were people and vehicles and lights surrounding that residence, correct?
I assume so, yes.
Well, you were there, so you don't really have to assume, you know, right?
There was at least 2 police cruisers and a fire engine.
Right, and civilians, and police officers, and firefighters, correct? And civilians.
Correct.
All right. With all of that activity outside 34 Fairview, did you ever see the homeowner come out of his house?
I wouldn't have known the homeowner.
Do you ever see anybody exit the house?
I was not focused on the house at all.
All right. You were there to do a job, correct?
I was there to take somebody to the hospital.
Right. And you were there also to do a medical or psychiatric assessment while you were on scene, correct?
Well, yes, my partner was.
Correct. All right. When you got there, you learned, well, I have to strike that. You knew going there that your patient would have been Karen Reed, correct?
No.
Okay. When you got there, you learned your patient was to be Karen Reed, correct?
Yes.
All right. And given the nature of the call, you knew when you arrived that you would be transporting her to the hospital, correct?
Correct.
One of the first things that you tried to do was to get a medical history from her, correct?
Or my partner.
All right. And you were present for that, correct?
I may or may not have been.
Getting a medical history is important so that you can pass along information to the hospital when you eventually arrive there with the patient, correct?
Yes.
And you know that when assessing and treating somebody, getting more information is always better than getting less information, correct?
Not necessarily.
Okay, so there are times when you'd like to get less information from a patient before you transport them?
So it would be pertinent information. For instance, if somebody was complaining of chest pain and they had, stents placed in their heart, we wouldn't talk about how they had their tonsils removed when they were 12.
Okay, fair enough. But getting more information is not going to negate the crucial information that you do get, correct?
It certainly could in a critical stage. If there was a critical patient, we wouldn't typically overburden passing off a report to a nurse or a doctor with non-pertinent information.
Okay, it's not your testimony that getting less information is always better than getting more information, is it?
I would say getting pertinent information is better than having.
That wasn't my question. My question was, is it your testimony that getting less information is always better than getting more information, sir?
I would not agree with that, no.
Okay, thank you. Now, the medical history that was taken from Ms. Reed listed her as having multiple sclerosis, right?
I'm going to see it, Seven.
Karen's hearsay. Don't want to get into the MS. Remember, it's hearsay if she offers her own statement. It's not if the prosecution does. So they get to cherry pick anything that she says for their benefit, and the defense may or may not be able to respond. Their only option is the rule of completeness, where if they cherry pick part of a statement, the defense can ask for the remainder of it. That has to, in fairness, be considered to put it in context. Don't know that we have that foundation here. Kind of funny that he was just talking about how it's a small town and the cops all run into each other, but he definitely wouldn't know Brian Albert. Couldn't help but notice that. Mr. Yannetti, so far, he seems like pretty right on track as well with what he did in the first trial, which was to hammer with all these witnesses. It was, everything that was going on outside, painting this picture. And that's his point to get at. And the Alberts never came out of the house. They would have woken up because it was so loud and bright and so forth. This witness is fighting him, quite a bit. Doesn't want to give him even little things about new information better than more information. That's because he smells a trap. He knows that Mr. Yannetti is walking him down the road to make a point. He doesn't want to help him, but he doesn't know exactly where the trap is going to be sprung. So he's having to feel his way a little bit carefully, trying to qualify, talking about pertinent information. Sometimes it would be worse to get more information, because you don't want to be distracted in a critical situation. Well, okay, that's not what we're talking about here. But he knows he can smell the trap, that there's going to be stuff that perhaps Mr. Yannetti is going to criticize him for not getting. Info he should have gotten but didn't, or something like that. He can definitely smell that. I thought we saw the first fire engine leave on the dash cam. Maybe I already forgot. Maybe I already lost my mind 2 days in. 2 days into the retrial. Noticed how he was very vague about property. At one point, he had to exchange a purse or a cell phone or some object from Ms. Reed. I got the impression Mr. Brennan is trying to sneak the cell phone to him, and then he gave it to Proctor and Buchanan. And he's giving just a vague enough answer that they could be, well, maybe it was that cell phone, because we don't know. That was just his impression. Don't know if we're going to get follow-up and clarification on that. Kind of hope we do, because I wouldn't want to leave that door open for the Commonwealth to be able to come back and say, well, maybe it was Mr. Whitley that Kerry gave the phone to, and then that phone was passed on to Buchanan and Proctor. Because otherwise, I'm going to want to ask. I mean, I'm going to want to ask every single first responder that was at the scene, did Kerry give you this phone? Because it had to be either the first time at the scene before they left or after they came back. She didn't have other contact with law enforcement that day, did she? She had to get it to Buchanan and Proctor before they went out to Dighton, right? Because they went out to Dighton. Maybe not. I mean, maybe not. I don't know. I guess they got back from Dighton at like 5:30, and maybe somebody at the station could have given it to them then. This is the, kind of transfer handoff. But we got to trace that phone. I'd be asking every single first responder, did Kerry give me the phone? And I would clarify that. I want to know if the phone will say, yeah, he gave it to me.
Thank you. Sir, the medical testimony, history that your partner and you took from Ms. Reed listed that she suffered from multiple sclerosis, correct?
Correct.
And you know that that's a chronic disease of the central nervous system?
It's my understanding.
And what does chronic mean?
I believe any disease lasting more than a certain amount of time. It could be 2 years, 3 years, 4 years.
Persists for a long time or constantly recurs?
Correct.
And it's a disease that affects neurological muscle control, correct?
That's my understanding.
And last question, it's also a progressive disease, which means it tends to get worse over time?
My understanding.
All right. Now, when you first interacted with Karen Reed after you got to 34 Fairview and encountered that whole scene, it was clear to you that a major focus for her was whether John O'Keefe was alive or dead, correct?
Correct.
Bless you. She asked if somebody could survive after having been found in the snow without a jacket, correct?
For many hours, correct.
All right. And you mentioned something about hypothermia, that you assumed that you may have been dealing with a hypothermia situation from earlier, correct?
Well, she said that he had been out in the snow with no jacket on for many hours.
And you assumed hypothermia was your testimony, correct?
Yes.
You are not qualified to diagnose hypothermia, are you?
I'm not a doctor.
Okay. And you don't know if your assumption about hypothermia was correct or incorrect, correct?
Is my assumption correct?
My question is that as you testify here today, after having dropped off Karen Reed at the hospital for that Section 12, you don't know if the assumption that you made that you were dealing with a hypothermia situation was correct or not. Is that right?
Well, they were certainly working on him at the hospital as a hypothermia patient.
You don't know if your assumption was correct or not, sir.
I guess I don't.
And you told her, in fact, that you could not speak to that, correct?
I'm sorry, to what?
In terms of how long somebody could survive outside, correct?
I couldn't speak to his condition is basically what I was trying to say to her.
All right. But she still persisted in asking you over and over if he was alive or dead, correct?
Correct.
She wouldn't let that go. Is that fair to say?
Correct.
And that was despite your not being able to give her an answer, correct?
Again, we were just trying to sort of give her any hope.
Right. Okay. So she kept asking it, and you were trying to give her hope that he could still be alive, correct?
Correct.
All right. Now, today you claimed that her demeanor had changed when you mentioned Kerry Roberts, correct?
Correct.
And the term that you used to describe her demeanor when You mentioned Kerry Roberts as being part of a support system. What term did you use?
I'm sorry.
When you just testified on direct examination, did you characterize the way that she reacted when you mentioned
She had been crying in her hands, and I said, you know, it looks like you have a very strong support system. And she picked up her head. She had her face in her hands. She picked up her head out of her hands, looked at me, and said, "Do you know Kerry Roberts?" And I said, "As a matter of fact, I do." And she said, "Anybody who knows Kerry Roberts wouldn't say that about her."
Okay, and you've previously described that in testimony last year as her being snarky was the term you used, correct?
Correct.
But you were first interviewed by the police on February 8th of 2022, correct?
If that's what the report says, yes.
About 10 days after this?
About that.
And the events of January 29th were fresh in your mind on February 8th of 2022, correct?
As fresh as they are today.
Okay, so you do not allow that your memory was better on February 8th of 2022 regarding January 29th of 2022. It wasn't better on February 8th than it is today, is your testimony?
I would feel it's just as good.
Okay. Your memory does not get better over time, correct?
For this case, it seemed to stick out to me.
Okay, so are you testifying that your memory gets better over time?
No, but
that would be crazy, wouldn't it?
Correct.
That would be
in that
crazy,
February
wouldn't
8th,
it?
2022 interview, you were asked about Kerry Roberts, right?
I'm sorry, what day?
February 8th of 2022.
Okay.
You were asked about Kerry Roberts, right?
I do not recall if I was or was not.
You told the police that you knew Kerry Roberts from your neighborhood, correct?
Okay, yes.
And you've testified today that she just lived 200 yards away from you, right around the corner, right?
About that.
And you told police that you had seen Kerry Roberts on scene at 34 Fairview when you got there, correct?
Correct.
You also told police that Karen Reed had told you about making statements about her wanting to die, correct?
Correct.
But on February 8th of 2022, just 10 days after these events, you never mentioned to the police during that interview that Karen was snarky in any way, correct?
I don't know if I did or I didn't. I don't know if it would be in their report.
Is your interview recorded?
If you saw that report, would it refresh your memory as to whether or not you mentioned snarkiness?
I don't think I mentioned snarkiness that day, no.
All right, well, that answers my question.
Okay.
But after that interview, and of course, even after January 29th of 2022, you went back to your neighborhood, the same neighborhood that you lived in with Kerry Roberts, correct?
Correct.
Do you still live in that neighborhood?
I do.
Does Kerry Roberts still live there?
She does.
So you and Kerry Roberts have continued to live in the same neighborhood for years after January 29th, correct?
We have.
And before you ever encountered Karen Reed that day, you had interacted with Kerry Roberts in the past, correct?
Briefly, yes.
Well, you were both on the same neighborhood Facebook page, were you not?
Yes, that's why I volunteered to bring the fire truck to the block party.
One time she had posted on that neighborhood Facebook page that she wanted to have a fire truck at the neighborhood block party, correct?
Correct.
And that's when you replied and volunteered that you would bring the fire truck to that block party as she requested, correct?
Correct.
And you also worked with Kerry Roberts on the Ponkapog Civic Association, did you not?
I did not know. She worked on the board prior to my arrival on the board.
So you both worked on the same board, but just at different times?
Different times, correct.
All right. I think you had touched on this earlier. In addition to knowing Kerry Roberts, having been with the Canton Fire Department since 2006, there have been many times when you've worked in conjunction with the police, correct?
Correct.
And in addition to the 2 police officers that you mentioned having seen at 34 Fairview on January 29th, that being Sarath and Merlaney, you know many other officers at the Canton Police Station.
I do.
And as you say, Canton's a small town, correct?
Relatively.
People know each other, correct?
Correct.
You also knew former State Trooper Michael Proctor before you arrived at 34 Fairview, correct?
Former. I did.
Michael Proctor actually was 2 years ahead of you in school, was he not?
He was.
And you learned at some point that your school classmate, Michael Proctor, was the lead investigator into the death of John O'Keefe, this case, correct?
Yes.
And in fact, when you spoke to the police in February of 2022, Michael Proctor was one of the troopers to interview you, correct?
Correct.
You did not go to school with Karen Reed, right?
No, not to my knowledge.
You didn't help coordinate neighborhood block parties with Karen Reed, right?
Nope.
You were not in a civic association that Karen Reed belonged to at any point, correct?
Nope.
She was a stranger to you on January 29th, 2022, correct?
She was a patient of mine, yes.
Well, as far as you knew, she was an outsider to Canton, correct?
I did not know that.
You didn't live in the same neighborhood with her?
I'm not sure if we did or did not.
You had no personal contact with her either before or after January 29th of 2022, correct?
No.
All right. Now, as a result of your having gone to the scene, there's a patient care record that is generated, correct?
Correct.
All right. And on this issue of the snarkiness and the demonstration that you just did, there's a contemporaneous report of your team's observations from January 29th, right?
Are you referring to my partner's wrong report?
Yeah, the patient care report.
Yes.
All right. And that patient care report is dated January 29th of 2022 and is timed at 9:03 and 34 seconds a.m. Does that sound right?
Sounds about right.
All right. And that 9:03:34, from your knowledge of how patient care reports are generated, would that be the time that you arrived on scene or the time that the report is written?
I mean, I would have to see what time, the exact time you're referring to, but it could be the time the call is closed, or it could be the time you finish the report. There could be multiple reports. I'm not exactly positive which report you're talking about.
Okay. In any case, it was from that morning, correct?
Well, it did. I assume so.
I mean, there was only one morning that you went to 34 Fairview.
Well, no, but there could be two reports. So the engine has to write a report and the ambulance has to write a report.
But they're both about that morning, correct?
Correct.
All right. Now, there are boxes to fill out on the patient care record, correct?
Correct.
One of the boxes is primary impression.
Yes.
What does primary impression mean?
That is just what we believe the patient's not complaint is, but what we believe the patient is suffering from.
Okay. And that is listed on the patient care record for Karen Reed as a behavioral/psychiatric episode, correct?
Yeah. So that's a box we check for just about any Section 12.
Sure. And of course, that mentions nothing about snarkiness, correct?
No, that is my partner's report.
Okay. There's also a box for secondary impression, correct?
Correct.
What is secondary impression?
That might be like just a secondary complaint most of the time. A lot of the times, patients don't have a secondary complaint.
Okay, but in this case, it's listed as anxiety/emotional upset, correct?
Yes.
All right. And again, that mentions nothing about snarkiness, correct?
That's my partner's report, yes.
There's also a box for signs and symptoms, right?
There is.
And nowhere in the signs and symptoms box is snarkiness mentioned, correct?
No, I don't think that would be medically appropriate.
And then in the patient care record, it's recorded that Karen was found sitting in the front passenger seat of a friend's car, crying and visibly upset, but cooperative, right?
If that's my partner's words, yes.
All right. And those words, actually nowhere in the patient care record is it listed that she was snarky in any way, correct?
Again, that would not be something we would put into a patient care report.
And you did not put it in, correct?
It was my partner's report, and no, we did not put it in.
Okay. And once Ms. Reed agreed to go with you in the ambulance, it's fair to say she was still upset and crying, correct?
At times.
If I may have a moment.
Sure.
Actually, if I can just get my glasses so that I can see. Thank you. Okay, you had just testified that you said at times she was upset and crying when she got in the ambulance, correct?
Correct.
You testified on April 21st of 2022 before the grand jury, did you not?
I did.
And that was 3 months after the events that you're testifying about today?
Roughly.
And your memory back then was fresh, was it not?
Yes.
And you were asked the question, once she was in the back of the ambulance and she agreed voluntarily to go to the hospital, did she appear to calm down at that point? Do you remember that question?
I do.
And your answer was, I mean, she wasn't arguing against us at that point. I mean, once she, agreed to come with us voluntarily, I mean, she was still upset, crying, and talking on the phone. Do you remember that answer?
I do.
All right. You didn't mention in that answer that it was only at times that she was crying and upset, correct?
No.
Okay. The whole time, from beginning to end, Ms. Reed was constantly worried about John, was she not?
Objection.
Sustained.
You recall that she was on the phone at one point speaking to someone that she called Papa, correct?
Correct.
Did you later learn that Papa was John O'Keefe Sr.?
I am just learning that just now.
All right. And in any case, you heard her say to Papa, is he dead? He's dead, isn't he?
Sustained.
You could hear on the other end of the line that Papa was saying something to her, correct?
The objection sustained.
May I approach?
The witness or me?
Sidebar.
Okay.
These are both hearsay. Not sure how he's going to get him in, except for maybe a state of mind, not offered for the truth of the matter asserted. They're just offered to prove what Karen was thinking and reacting to at the time. Oh man, I'm not in love with Mr. Yannetti either today. we had an AJ criticism this morning. Now I'm going to not be so thrilled with how Mr. Yannetti is doing. There's so many things I like about his style. Okay, when he does something really good, I definitely want to call it out. And that moment where he led this witness into, surely you're not saying your memory is better over time. That would be crazy, right? Anytime you can maneuver somebody like that by just triangulating them against common sense, that's a very good technique. Everybody can understand that. It's very effective. But he likes to hammer on things past the point where it's effective. The whole, it's snarky. You didn't say it's snarky. You didn't say it's snarky. And the problem is every time you've asked that, now you've given the witness an opportunity to think about, how can I explain it? And so you've opened the door for him to say, well, no, of course we didn't put it down. It wouldn't be medically appropriate to say that. But if you had just stopped it at the first time, you would have been left with, no, it wasn't in there. But like you had to make the point to hammer on it, hammer on it, hammer on it. And now I don't feel that this impeachment is particularly particularly effective because I don't see a big inconsistency between what he said to the grand jury, that she was still upset and crying and talking on the phone, and didn't say that she was only at times crying upset. I mean, it sounds like he's talking about a particular moment when she got into the ambulance. So I'm not sure I see a particularly big inconsistency here. Looks like he's shooting for something to make a point. And once again, to kind of reiterate my theme for today, I don't know what the point of it is. I don't know what I'm supposed to get from the defense out of this witness. I didn't hear about it in opening. Where does this witness fit in with what I need to know or not know about why Karen Reed is or isn't guilty? I don't know. I'm left with a general impression that I should not believe this witness. I should find this witness to be not credible, but I'm not really sure. And I'm left with a general impression. I'm supposed to think that him being neighbors with Kerry Roberts has had some influence over his testimony. Okay, but I'm not sure really why. And I don't think that that's landed. I don't think that that's landed. I have neighbors I've never talked to. I don't know. I don't really do the neighborhood Facebook group thing or anything like that. Oh, the Nextdoor. I hear about the drama on Nextdoor. Never done that, but hear about it.
It'll be short. I don't want to keep you folks here until 4:30. It's been a long day. So I'm going to release you today, have you come back tomorrow. We'll make every effort to start right at 9 tomorrow. Please follow those cautions. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know and be very careful on your social media, okay? Thank you. Have a good night.
All rise, please.
Are we arguing something outside of the presence of the jury or just done for today? I'm sure we will find out. In the meantime, they're gonna, at least we don't see the cobweb when they point the camera directly at the light. We don't get that reflection. We just get the direct glare from the light, and it burns out that cobweb that was hanging out up there. That was going to drive me nuts almost as much as the windshield wiper. Just, guys, you got to replace your wipers. If you drive in winter, you got to replace your wipers.
All right, so we're still in session.
Court is still in session. Please be seated. It's my
All right, so I would like to move things along a little bit more expeditiously tomorrow. What would be very helpful to me, Mr. Brennan, are these clips. I haven't seen I haven't watched anything on television about any of these. Do you have them all in one compilation that I can look at in advance? If you don't, you don't.
I thought we had provided it to the court. If we haven't, we will. May I have a moment?
Sure.
I bet she hasn't watched any of it on TV. She don't want to know.
Is it 100 hours or something, or is it?
No, we sent the share file, but it's my oversight. We should have brought in a hard copy for you as well.
I don't know that I have a shared file. Was that?
Dropbox link on Monday that we sent, but I can put it on a zip drive as I should have. And I can.
All right, because I couldn't open that. It needed an email and it didn't accept mine.
Didn't realize the court didn't have access. We will get a zip file. And
all right, you talk to Tori about it. Okay, Tori, you'll get it for me. All right.
The intention was that you'd have an advanced opportunity to look at them. I'll fix that failure.
All right. Have your associate talk with Tori.
I will.
All right. All right. Anything we need to know before tomorrow?
No, Your Honor.
All right. We'll see you tomorrow.
So I guess, we're not done with cross of Mr. Whitley, or was that her way of just kind of communicating to Mr. Yannetti, you're done? I mean, what else does he have? Does he really have anything else? If they're going to sustain the stuff about what he overheard on the phone, then she's not going to let him get into it. Does he have anything else with this guy? I don't know. if he was important and I knew why he was important from the opening statement, I wouldn't have that question. So sorry to keep harping on that, but it's just going to be my theme. So number one thing that I think they really could have done better from last trial. I'm not seeing them doing it. It's disappointing to me. I'm honestly just seeing a lot of rehash from trial one. This cross of Mr. Whitley, this is Karen Reed was framed 2.0. This is the same Karen Reed was framed 2.0 because we got to put suspicion on kind of everybody that's collaterally involved in the investigation. But a lie is a lie. After Brennan, it's effective. Yeah, I don't know. Okay, it looks.
I was up.
I
mean, I had
anything coming on. I'm gonna shut that off. Yeah, we remember when you apologized, Diddy. That one's coming up soon. Kind of surprised they didn't get a continuance, but what do I know? But yeah, this is recap of Karen Reed was framed 2.0. As far as I'm concerned, it's everybody who is connected is under suspicion, and Karen is the outsider. And these are just kind of the themes that they developed the first time. That's not the theme of this trial. This trial is John. There was no collision. There's no collision. So none of this stuff matters. I don't like seeing them continuing to rehash the strategy from trial one, because to me, it just feels like they are letting the Commonwealth drive the train on what the strategy is. And they shouldn't be reactive like that. Just like Emily D. Baker said about the Commonwealth, if your theory of the case depends on what ARCCA witnesses do or don't say, you've got bigger problems. The defense is in the same position. If your case can be blown apart by a firefighter paramedic saying that she was snarky to Kerry Roberts, I feel like you got bigger problems with your theory of the case than that particularly testimony. Who cares? Who cares? Women are sometimes snarky with each other and about each other. And boy, is that going to take me full circle back to where I said we were going to have a hard conversation, because we're going to talk about patterns. We're going to talk about patterns in relationships, because we're talking about domestic violence. Okay. It is domestic violence to kill your partner. And the thing about domestic violence is it doesn't always, in fact, probably rarely starts off with physical violence. It's an escalating process. It starts much milder than that. It starts with name calling. It starts with controlling, monitoring your whereabouts. Who are you talking to? Isolating. It starts with these kinds of behaviors, and it escalates and it escalates and it escalates, and it culminates, worst case scenario, in some type of violence that often ends people up in court. So we see this pattern over and over and over and over again. And yeah, the thing is that most of the time, people who find themselves in these relationships and stay in these relationships, it's because that's what they know. There is a familiarity to it. There's a normalization to it. There's a history. Because people learn how to bond and how to interact with each other from other people, usually the people that you see growing up. So having said all that, let me take us to the hard part of this conversation, where I acknowledge Peggy O'Keefe is grieving, understandably. She has probably had been in a lot of pain. And I believe in her sincerity of her pain here on the stand. But she displays some problematic behavior. And it's behavior that can be characterized on the very, very, not physical end of the scale, but on that closer end of the scale as abusive. I found it remarkable that Hank Brennan just went ahead and called it out straight like that in his argument. Karen's trying to pitch herself as a victim of Peggy O'Keefe's abuse. Well, we did hear it from Kerry Roberts, didn't we? First off, from Kerry Roberts, that they're in the hospital and she wants to know what happened. Karen tells her, I dropped him off. We were at a party. I dropped him off. And she's like, and you just left him there? And oh, we got a doorbell going. And it's stuck. Somebody's going to come fix that. Pardon me in the meantime. And so her husband had to tell her, according to Kerry, you know, she's been through enough. She doesn't need shit from you right now. Have some fucking empathy for this other person. She doesn't need to be attacked by you in this situation. It's problematic behavior. We can maybe cut her some slack because, yeah, she's also grieving and she's also worried and she's also maybe a little bit frantic. But it's just something that's a little bit concerning. Something else that's a little bit concerning. When she gets on the stand and the first thing she does is belittle her husband. Guys, I know there are people that think this is funny. It's not funny. It's not cute. Nobody thinks it is. It's not cute to belittle your spouse who've been married for too long. Too long we've been married. That is not a supportive, loving type of comment. They've been married too long. Then she's very upset talking about her daughter, Kristen, who died. Very upset when she's talking about John. And then Paul is over there. It was like a switch flipped. And then Paul is over there. There's Paul. There's a certain kind of pattern of behavior that you sometimes see in parenting that can be very damaging to children. Not saying for sure this is here, of course. I don't know. I didn't grow up with these people. I just see signs that alarm me, red flags. And when it looks like somebody has golden children and scapegoat children, that alarms me. That alarms me. John and Krista, we are devastated about. Paul's over there. That just tends to not be a real emotionally healthy environment for children to grow up in. If that's the kind of attitude that they're subjected to, these children are important. This child is not important. Kind of sets up a scenario where the kids are in competition with each other. Kids are competing for the affections of the parent. And that can be very, very damaging for the children. And so then we look at the patterns, right? We've already talked about John is 40 some years old, 43, 45 years old, hasn't been in a long-term committed relationship, has these series of girlfriends. Some of them are nice, but others are randoms. So shallow. Series of shallow relationships. Kerry herself didn't get it elicited this time, but in that last trial, you know, Karen's just a babysitter with benefits. There's no depth of the connection there. There's just a shallow kind of connection. Take a look at everybody else around John O'Keefe. We're not going to get the Sullivan sisters this time. We're not going to get them this time. We got them in the last trial. Little catty, maybe? A little competitive with each other. See patterns. patterns. People tend to find the same people over and over and over again. That's what you know, that's what you're comfortable with. And you may not even be aware of it, but it's just how things continue to unfold. And that's why, people talk about therapy and do the work. It's really what they mean is understand your role in contributing to these patterns. If you recognize a pattern that's dysfunctional, you have to recognize it and you have to look at how you are contributing to it before you're ever going to be able to fix it. You're not just a victim of circumstance. Everybody makes their own choices and they make their own choices for a reason. So this is just, some of what I saw that alarms me a little bit, because there's obviously a lot of case still to come, but we know what some of it is. One of the things we're going to see is the communications between John and Karen. Now, remember the whole theory, the Commonwealth's theory of the case here is that, their relationship was falling apart. And so this was an act of, I don't know, retaliation, rage, scorned woman, something like that from Karen. That's pretty much the same way as saying control. Okay. In abuse language, you're talking about control. That person's going to leave. I won't allow them to do that. I will kill them instead. That's control. And so that's saying Karen's an abuser. And she escalated it, right up the ladder to this point where she would kill him. It's not what I saw in the text messages between Karen and John. It's not what I saw. There might be arguments back and forth. Maybe the argument, she's constantly calling him. She won't take no for an answer. He's always got to answer. Yeah. You can see that as potentially being controlling focused behavior. But just it can get very difficult to sort out these relationships because, again, people are complicated. People are complicated. It isn't always as simple as being able to say this person is an abuser, this person is a victim. There's often bilateral violence. There's often reactive violence. But it's just something to bear in mind as the trial continues to go forward. Bear in mind, at the end of the day, this is domestic violence that's being alleged. And so given that, and given what we know about those patterns and how they emerge and how they recreate over time, as we see the evidence unfold in front of us at this trial, can we get a sense of how those patterns operated in these people's lives and how they would have reacted to that and how they carried those patterns forward? So that's my difficult chat today about domestic violence based on what we saw on the stand. So just, I guess, our recap for today started off with that issue from brand new stuff from Gorino. Didn't introduce it today. They're going to recall him. That's why they didn't get to cross-exam. But yeah, ironically, just a day after the Commonwealth is screaming about how we can't possibly defend ARCCA with their late production, they themselves are late producing stuff. It would be laughable if it were still funny, but it's like the joke that you've heard too many times by now. It's just not really that funny anymore. So defense has to give their objections to the PowerPoint by tomorrow. Wolf and ARCCA witnesses, that voir dire has been deferred till Monday. It was on condition from Judge Cannoni. If we do it Monday, he has to finish his testing by then. Why? Why does Friday to Monday make any difference in terms of like a sanctions calculation? You didn't say it before. You didn't say he had to have it Friday. Why would he have to have it Monday? This just seems like a kind of arbitrary. He's going to have to work over the weekend to get it done if you're going to use it. Remember how I was saying it really looks like she's looking for a reason to be able to kick them out? So she's been told he's got a scheduling conflict. And so now she's going to create this new condition. He's got to get his testing done over the weekend, or it, you know, that's the unspoken or. I won't let him use it. That's the unspoken or else. Why does it have to be done Monday? I don't know. I don't know. There's no real rhyme or reason to that fits into where we've kind of already been with the case. Previously, it was just going to ARCCA. It was just going to be the voir dire of ARCCA sometime before they testify. Now, all of a sudden, everything is getting accelerated to 5 days from now. 5 days to finish his testing. Out of nowhere. I think it's a tell, guys. I think it's a tell. She's really trying to set that up. So then Alessi asked what I thought was a very reasonable question, which is, what is this voir dire even about? Yeah. Bev's just like, well, we're going to have a voir dire. Okay. Why? What's the purpose of it? What's the purpose of what is the issue that we need to talk to ARCCA about? And she's like throwing this, she's doing that thing. It's just like with the objections. Oh, you should already know. She's like throwing it like they should already know why she wants ARCCA there to voir dire them. Although she hasn't said, and she hasn't said exactly which problem is it that is necessitating ARCCA being present. So they have to apparently anticipate and address all of Hank Brennan's outstanding grievances and present them to ARCCA. It's really not how a voir dire usually goes. Often in this type of situation, it's not the person who's calling them that's conducting the voir dire. They already know. It's the person who has the questions about it that's conducting the voir dire. And so this will happen all the time. Like often it's just basic things like in the middle of trial, somebody's testifying to something. It's not clear to me maybe what their foundation is. I'll say, you know, Your Honor, object. May I have an opportunity to voir dire? And I'll be able to ask that question and clarify so that I know, is there a foundation for this or not? And if there's not, then I can object on the basis of foundation. It's just kind of an example off the top of my head. So the voir dire is usually by the person that is challenging the witness because they need to know something as a predicate to knowing whether there's something else I need to ask for. But she's got this all reversed where now the defense team is going to have to address all of Hank Brennan's grievances, which puts them in a situation where, you know, they have to over ask now, or they risk there being an issue with their record. So to the extent this is about Hank Brennan getting a free examination of ARCCA, a free cross, yeah, this is really consistent with that, I think, because you're putting it on the defense in a situation where they don't really have any choice but to try to put everything they can think of with ARCCA out there, because of the risk that if they don't, you might say, you didn't bring that up, you didn't voir dire on that, therefore you can't use them, you can't use that. I mean, you don't know. It's so unpredictable. That's not how a courthouse is supposed to work. It's not how a courthouse is supposed to work. You're not supposed to have to guess. What's the problem here? And what are you getting at? And what are we doing? Why are we doing this? Perfectly reasonable question by Mr. Alessi. And He's a smart man. Bev's answer, I am indifferent. I am indifferent about this voir dire. She's above all that. I found a discovery violation, so I'm giving you a chance to put them on, and then the Commonwealth can cross-examine. A chance to put them on for what? Why would I need to put them on? I already know what they're going to say. I already know what the deal is with the communications. I'm not the one with questions about that. Why would I need to put them on? And so that's kind of what's so aggravating about dealing with this judge. She's expecting you to read her mind, but her mind is like not going in the direction that normal legal practice, normal legal research, etc., would take you. ABA rules? Why on earth would I be contemplating that the ABA guidelines for record retention would be binding on me in the state of Massachusetts that hasn't adopted them? Like, that's where her mind goes. And yet also I'm supposed to forecast where her mind goes because I should already know. It's irresponsible is what it is. When she says to the jury, her job is fair and efficient progress of the case. It's not efficient. It's not efficient to play this little, you don't know what I'm thinking, but you should. And I'm not going to just tell you. It's very immature is what it is. So that's annoying. And ultimately she comes back down to, now she's at Mr. Alessi. Now she's trying to lump Mr. Alessi into this whole problem that she's perceived with how they've discussed their relationship with the ARCCA experts. You said the bill came out of the blue. But all of these 100 text messages and so forth, that gives me some pause. Love that Mr. Alessi pointed out 30-day delete is standard. And in fact, that's what Mr. Morrissey did. Remember the looking for texts and emails and so forth from Mr. Morrissey from his burner phone? You remember that, Judge? You remember that? 30-day delete apparently is standard there. So is it the ABA rules that apply or not? Does it apply to the Commonwealth or does it only apply to the defense? And if not, that's not the issue. It's just the fact of the 100 ones that you don't like and you think that gives you pause. That doesn't mean they had an obligation to keep it, does it? No, it doesn't. So it doesn't mean there's a discovery obligation. And so your suspicion, you're entitled to it, but that's all it is and all it would stay. So, bulk of Kerry Roberts's testimony today. I'm just going to kind of flip through and see if I can catch the highlights that I haven't hit on. I mean, overall takeaway, I really did think she was much less sympathetic this time on direct. She was much more, closed and haughty. I feel like haughty is just the best way for me to describe her kind of attitude. Friend of John's and a little catty about women. Look at that theme. Look at that theme. Kind of like how Jen McCabe is a friend of John's and Jen is a little catty. She was a little catty about Kerry. She's a little catty about Kerry. Talks too much. Dropping that whole babysitter with benefits thing. She outed Kerry as being the gossip. Just noticing a pattern. By the way, guys, it's absolutely fair to consider where Karen fits in this pattern too. Absolutely fair to consider that. I mean, consider this hypothetical. All right. One of the reasons why somebody can have shallow, not long-lasting, deep bonded relationships is because they think they're better than the other person. They're too good for that person. They're okay to play with, but not going to keep them around. Not going to do anything serious. And somebody who's a golden child might have a kind of mindset. They've been taught. They've been taught you're better than everybody else. Might be common to have that kind of mindset. But you notice Karen doesn't fit that pattern, does she? You heard a lot from the last trial, like Laura Sullivan. She was the the Aruba sister, the older one, who had been married to John's partner, I think, or engaged to John's partner at Boston Police Department, and he died, and it was tragic, and she ended up dating John for a while, and it didn't work out, but they remained friends. And this was a big pattern with John from the last trial. He's got all these exes, but they all kind of continue to circle around. He stays in touch with them. He texts with them, gives them attention. But Karen really didn't fit that mold. Right? Because they were, they did get back together. They had previously dated years before this. But it didn't sound like they stayed in touch. They just kind of got back in touch. Got back together. Anyway, she doesn't really fit the mold of, from my perspective, thinking that John is too good for her. He was just too good. That's why he would leave, and we would understand it and be cool with it, because we've bought into that. Yeah, he really was too good for me the whole time. It's okay. Maybe if we stay friends, I don't think Karen shared that perspective. And why would she? She's not dependent on him. She's a professional woman herself. Got to point out the playing with Higgins. A lot of trials still to come. But the playing around with Higgins, it's not long-term bonded relationship. I don't know, guys. These patterns are tricky to work through sometimes. Anyway, back to Kerry. Really didn't find her anywhere near as sympathetic this time around. That walkthrough of the dash cam video, I know that was excruciating for everybody. I really appreciated getting able to see the whole thing pretty much from beginning to end, and then see large chunks of it, not seeing it chopped up. It just helps keep everything together and in relationship with each other. And so then, when we're talking about, is it this point on the video when you took John's phone, or is it this other point on the video? It just, the entire process makes a lot more sense. And it isn't like two disjointed, disconnecting things that are trying to be fit together, but I don't really know how they fit together. Okay, I saw this one happen before that one, and what was going on in the meantime. But that's really going to be the key to Kerry, I think, is she put John's phone in her pocket and she handed it off to a first responder who I would be asking every single first responder at the scene, did Kerry give you John's phone? Every single first responder, did Kerry give you John's phone? Who is going to step up and say, yeah, I'm the one she gave the phone to? Nobody volunteered last time. So let's put them on the spot this time. Let's find out. Who did she give the phone to? Oh, yeah, that story about Karen saying she left him at the party, and Peggy saying you just left him there, and John said she's been through enough. John has to placate his wife. Another pattern you see, pattern of appeasement. Pattern of appeasement. Consider a pattern of appeasement when you look at the text messages between John and Karen. Just a pattern to bear in mind. The blue bracelet. Okay, it wasn't really significant, but you know, good tearjerker thing for the Commonwealth to elicit. Instantly becomes fast friends with Jen, and her explanation is because they went through something horrific together. I can understand that, honestly. Yeah, I can understand that. It's not the worst explanation ever. It's just that the defense needs a theory for how to deal with it. And so what does that mean? What does that mean? Okay, it means you were subject to Jen McCabe's influence. And if Jen McCabe is your ringleader, she's your organizer, your fixer for this whole situation at 34 Fairview, then how did that operate? What's your theory for how that worked with Kerry? Did Kerry knowingly conspire with Jen? Did Kerry just be subject to suggestion from Jen? She's a confabulator like Mr. Nuttall, incorporates things into her memory that didn't happen. You need to have a theory and be able to address that through your approach to the witness. I'm not sure what I'm supposed to think of Kerry. Is she a liar? I don't feel like that landed. They tried, but I don't feel like it landed. Is she just inaccurate? Maybe. She's got an explanation. I have a lot of sympathy for the I didn't understand Mr. Lally's question, because you watch the first trial. He's not good at asking questions. He tries to put every single thought into his question. They're disorganized. They're disjointed. They're all over. They're incorporated. They include all this qualifying language with respect to, that is just, it was a mess. So I can kind of sympathize with that too. Didn't understand the question. It's a good answer. It's a good answer. And I can honestly, if I'm being very fair, yeah, I could see how you would misunderstand that question, because, you know, anything that that Karen said to Jen in the car that you heard, does he mean the thing that Karen said? Did you hear the thing that Karen said, or have you heard about this thing in the car? I mean, I could see how you could maybe not be entirely sure, especially if it is something you have heard and not something that you personally witnessed. And so you're like, oh yeah, he's asking about that thing I heard. Here's the thing I heard. Your mind would go to that. I can kind of understand that as an explanation. I really can. But that's where I think the phone is so critical, because that's what the phone would tell us. She gave it to a first responder or she didn't. If she didn't give it to a first responder, I don't think that's an accidental I misremembered. Because then we got to go to, who did she give it to and how did it get to Proctor? If she did give it to a first responder, I got to give her the benefit of the doubt. You know, maybe she's inaccurate, but I'm not convinced that she's deliberately being inaccurate. But if she's lying about the phone, yeah. Falsus in uno, falsus in omnibus. You can't trust them. If she lied about that, you can't trust what she has to say. So I'm asking every single witness, every single first responder that was at that scene, did Kerry Roberts give you John O'Keefe's phone? She started to get uncomfortable, I thought, during the questioning about the visit to Lank's house, because she knows they have stuff, but she was very cautious about answering sort of the surrounding circumstances. Where did you go before that? How long were you there? You left Jen's kids at that house. You didn't go to 34 Fairview first. But they didn't impeach her with it, so they don't have it for her. And I guess, yeah, they wouldn't have had her phone. Well, no, this should be on her phone, shouldn't it? Because this was the very next day, and they didn't get her phone. Did they get her phone the same day? He just told me that. Trooper Gorino just told me that, but I thought it was a couple days later. So John's, they did the extraction on 131. 129 at 7 is when he got John's phone. He got it at the same time as Karen's phone. Where in my notes? Connor Keefe did the other ones. And I don't think he said when. I don't think he said when. If he did, I didn't write it down. This is the very next day. They would have her location data if they got her phone after to do the extraction. That's kind of what I'm getting at. So I don't know if they have hers or not. They should. They should have it if they got her phone later. And my feeling here is that they got her phone later. Yeah, you're right, guys. After the arraignment. It was after Karen's arraignment. So that would have been on February 1st or February 2nd. That's how they walked that through. Yeah, that's right. It should be on there. If they had it and they didn't use it, I'm going to be upset. I'm going to be upset. If you left it in your back pocket because you're, setting up Jen or something like that, I'm not going to be happy with that. It's just, that's not smart. It's such a gamble. You never know if you're going to get that same pitch. When you have that, I'm in the middle of some Phillies trauma right now, so happens every season. But when you just hang that slider right out over the middle of the plate, you don't know if you're going to see that one again. You're going to swing at that one. You're going to swing hard at that one. You don't just let it go by because, maybe you'll get a fastball that you could hit harder. I don't like letting it go if they had it and didn't use it. And they should have had it based on the timing. It was a couple days later she handed their phone over. They should have it. Maybe they didn't get it from the extraction. I don't know where the location info was sourced from. It could be not from the phones. It could be actually, would it be geofence? Would they? I can't see that they'd be geofencing Mike Link's house, the feds, but maybe they did. I don't know. So that walkthrough with the dash cam, I really liked it. I liked how they pointed out, here's where you said you got the phone. It looks like that's when she would have picked up the phone because it does look like she's putting something in her pocket. It does. You can kind of see it right there, her putting something in her pocket. But maybe it wasn't, but that's when she said it was. Right there within a couple minutes of at the scene, and it's right as first responders are arriving. But it's not when she said it was, which is when they, lifted John up and put him on the stretcher and carried him away. It wasn't then. So, a lot of meetings with the DA's office. 50 times you've communicated with the DA's office. Guys, there are cases where the DA never talks to the witnesses until trial. That is not uncommon. It's not very professional, but, you know, kind of like public defense, unfortunately, in prosecutors' offices, sometimes the bar isn't very high. Sometimes the bar is kind of low when it comes to performance. There are prosecutors who don't talk to witnesses until they show up to trial. And then there's prosecutors who meet with a witness 50 times. That gets my attention. That's a lot. That's a lot of times. And so most of it was, according to her, with Steve Nelson, the victim witness guy. Curious about that? I'm curious about that. Jen asked her to relay information a few times or find out information a few times. That gets my attention. Still not quite sure how to tie all of this together, or what I'm supposed to mean, what I'm supposed to make of it, or if I'm even supposed to make anything of it. Is this just a possibility the defense is fishing for, or does this mean something? It's part of what I don't like about these broad crosses. You're supposed to put together what's meaningful and give that to me. If you expect the jury to do the job of piecing it together, you're asking a lot. You're asking a lot. So, anything else really important from Kerry? She did start really getting cautious on cross. I don't know. I don't recall. I don't remember. Okay, this is a witness who's been coached. And by coached, I don't mean coached in the sense of like told what her testimony is supposed to be, coached in like the unethical way. I mean prepped. This is a witness that's been prepped. I should use that instead. She's been prepped. The first thing you tell a witness who's getting ready for pretty much any type of questioning that's not friendly: 4 answers to any question. Yes, no, I don't know, I don't remember. Those are your 4 answers. I don't know is riskier than I don't remember. I don't remember gives you so much plausible deniability, right? If they have the goods and you just don't remember, you can save some face. But they ask you if you said something. I don't know if I said it. It's where I really want to see the defense drill it down, nail her down. Do you deny it? Make her think about, is it possible that she would have said something like this? Because that concession in and of itself can be very telling. Because if it's something you would never say, you would never say it, you'll deny it. No, I didn't say that. I would never say that. And then you find out if they got the goods. But it gives you a lot more deniability. I don't remember, because you can't really be faulted for not remembering, right? You can be faulted for not knowing. You should know. Shouldn't you know? You reviewed your entire testimony before this. You've testified before. It's the same thing you're talking about. Shouldn't you know the answer? Shouldn't you know what you've said? Because what you've said should just be the truth every single time. But if you just don't remember, I just don't remember, gives you a little bit more of an out. She didn't take it to mean when Karen called at 5 and said John's dead and hung up, and then had that conversation about the taillight and showed her the broken taillight and said, could I have hit him? And she didn't remember any of that until 3 days later, when she tells it to Connor Keefe and Kathleen Prince. That's the first time she remembers. Oh yeah, Karen said that thing at 5 a.m. Yeah, I don't know about that. This just goes back to when you're looking at whether people are telling the truth or not, you can look at how they acted at the time. And is how they acted at the time consistent with what they said being true? I find it hard to believe that if Karen had said these things at the time and then they find John dead, that nobody is putting two and two together like right away and letting law enforcement know right away. I don't really buy the I'm in shock and horror. I don't really buy the shock and horror defense on this one. I'll give a lot of leeway to being in shock. I'll give a lot of leeway to being in shock. Selective recall is not what shock looks like. Selective recall is not what shock looks like. Shock looks kind of like, Karen running around with her head cut off, being irrational, just being unable to kind of cope with any of it. But it's not, I'll tell you some things and I just don't mention others, or I haven't remembered others. So I find it hard to believe that these pieces wouldn't have been put together, that these people would have acted the way that they did had this morning unfolded the way that she's describing it as having unfolded. Noticeably, of course, what's missing from Kerry Roberts' testimony? I hit him. Nope, she did not say that Karen said that. She's never said Karen said that. She says Kerry's running around saying, is he dead? And that at one point, or he's dead, he's fucking dead. And at one point she did the asking about, did I hit him? She does not remember the I hit him. She was there at the same time. I mean, longer than Mr. Nuttall is there doing his chest compressions, paying attention to just or his airway, paying attention to his airway, nothing else. The I hit him didn't matter, wasn't relevant. But he heard it again in the background. It was enough to catch his attention, even though it didn't matter. Kerry didn't hear it. So you got a first discrepancy there with the I hit him narrative. Last thing I guess I want to mention about Kerry is just that I think in many ways, Mr. Jackson, he kind of got lucky with her. She did try to pull the same tricks as Jen McCabe, the same maneuvering to try to buy time, to get out, to be combative. She just doesn't have the heart for it that Jen does. Jen, you get the impression she sincerely likes the combat. She likes it as much as these lawyers do. Kerry, maybe not so much. She gets worn down. And so she finally reached the point where she's going to be maneuverable. So when she's refreshed by what, asked if she's going to be refreshed by what she's seen, she's going to give it to him. You don't have to. You don't have to. No, you can say, no, I still don't remember it independently. I see it written here, but no, I don't remember it. Doesn't refresh me. And then what's Mr. Jackson going to do? Because he's not going to ask, well, do you deny it? He should. But he's not doing that at this point. He's not doing that. And that's the follow-up. Do you deny it? So I feel like he's gotten away with it because this witness is weak. He's able to skate by. But that's why he had such a hard time with Jen. Because she's not weak. Whatever else you want to say about Jen McCabe, she is not weak. She is there to fight. And she's there to win. And he really, really struggled with it. I hope he learns. By Jen McCabe. Do you deny it? Last thing I'll say about Kerry. We did establish she did not herself hear Karen say anything to Jen about Googling hypothermia or how long. It came pretty clear that was something that she heard, and given the context, not hard to infer, she heard it from Jen. So Jen is the witness to that. Whatever Kerry said at the grand jury is not corroboration of Jen. It's just repetition of Jen. Did the jury get that? I don't know. Maybe. I'm not sure if they know it's important because it didn't come up in opening. I think I said pretty much everything I want to say about Peggy O'Keefe. The clips that he played of these interviews, are people finding this damaging? Are people finding this damaging? So we got the Gretchen Voss interview. That was clip number 3. And that was, she was at John's and she picked out a few small pieces of tail light. She was worried about an electrical short. You could see the bulb. It was exposed. She showed it to Kerry. She dropped it in the driveway. So this is corroborating, in large part, Kerry's version of being shown the tail light. And there's a little bit more specifics to it. So, to that extent, I guess it's damaging. We know her taillight was broken when they went back to Meadows, and Kerry is not lying about Karen showing her the taillight. That happened. But it's not on video. It didn't happen when she thought it happened the first time, when she testified. We established from that, maybe her memory isn't great. Okay, but why does it matter? I'm just, not sure why we went down that road or why it matters. So, that's consistent with Kerry, but it's also not inconsistent with what we are already expecting from the evidence, because we were told in opening she cracked the taillight earlier that morning when she backed out into John's car. So we're already expecting the taillight to be broken. Are we still arguing about how broken it was? I think that's it. I think that's it. So she picked out a few small pieces of taillight. The bulb was showing. She was worried about an electrical short. Tends to suggest it was not merely a crack, that there was like literal pieces loose, and that certainly by the time she was, done showing it to Kerry and she picked the pieces out and left them in the driveway, now there is actual portion of the taillight missing, if not earlier. Oh, I guess the one thing I will say about Peggy, just because it stood out, was her report that when they're in the hospital and she sees Karen and she asks someone, what's she doing here? Again, remember our patterns and whatever, catty women. But, and she's told by somebody at the hospital, oh, she's being psych evaluated. Guys, every one of you who this time were like, is that a HIPAA violation? It actually is this time. It's almost always not a HIPAA violation when people think it's a HIPAA violation. Somebody who works at a hospital as a healthcare provider providing confidential healthcare information to some person in the hall, that's a HIPAA violation. Yes. Yes, it is. Doesn't mean it's not admissible in evidence. Doesn't mean it's not admissible in evidence, just means that Karen may have a grievance with the hospital if that is in fact the case, if she were to make a complaint. Any real consequence for that? Doubtful. full. And no cross, of course, no cross from Alan Jackson of Peggy. I mean, if it's not going to be targeted and direct and there to elicit very specific facts that are necessary to support your theory of the case, then you shouldn't cross any of the witnesses. You know, if they don't have anything that adds to your case, you don't have to ask them anything. But I, you know, they didn't have anything to get from Peggy if it was just going to be this kind of like needling to try to draw out inconsistencies or whatever. No, it would be a very bad call with her. Very bad call for reasons that I think are obvious. Then we had the recess and the clips. So first off, you know, the Karen's explanation about you know, why she what happened when she went back to the house, and they suspected, you know, they suspected her. She says Peggy leans over the table or leans over the counter and is like, he looks like he was hit by a car. He looks like he was hit by the car. And she assumed that they had seen her taillight. That's a good assumption, isn't it? Because her car was just sitting there parked in the driveway. It's like up there at the far end. They would have all parked behind it. They would have walked past it to get inside. Would have noticed. Right? Would have noticed the taillight if it was all busted up like we're hearing. Nobody saw it. Nobody documented it. Nobody said anything about it. Right? So I guess it wasn't that noticeable. I don't know. So she claims, Karen claims that Peggy said this in the clip. Peggy has let's look at the specific questions. It was back at the house. They asked to go upstairs. I should have never let them. Well, we don't know why. We don't know what you're getting at with that. It sounds like they're still hinting at Karen went upstairs and deleted the ring video. But of course, the jury doesn't know that at this point. They have no idea what all that is about. Just, I should have never let them go up there. Not sure why. Didn't see them go up. Could hear her there. She didn't see them come back down. She was trying to calm Patrick. He was very upset. Didn't personally interact with Karen. Didn't have hugs or condolences. Didn't confront her with any accusations that morning. So that was her kind of specific disavowal of like generally this. But he looks like he was hit by a car. Is that a specific accusation that she confronted Karen with? Not necessarily. It's the whole point, isn't it? It's this kind of indirect. Even if that is her suspicion, it's indirect. She's not saying, what's up with your tail light, Karen? Did you hit John with a car? That would be direct. So it's this kind of sideways accusation. But then he asked specifically, did you ever lean out over the island and say he looks like he got hit by a car? So when she's asked specifically, she says, no, I don't remember talking to her. I didn't see her leave. I didn't see her SUV. I don't remember. It's not, I didn't say it. It's not, I didn't say it. Now, the defense doesn't really care because they don't care about this clip. They don't think that this clip is particularly damaging. I found Mr. Brennan's argument that this is clear consciousness of guilt to take the murder vehicle, the murder weapon. He didn't say the murder vehicle. He said the murder weapon away from the scene. It's her car, dude. It's her car. At what point would it not be consciousness of guilt for her to, I don't know, go and recover and drive her own car? But he wants to make the argument. He can, I guess he can make the argument. It's just not a particularly good one, I don't think. I'm on the jury, that is not persuasive to me. Of course she came and got her car. Is she staying there? No, she's not staying there. It's not her house. I would expect her to need her car. But the clip 5 is the one that they objected to, and that's where she says that is the one. That is the one where she says John's mom leans over and looks at me and says, "It looks like he got hit by a car. It looks like he got hit by a car." And it's gonna come in, guys. She's gonna let it in. I mean, not just because this is Judge Bev, but they don't have a good opposition to this. They don't have a good opposition to it. He's trying to say it's more prejudicial than probative. She's not going to find that. If Karen were testifying, they'd have an opportunity to observe her demeanor and the manner in which she delivers it. Not sure that it's unduly prejudicial for them to see her demeanor in the course of telling this in an interview. I don't know that that's unfairly prejudicial. He tried to say that it's purporting to impeach Mrs. O'Keefe, and you can impeach your own witness in Massachusetts. Yes, you can. Yes, you can. I read you guys the statute. You can't call them solely to impeach your own witness, but they got other information from her. They did not call her solely to impeach their own witness. That is a very low bar to clear. So, yeah. Hank points out it's not to impeach her. It's her own statement. It's admissible as a statement of party opponent. It is. It is. The fact that they have the transcript, fine, but they don't have to put in the transcript. They're entitled to put in the video. I don't think this was a good opposition. So I think that one is going to come in. But that whole "do you want the consciousness of guilt" instruction? Oh, guys, I was going to try to find it. Like, here's the one from district court. I don't know if it's the same, but I'm going to read it to you guys. You can see why. I don't know if I would honestly ever ask for this instruction. Consciousness of guilt. You have heard evidence suggesting that the defendant outline the nature of the evidence, so they have different options. Let's see. May have intentionally tried to conceal, destroy, falsify evidence in this case, right? That's what he's getting at with the taking away the car, the murder car. If the Commonwealth has proved that the defendant did this action, you may consider whether such actions indicate feelings of guilt by the defendant and whether in turn such feelings of guilt may tend to show guilt on this charge. You are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of the case. If you decide such inferences are reasonable, it will be up to you to decide how much importance to give them. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. Why don't I like this? I don't like you calling attention to it like right after it's been played and reading this instruction to highlight that this is kind of different and special than everything else you're hearing, because you're not getting an instruction about everything else you're hearing. You're getting an instruction about this thing. So this thing stands out. And why does it stand out? I'm not entirely sure, because there's a lot of words here and it's lengthy and it's hard to follow. But what I hear a lot is feelings of guilt. I hear feelings of guilt over and over and over again. And I might just form that association if I don't take away anything else from this whole process. I just might make that association between this video and feelings of guilt. And that's my takeaway. I don't know that I would ever want this instruction. Oh, and by the way, you may consider whether it makes the defendant guilty. You may. You can decide how much weight to get them. Now, be cautious, but you may consider it in your deliberations if you're considering whether the person is guilty. I do not like that instruction one bit. Do not blame them for saying no, thank you. I don't think I would ever want it. Maybe at the end of the case. But I realize my banner is still going there. But not right now after you've read the evidence. Finally, Nicholas Gorino. Yes, Nicholas Gorino, he of the 30,000 overlooked text messages between Sandra Birchmore and Matthew Farwell, who is now being federally prosecuted for murdering her. That Nicholas Gorino. So, little bit of foundational stuff in here that Mr. Alessi is going to be doing the cross on this, but it's going to wait until he's recalled, and that's going to be, sometime after the defense has been able to make their objections, if any, to his newly discovered, stuff. Since we have different rules when it comes to late production. But there's some foundation here about his training. Okay, this is going to be, from my perspective, important for them to follow up on. Why? Because they're expert on training and what's required, how to investigate cases and so forth, has been excluded. And it's been excluded because Judge Bev said you can get all that through cross. If they did a bad job, you can get all that through cross. So that really puts a burden on them to establish what they can or cannot get done just with cross-examination. They got to kind of make their record of what they're able to get from these people about. How are you trained? What are you trained? You're trained at this level. You're trained again at this other level. So they got multiple academies, is what I heard from Trooper Gorino. He went to the police academy, learned how to conduct investigations, respond to calls, learned about laws and procedures, how to conduct investigations. I'd be following up on that. What did you learn? You had to go to the state police academy also for 6 months. So then once he transferred from Norwood, which they say like Nord. It reminds me of England a little bit, how things go quiet. Nord police over to MSP. Then he had to go to the state police academy for 6 months. I'd be following up on that. Definitely following up on what you learned at the state police academy, because our main investigators here are state police officers. And those are the ones we really have the biggest criticisms of. No, they're not the solo cup leaf blower guys. But they're the no chain of custody, no recorded interviews, 46 pieces of tail light, putting it in the same bag with the clothing from the hospital. Those guys. They're those guys. The interview everybody over at Jen McCabe's house. Yeah, those guys. You want to get into some of that to lay your foundation about what exactly are you guys trained, so that number one, maybe you can. Maybe Judge Cannoni is right and they'll be able to get every single deficiency that happened in this investigation. They'll be able to elicit that it's improper from these witnesses and it's not how they're trained to do it and it's contrary to their policy. Maybe they will. I'm a little skeptical though. And so the important thing is to have the record that you tried and they don't know, or they won't give it to you. They don't remember what they were trained. They're not sure what the policy is. They're not sure if there even is a policy. That's your record then to go back at the close of their case, say, here's all the things that they weren't able to do through cross. Couldn't establish it. This guy can. We want to call him. That I think is going to be important. So you know, some of this preliminary explanation about how you do the extraction and how you make sure that it hasn't been altered, how you authenticate it. That's a little bit of a preview because don't we know they didn't give all that to the defense? They just gave them the PDF. Didn't we learn something like that? But the other piece of this too is that the extraction is only good, you know, even if let's say they hash it, it's valid. This is a good extraction. It hasn't been authenticated. It doesn't mean they didn't alter the phone before the extraction. We have some alarm bells. We have some alarm bells with Trooper Gorino's testimony because according to him, he was provided with Karen Reed's phone on January the 29th by Proctor and Buchanan, but they had to wait until July of 2022 until they got the software so that they could brute force the phone. Ask him directly, Mr. Alessi, on cross-examination, are you saying you didn't have the passcode? Because, let me just go to my notes from the last trial. Both Trooper Proctor and Trooper Buchanan testified they got her passcode. They sat there and they watched her enter it while she was looking for contact information for Michael Camerano. They watched it and then confirmed it was hers, according to Trooper Proctor. They had the passcode. They had the passcode. Why didn't he have the passcode? Why didn't he have it? I'd like to know. I'd like to know. Kind of the same issue with John's phone. You know, the John's phone in the chain of custody, big mystery. Don't know who had it to give it to Proctor. He being Gorino, got the passcode for John's phone on the 31st. From who? I would definitely want to know that. Who'd he get it from? Who'd he contact looking for it? How did this communication take place? I'd like to know that because I'd like to know if it's somebody that we can put in contact with Trooper Proctor before January the 31st. So by and large, this is mostly foundational stuff that I think he's kind of holding off. You know, he's obviously not going through the details of this right now, but he's also kind of dropping this preliminary stuff now before Gorino is going to get crossed on it. Because if I remember correctly, I'm not 100% sure, but what the defense was provided was the UFED report, the Celebrate report. And that's not the thing that hashes. I mean, it, you know, probably has its own hash, but that's not what you're worried about them changing. It's the original extraction. But I could be wrong about that. That's just kind of what I have in the back of my mind. But either way, clearly laying some foundation there as far as the security, and they want us to infer, you know, it's easily verifiable. It's locked up. You'd be able to tell if it had been changed. We'll find out on cross if that is the case or not. And then finally, last witness here, Mr. Whitley, firefighter paramedic who ITA'd Karen, sectioned her. I mean, what else to say about it? She was upset. He was a little, also, I think so far I've gotten an impression, maybe not so much Gorino because we haven't seen everything with him and we haven't seen his cross yet. I think that's kind of important. Peggy, of course, didn't have a cross. Kerry, it's hard to gauge because she didn't get crossed in the first trial. But so far, the witnesses who have been crossed, it seems like their demeanor is a little different this time than it was last time. A little bit more closed off, a little bit more combative, a little bit less giving. I'm gonna negotiate with you around the edges of things to the point where Mr. Yannetti is going to have to pull out that ace in the hole. That would be crazy, wouldn't it? I did like that. Yes, it would be crazy. It would be crazy. When you can kind of have everybody on the same page about where you need to be standing with your answer, that's a good place to be. But he gave that very vague answer about property. She get property from anyone. At one point, he had to exchange a purse or a cell phone or some object from Ms. Reed. He's talking about any property from Kerry. I want to clarify that about that cell phone because I want to know, was that John O'Keefe's cell phone? I want to know for sure. You're the guy who's saying it was you, so I can ask you about how and when it got to Proctor. And if it wasn't you, then I know I need to keep asking everybody else. The comment about Kerry Roberts, anybody who knew Kerry Roberts wouldn't say that about her being part of the support system. Women being catty to each other, maybe a little bit of a pattern around John. Maybe a little bit of a pattern. We don't necessarily have the sympathy for that statement as well that we have last time because we didn't get the babysitter with benefits comment. We didn't get that elicited from Kerry. So we don't know. That's what she actually thinks of Karen. The jury doesn't know that. That's how she talks about Karen behind her back. When you know that Kerry talks about Karen behind her back like that, does it make it more understandable why Karen might say, yeah, if you really knew this woman, you wouldn't be saying she's a support system for me? Yeah, I think that makes it clearer. But it didn't come out. And I'm not sure it can come out through Jen, unless Jen sort of volunteers it, vomits it up like she did last time, because it is hearsay. It's hearsay. They didn't lay the foundation to impeach Kerry with it. So it's Kerry's out of court statement. I don't think it's coming in. Might be a missed opportunity, but might not. I don't know. I don't know from opening how important that is or isn't. So to me, women being catty with each other is really not the end of the world. And it definitely doesn't tell me that somebody hit somebody else with a car or not. But, like I keep saying, that same thing can be said about a lot of what the defense is doing here with these crosses today. I know I may not have the majority opinion, but I don't see them as necessary. Really don't see them as necessary. And frankly, if I'm being totally honest, to me, they question witnesses like prosecutors. I know they've both been prosecutors. They both started as prosecutors. Pretty sure Mr. Yannetti was a U.S. attorney. Wasn't he in the U.S. Attorney's office? He was a federal prosecutor for a little bit. And Alan Jackson, of course, over in California, prosecuted Phil Spector. To me, they question witnesses like they are prosecutors. And the reason why is because Hank Brennan has been giving us this great demonstration of the kind of joke that defense lawyers have about how prosecutors, how easy it is to ask questions as a prosecutor. Because all you have to ask is, and then what happened? And then what happened? That's your open question. And you get to do that. And it's very easy because by and large, all your witnesses are friendly. They're all on the same side. You're calling cops. If prosecutors have a more hostile witness, it can be harder for them to deal with because they're just not so used to dealing with that. That's all defense attorneys deal with. There's people who don't like them, don't want to answer their questions. And so I think that's just part of why generally in defense, you develop a more targeted strategy. You learn not to give them more opportunities to fight back because they want to. They want to fight back at you. They want to defend themselves. They know you're there to disagree with them or discredit them or just, whatever. To say that they're not credible, not reliable. And people tend to resent that. People tend to have a high opinion of themselves. And so they don't want to just give in to that characterization. So you always know they're going to be fighting back, and you learn. You can't give them openings. And the fewer questions you ask, the fewer openings you give them. And so, pretty much every defense lawyer has learned about not asking the one question too many. You've learned it the hard way. You took it too far. Real common place where that happens. People can just destroy their own work with their questioning by taking it one step too far. You're there to get the facts from the witness, whatever it is you can get from this witness. You're not there to characterize the facts. That is what your argument is for. That's what your argument is for. I'll give you an example of what I'm talking about when, because Mr. Yannetti kind of did this. He got away with it because it wasn't really that important and it doesn't really hurt him, but it's just a bad habit I don't like seeing. He established this guy lives on the same neighborhood as Kerry Roberts, still lives there after years, went to high school with Michael Proctor. People know each other in Canton. They work in conjunction with police officers all the time, knows many other Canton Police Department officers. You have established everything that you need to establish for the jury to take the next step. Oh, this kind of looks like an insider's club. But when you move and you try to characterize it, so kind of what you're saying then is that she was an outsider to Canton. No, he's going to resist your characterization. They always are. They're going to resist your characterization. Then they're going to argue with you about what you should have just argued to the jury. Because the jury can reach that conclusion for themselves if they think that's reasonable based on your facts. But now you've given this guy an opportunity to explain and talk around. It's not necessary. And so this is an example of that happening in a situation where it didn't necessarily matter. But there are situations where it matters. Asked him way too many times about the snarkiness. He made the point the first time. You could have done it all in one question. You wrote this report, you wrote this other report, you spoke to the person on this occasion, and in none of those, you didn't mention the snarkiness in any of those. Would have gotten it across, but you asked him over and over and over again, and he's had time. Every time you asked him that question, he's had time to sit and think about it and be like, well, I mean, no, I didn't put it in because I wouldn't put that in. It's not the type of thing I'd put in a report. He's had time to adjust and to come up with his explanation because, yeah, he's going to defend himself. You're implying he did something wrong. You're implying that, he can't be believed. He's making it up after the fact. There's all these possible bad inferences that can be raised about him based on what you're saying. And he knows that just by virtue of who you are and your configuration in this courtroom. He knows you're not his friend and you're not asking these things because you want him to look really good. So you're just giving him too many opportunities to be able to resist that and to be able to come up with an excuse and fight back. And now the jury, instead of just hearing, he didn't put any of that in his report. And we can think about whether that's important enough for a while. Does that matter? Is that something you would have put in? Does that affect his credibility? And then you can argue it in your closing and you can try to persuade them. Yeah, Yeah, all these opportunities he had to describe what would happen. You want to be thorough in your reports. Never mentioned any of that. You've given them the opportunity right off the bat to say, oh, well, maybe I'll just discount it because he wouldn't put it in. It's not appropriate. He says it wouldn't be appropriate to put that in. You can ask too many questions. Prosecutors generally get to ask lots of questions because the witnesses are friendly to them. They have a little bit more leeway to explore. Most of the witnesses in a case are prosecution witnesses. So the defense is used to having to be cautious. And when you have to be cautious, you just learn to do what's necessary. Get in, get your work done, and get out. You don't need to be in there. Oh, as they say in the ring, you admire your work, you land a really good one. And then you're like so impressed with yourself that you like stay right there. And in the meantime, you just got encountered. You can't sit and admire your work. You got to get in, get the hell out. It's dangerous in there. It's very dangerous. Anytime the witness is speaking, you want to have as much control over what is coming out of their mouth as possible. That's why you don't ask a question you don't know the answer to. That's why preferably you don't ask them anything that you can't substantiate with something else. You don't ask them anything that you don't have a backup plan for how to get it in if they don't give it to you. Something you can impeach them with, something you can bring in through another witness. Because it's dangerous in there. Every time they talk, they can make something up and it can blow up in your face. I feel like they question like prosecutors, guys. Not necessarily an awful thing, but just not sure that it really gets them where they need to be. And I'm not sure that it's worth the risk that they take by asking the extra questions. Are they getting such a valuable payoff here in exchange for that risk? If I'm going to take a risk, it better be very high reward. Better be very high reward. Just my thoughts about that, guys. We got a lot of questions to get through. Holy cow. Let's get to it. Track worker. HB is de facto defense attorney for 34 Fairview crew. It's very similar to trial one so far in that respect, isn't it? The kind of pre-defending the folks in the house, the policing the third party culprit, trying to turn everything into a third party culprit. Anything that's about like these people acted really sus is trying to, be transformed into a third party culprit accusation, which it's not. It is a foundation for a third party culprit defense. But yeah, it's pretty similar. The rural juror, I love Jeff's sarcasm in the comments. I love Jeff's sarcasm too. It's one of the things that we have in common. We speak the same language. R&M Productions, good to see you, girl. Y'all are on a hike with me at the moment. I'm jealous. And the only way I can stomach honk Brennan and witness histrionics in the morning is with Andrea's Zen in my earbuds. Well, I'm glad to hear that. It is my goal to just try to bring a little calm to this. There's enough hysteria elsewhere. There's enough excitement and anxiety and that high adrenaline, high cortisol kind of stuff going on. I'm trying to give us a little bit more of a break from that. Things are going to unfold how they're going to unfold. And our power here is very limited. We have very limited ability to change what is going to go down in that courtroom over there in Dedham. What we can do is we can watch and try to understand, and that might help us predict and prepare. I appreciate you being with us this morning, and thank you for taking us on your hike. I do love a good hike, so Maybe you'll share some pictures with me sometime. Tara Rayner, either Karen knew where he was or she was so drunk the night before that Jen had to tell her where Jen wanted her to be. Salem witches in Karen's ear. It is kind of hard to have this both ways, isn't it? She's so drunk that she doesn't remember, or they had to tell her, or she's so, is she so stressed she doesn't remember? She remembers the waterfall and not quite clear what happened after that. We know the text messages were very angry. I don't know. I don't think that we necessarily know enough at this point. And it's hard to know what, if anything, we can even get from Karen about that, because it's, what she said in that interview, I didn't think was, to me personally, just kind of, we talked about memory science this morning. I understand completely what she's getting at. Like, it's hard for me to distinguish between what I've been told and what I remember and what I've seen. And I don't know what's real and what I've incorporated. Like, that to me is it's a very insightful thing to say. Much more so than these, witnesses who are like, yes, I have very vivid memories of this thing that, that never happened 3 years after the fact. And by the way, the fact that it's different from my prior testimony doesn't alarm me at all. That is very uninsightful. Karen's description in that clip, I thought was very insightful. Like, yeah, I can imagine that would be really difficult. I can think back about things like that in my own life where you just wonder, do I have a real memory of that? Was I told something about that? Famous example of this. We talked about Dr. Loftus this morning. Dr. Loftus has a very famous personal example of this, because when she was young, I don't remember exactly how young. I don't remember if she was like a teenager or if it was younger than that, but she was quite young. Her mother died, and she has a story where years later, like she's in her 50s or something like that, her uncle says something to her about, you remember you were the one that found your mother when she was dead. And she hadn't remembered that, but this flood of memories then came back about her finding her deceased mother. A couple days later, the uncle's like, oh, my bad, I totally made a mistake. It wasn't you at all. It was your aunt. Vivid memories that came flooding back, and none of them were true. None of them were true. So, yeah, that kind of thing can happen. And I can imagine it would be very difficult for Karen at this point to distinguish between what do I even remember and what have I just filled in after the fact? What do I know because there's objective evidence that tells me that? Or what do I know because I have a memory? Is my memory reliable or not? I would just expect that to be extremely challenging to navigate. Susan C. with a gift of 5 memberships. Thank you so much, Susan. And thank you on behalf of everybody who got one of those. Ellie B. from Tennessee. Wasn't it John's phone in back of the car whose voicemail picked up the 911 call Jen made, or am I crazy? It was Karen's phone, is my understanding. Karen left her own phone because she had been making a phone call. I don't remember if it was her parents or who it was, but it went to voicemail. Maybe she was calling. Was she calling John and it went to voicemail on John's phone? It was something like that. I forget exactly, but it was open. It was her phone that had the line open that picked up the conversation as it was happening. Pretty sure it got caught on somebody's voicemail. So it might have been John's voicemail. Hypnotizes lobsters. Jen had it and smuggled it upstairs at McAlbert's, in my opinion. Possible theory. I'm going to be interested to see what that temperature data is and whether and to what extent it supports any particular theory about what happened with the telephone. I don't know. Jonathan Dean, I do not like the fact that the defense cannot see the prosecution while this witness is being cross-examined. She is glancing over at Brennan. I don't really care for the layout of this courtroom either. I don't like how it kind of gives a sense of importance that the prosecution sits right in front of the witness and then the defense is back there in the back. You know, there's just kind of associations with that I feel are natural, and like, no, nobody is going to overtly sit there in the jury box and be like, oh, those defense people sitting in the back, they think they're so cool. Nobody's like deliberately doing that. But you have those kinds of associations and stuff, and you just kind of naturally, maybe make them sometimes. It's fairly normal to not be able to see the prosecutor's face while you're doing your cross-examination, because even if they're sitting over to the side of you, you're not looking at them. You're looking at the witness. So the fact that they can see her, and if she's making faces, if she's mouthing things, if she's acknowledging, whatever, they're going to be able to see it on her. If the prosecution was like feeding her something or like winking or, making a secret hand signal or something like that, I'm honestly, they're probably in a better position to see something like that where they are than way over on the side. Maybe not so much a facial expression, but like a gesture or something. Probably in a better position to see it where they are than over on the side. But no, I don't like the configuration of the courtroom for other reasons. I don't like how they're stacked. It just to me it kind of necessarily implies that there's an order of importance, and that is not the case. Not That Susan is a YouTube member now. Welcome, Not That Susan. Samantha Teresa, why does Bev have a problem with Cross on Kerry? She's trying to, I think, cover that by talking about how it's her job to make sure things are efficiently and move forward, and I want to move things forward expeditiously. Talking about, rules for one side and rules, not rules for the other side. If you didn't endure trial 1 and the Lally repetition, how many times we had to hear the same irrelevant stuff over and over and over again about the Canton Fire Department having to shovel the apron and the basketball game that Jen McCabe and John had gone to the night before, and the fact that there was a band at the waterfall and that they sat at a high top table, not in a booth. We had to hear all of this from like 10 witnesses. Okay, it took forever. It was nonsense. It was insane. And she put not a single restriction of any kind on any of that. But when it comes to Cross, we got to move it along. Are we about done here? With Kerry and with Cross, she's not telling us her reasoning, of course. So we don't know. We're supposed to know already, right? Because we're supposed to read her mind and understand what the problem is. My suspicion is, if I were guessing, is she thinks they're badgering. And that's if you're hitting on the same thing over and over again and not letting it go. Sometimes you're not getting what you want, but sometimes you're not going to get it. You got to know kind of when to quit. Difference between you don't like the answer and you haven't gotten one, So I kind of suspect that's what she is looking for. That's what she's kind of attuned to, is like, are they crossing the line into badgering the witness? Because if they are, then I can cut them off. Like it's not useful anymore at this point. They're just being harassing. Wonder if we'll see the same thing with the Commonwealth on Cross. What do you think? Edward Kirkpatrick, this breaks the sequestration order, doesn't it? She was still under oath on the stand. She should not be talking to other witnesses like Jen. They are not supposed to be talking about their testimony or about what is going on in the courtroom. So, for example, if Kerry, got off the stand today and goes home tonight and calls Jen McCabe and tells her what happened, that's a violation of the sequestration order. But that's why she's very specific that, oh no, we didn't talk about the case. She just wished me luck. She just wished me luck. And they didn't follow up on that any further. So that would be a short phone call, right? If I were going to follow up on that, she was just there to wish you luck. That would be a short phone call, right? That takes, hi, Kerry, I just wanted to wish you luck today. Oh, thank you so much. Took about 4 seconds. Was your phone call 4 seconds? Was it longer? Oh, it was longer. So you said things besides good luck. What did you say besides good luck? And that's how I would follow up on it if I were going to follow up on it. But, the answer that she gave is not a violation of the sequestration order. They're not allowed to not have contact with each other. Some of these people are married. They're going to have contact with each other. They're just not allowed to talk about the case or about their testimony. McRae H. Would AJ get in trouble for referencing Proctor as former Trooper Proctor every time he mentions him? No, I don't believe he would. And in fact, Mr. Yannetti referred to him as former Trooper Proctor just this afternoon in talking to Mr. Whitley, former Trooper Proctor. It's accurate. There's nothing objectionable about it that I know of. It's not like unfairly characterizing him. It's putting it in context of who he is, and particularly in the context of this case. He's the guy that was the lead investigator, but now he's fired from the MSP because of how he behaved in this case. So he's a former trooper now. No, I don't think he would get in trouble. Track worker. She's a TACA, unless it's the morning of trial. Yeah. It's more like TACA, right? I went a little Long Island with that. She's a TACA. I'm not so good at my East Coast accents. I probably made an ass out of myself last year trying to get these. I'm not very good at accents in general, but East Coast, I don't have an ear for all of the nuance. But I do understand that boss. It's a wide thing. It's that she's a TACA. I don't know. Yeah, unless it's the morning in trial, then it's just good luck, and she didn't have anything to say at all. What did you say back, Kerry? Don't know. We'll never know unless we get trial 3, and then they ask, but didn't ask this time. James Casatelli, I don't see this being effective with the jury, though. He's putting too much on the table. How are they supposed to know what's important? How is he sure they're still paying attention? This is my complaint. This is my complaint with the, extended cross, is we don't know what the point is. We don't know what the point is. We don't know what we're supposed to take away. Let me give you an example, because I had kind of, keep little notes of my takeaways and stuff like that. And I started noticing, this issue yesterday with how they do cross, and how I really would like things more tailored, more direct, more tied into your opening statement. That's just how you keep your case and your theory cohesive, and you keep the jury with you all the time. Because they know where you're at. They remember it from opening. They can relate it all back together. It all makes sense. And so I just made little notes about, like, if I were the attorney on this case, yes, I realize very easy for me to sit here not being the attorney on the case and talk about something like that. But just if I were going to cross-examine Timothy Nuttall, right? If I were going to do that cross of Timothy Nuttall, what would I do and how would I do it? And the answer is really this. You need to know going in, what is the point? What is the point of why I'm talking to this guy? What do I need to establish from him? And so with Timothy Nuttall, the main thing he's coming in there to testify about is I hit him, I hit him, I hit him. Right? So first off, my question is, do I care that he said that? Is this something that matters? Do I need to address it? Let's say I decide I need to address it. It's important to the theory of the case because we need to undermine that Karen, if she even made any admissions, are truthful, or because I need to emphasize that there was too much opportunity in this case for confabulation, people having tainted memories, tainted recollections, whatever, possibly combined with some deliberate revisionism, right? Some deliberate lies. So I need to address it because I don't want the jury thinking she did in fact say I hit him, I hit him, I hit him. I want them thinking this is not true. So now I need to have a theory. Why does Mr. Nuttall think this? What's my theory for why Mr. Nuttall thinks this? My personal theory that I'm going to use, he's confabulating. He may not be the only one. He's confabulating. He really truly believes that this happened, that he heard it, but he didn't. And so the reason why you know it didn't is because here's my proof that this is confabulation. Nobody said it at the time. Nobody said this. It took time for it to come out. That's a red flag. That's a red flag. Opportunity exists for there to be confabulation. Nobody acted at the time like it was said. We talked about this as far as the consistency. Okay, if this had been said at the time, would the people have acted exactly the way that they did? I would say no. You would not have just let Karen be driven away by Kerry at the scene to come back, to be taken to the hospital and evaluated and then released from there, and then go back to John's and pick up her car and go to Dayton. If she had made confessions that morning that people had understood as confessions, they would not have acted that way. And now this particular guy, he said it doesn't matter. It didn't matter to him. But this is a guy in his own mind. He's there to help, right? He's there to help. That's part of why he's so anxious there on the stand. Like, I'm just there to help. Why is everybody going to hate me? He's just there to help. And so he wants to do the best job he can. And he wants to know what's going to help this patient. Well, wouldn't it help this patient to know the cause of his injury, how he ended up here? Wouldn't that be helpful to help him rule out some problems or maybe put some other ones on the table that would need to be evaluated? Of course it would be helpful. If he thinks the guy's been in a car accident versus he thinks the guy just, passed out drunk out in the snow, you're going to be looking for different things. So nobody said it at the time. And then finally, the stories, they don't add up with the other evidence. They don't add up. When they tell the story about when this happened and you go back and you look at the video, they don't line up. The memories don't line up with what you can see on video. So this is my general support for the theory that these witnesses are confabulating. So any witness I think is confabulating, these are the points I'm going to want to hit on with them to be able to establish that. Nobody said it at the time. Nobody acted like it at the time. And it isn't consistent with the other evidence that we've seen. That's how we know it's a confabulation. So applying that to Mr. Nuttall, what am I doing in my cross-examination with Mr. Nuttall? I am establishing, you didn't say this ever until February 8th with Proctor. That was the first time I hit him, came out of your mouth. If it's really important to me to demonstrate to the jury how confabulation works, then I would get into, you told him, the version that you told at the time is not the same. It's not the same version that you're telling now. You gave a different version back then because you told him that she said it to another woman at the scene and that woman told her to shut up. Now you're saying she said it directly to you in response to a question to you. That's different. So the memory has evolved. I might show that. And then I'm going to elicit from him, if this had been true, it would have been important to your treatment. If he had been hit by a car, he could have internal injuries. That could be something that would be important if you are giving CPR and you know he's got an injury that's going to, potentially flatline him, even if you can get him resuscitated. You would need and want to know that. You want that patient to be in the best position possible to be able to recover from something like that. Remember, Princess Diana died in a car accident, torn aorta. She was conscious. She was conscious for a little bit before she died. Just, sad and horrifying. But bled out internally. Might be a good thing to know. Might be a good thing to know if somebody's been in a car accident. They can have very severe internal injuries, and you would need to address that and be prepared for it, because even if you can get this guy resuscitated, he's got a tear in his aorta. He ain't going to be around for long. So that's what I would have elicited from Nuttall. How you, being the hero of your story here, would have acted differently if you knew John had been hit by a car. And just the fact you didn't say it. You didn't say it until later. And by the way, it doesn't add up with the video. Your account of when it happened doesn't correspond with what the video shows. Your memory does not line up with what we can see happening. Maybe she did tell it to you at that earlier point when you guys came up to the body, but that's not when Mr. Flamati was down there doing the chest compressions. So your memory that it happened when Flamati is doing the chest compressions is wrong. That's all I'm establishing from him. That's all I need. Those are the facts. And then I get to go to the jury and I get to argue, jury, when somebody's confabulating, here are some ways that you know. You know because they didn't say it at the time. You know because they didn't act like that was the case at the time. And you know because it doesn't line up with the evidence. Now let's talk about the people who confabulated. Here's why Mr. Nuttall confabulated. Here's how you can see. He didn't say it initially at the time. He didn't say it until Trooper Proctor on February the 8th. He didn't act in a way that's consistent with it being said at the time because it would have mattered. It would have been important information for him to know to follow up for his treatment. And nobody around him followed up on it either. Nobody around him acted like somebody had just made an admission of, something incriminating as far as how he ended up there. So nobody behaved like it. And, your story evolved. Story evolved over time. Doesn't line up with what we can objectively see because true stories will stay the same. If it's the truth, it stays the same and it's consistent with what we can see. But your story has changed multiple times, and your recollection of it is not corroborated by what we can see on the video. That's how we know that Mr. Nuttall confabulated. I hit him. That's how I'm approaching the case if I'm the lawyer. It's just kind of a quick and dirty example, but you don't need to run around and do a lot of extraneous stuff. The more you do, the riskier it is. What's that one? Jules Buddha. I already know what the troopers are going to testify about. They didn't ask the witnesses not to talk to each other. Either is going to be in trauma themselves, or they believe the witnesses would need support to go through the trauma. I feel like I have a vague memory that they asked about this at the last trial, and they just kind of said it wasn't important. I could be wrong about that. Or just the whole it depends. It depends. You just case by case. Gorino is already giving himself all that wiggle room with there's no real protocol. You just take it case by case. I would nail him down on that for sure, because there should 100% absolutely be a protocol for what you do with a cell phone that is brought to you to extract. You should have a standard procedure for how you handle that. And then if you deviate from that procedure in any way, you should document it. And so that's all those things like you shouldn't get into the phone. You shouldn't power off the phone. You shouldn't put the phone in airplane mode. You should keep the phone charged and secured until the point where you can get it plugged into the extraction. You should do the extraction, immediately. You should do the most comprehensive extraction that you are allowed to at the time. Here's what you should do with everything after the fact. You should absolutely have a protocol, because if you don't have a protocol and you're like, well, we don't really, and so sometimes maybe I'll get into the phone and thumb through it and see if there's nudes in it before we do the extraction. Well, yes, that can alter the phone. It's obviously picking up new data. It's recording your activity. It's no longer in the condition that it was in when you took it for evidence. So there should absolutely be a standard protocol for things like that. But he's given us that preview, right? And I think that's what we're going to get. Just the wiggle room. It depends. Just depends on the individual investigation. Sometimes it makes sense. Sometimes it doesn't. And they're in a position right now. The defense is in a position right now. They don't have the ability to call in their own expert to say that's a bunch of shit. There are certain things that should always be the rule in all circumstances. Like witnesses should be separated before you get their statements. You should interview them separately. You should not interview them in front of each other. You should not have people that know them doing the interviews. You should have, unacquainted, not friends, not the old family friend, Michael Lank, going into the Albert's house to do that interview. You should not have that happening. You should log things into evidence as soon as you get them and take them back to the police station or wherever your evidence storage place is. Yeah, there should be procedures for all of this. But that's what I'm anticipating. They're going to say, well, it just depends. You can't always. And so sometimes, it just depends on the needs of the case. And the defense needs to be prepared to make that foundation for why they're full of shit and why they need to be able to present the expert to show, no, in fact, the training that they get at the Massachusetts State Police Academy tells them you need to secure the evidence immediately and log it in. Like this is a basic thing that they're taught. So they need to be prepared for that. Because I think it's going to be, it depends. And yeah, I wouldn't be surprised at all if, I don't think it'll be their own trauma, mainly because these are tough guys. I don't think they're going to lean into their own, we were traumatized by it, so we did a bad investigation. No, but I do think that they'll make themselves the hero. These people needed each other. They needed each other. So You know, you had the best intentions. They needed to comfort each other. They needed to deal with their trauma together. I think that one is very, very plausible. I could see that happening. But by and large, I think it's just going to be well, it depends. It depends on the investigation. Nick Starrow. Hey, Nick. I feel kind of sorry for Kerry. She thinks Jen is her friend, that she is not someone Jen uses to say things that never happened to save Jen's own skin. Does she think Jen's her friend? I don't know. I kind of always wonder. Remember the pattern here? Remember the pattern? Similar people around John, catty women around John. Do they ever like really trust each other, really like each other? I don't know. See, I don't relate to women like this, guys. But I don't know. I'm not somebody that has like the big crew of girlfriends, with a lot of gossip and things like that. It's just not me. I got a small circle. So when I've got girls in my circle, I absolutely do. You guys know the fabulous Heidi Elkington is like my number one girl. I got her back no matter what. I would not be gossiping about Heidi behind her back. She's like the coolest person I know. And I'm going to like tell everybody how awesome she is. That's what being friends is. So I'm always kind of a little suspicious when I see these types of relationships, just because it's hard for me to relate to. I don't relate to this kind of two-faced style of female friendship. It does. I'm aware that it's out there. It's just hard for me to relate to that, because that's not how I personally relate to other women. But so it makes me wonder, does she really think Jen is her friend? Or is this just kind of a, it's mutually convenient. We get things from each other, but I don't necessarily trust her. I don't know. I think if she does trust Jen, that is probably a big mistake, because we already saw from the last trial, Jen will throw you under the bus. Jen will throw you under. She'll talk shit about you. She'll talk about what a gossip you are, and how that comment about the babysitter with benefits. You said that bitchy thing about Karen. She outed that. So that's something your friend would do. I don't know that my friend would do something like that. Say something about me that makes me look real bad. I don't know. If she does think Jen is her friend, then I think that's probably some bad judgment on her part. 4 knots to nowhere. How is it allowed to play random clips between witnesses? Well, they're offering them as Karen's statements, statements of a party opponent. So they're an exception to the hearsay rule. There's a million challenges. I mean, not a million. I'm being, facetious. There's a lot of challenges that I could contemplate being made for this process. It is just kind of out of the blue. There's no sponsoring witness. Part of the reason why you have a sponsoring witness when you're presenting, like if you wanted to present this the technically correct way, what you would do is you would call in the person who either, made this video or collected this video or something, somebody who just has knowledge of what it is. And they would identify it and say, yes, this is the video that I collected from Dateline producers on this date, and it's correct. And then you would play it. So they would be able to get it in through some type of witness that would sponsor it. And what those things are usually getting at is authentication. How do we know what this thing is? The issue that I have with playing these clips of the interviews, where I can kind of contemplate maybe there are potential challenges to this, is that interviews are edited. What you get on a Dateline documentary, it's edited. And so I don't know what the source of this information is. I don't know if this is coming from the raw video. I don't know if this is coming from, the final one that was produced. But if it's edited, it's not necessarily in context and it's not necessarily accurate. So I'm going to want to be pretty confident that this is not misleading the way it's being presented like this. That's a little bit more foundational than authentic. It's just foundational because it needs to be a fair and accurate depiction of what she said. And if she actually said something bigger and this was edited to put things together in a way that's communicates a different message, that's a problem. It's not accurate. It's not an accurate statement. So I would hope and assume the defense has had all these, the defense has gone through all these. We are seeing when they have an objection to something about it, they're raising it. They're not raising these particular objections, so maybe that's not a problem. They aren't also raising a rule of completeness issues, right? Rule of completeness. It's the exception to you being able to admit your own testimony, your own out-of-court testimony. It's not hearsay when they do it. It's hearsay when you do it, though. The exception is the rule of completeness. If more of the statement needs to be introduced to give the jury a fair impression, fair context for the part the Commonwealth wants to put in, then it can come in. They're not raising that so far, so don't seem to be arguing it's out of context or misleading for that reason. But that's the bottom line for why they're allowed to do it. It's a statement of a party opponent. The defense, I suppose, could be raising a stink about you need to bring in a sponsoring witness. That's not going to make them friends with the judge. Do they have a basis for an argument that this is not authentic? I kind of doubt it, or they'd be making it. So that's why they're doing it. Lauren Boborin, I feel like combative works in Massachusetts. They fight. Well, maybe it does. I mean, you could be totally right. You could be right that I don't have a good read on the culture over there. I don't. Like I said, I've been to Massachusetts one time, Boston for like 4 days, maybe. And most of the time when I was there, it was over on the west side of the state near Williams College. Kind of a different climate, different environment in general. But I didn't really get a sense of that whole mass hole culture I hear about. I don't know. So it's hard to know what the jury will relate to in that standpoint. Just in terms of what is a cultural norm over there. But I know what juries can relate to. Juries can relate to facts. Juries can relate to facts and evidence. I mean, yes, I have to give them. They're in the courtroom with the jury. They have a much better read on what this jury is thinking and reacting to what they do than I do sitting over here. They know this culture. They've tried this case in this community before. Of course, I'm going to give them all that. Is that why they're doing it though? Because they have given it that careful consideration about here's alternative ways that maybe we could do it and we think this one is more effective? I doubt it. I doubt it. Alan isn't from Massachusetts. He's from California. His style, we can't attribute his style to Massachusetts. Now, is it going over well in Massachusetts? It didn't go over well enough to get Karen acquitted the first time. Is that the reason? Of course, I don't know if that's the reason. I just have concerns. And it's really less about the mood of it. Not everybody has different style. I talked a little bit before about the difference between being aggressive and being direct. You can be very aggressive in a very indirect way, and you can be very polite in a very direct way. They're not necessarily the same thing, and people can have all kinds of different moods with how they interact with witnesses. That's not really what I'm getting at. It's not like, do you go in and try to dunk on them or slap them down? It's the method, the technique that you use to do that. Because I'm telling you, nothing smacks down a witness harder than a bad fact that you can back up and you can just make them have to eat it. They're on the stand. Told the story before. I'll tell it again. One of the last trials I was in, gang detective is called to the stand. He's there to testify about the rap lyrics that my client wrote while he was in jail. They did a search of his cell, found his rap lyrics, and the prosecutor is arguing he's describing this crime in his lyrics. So they're consciousness of guilt. They're admissible for that. And so the gang detective is on the stand to testify. He's the sponsoring witness, right? He's the one that got them out of the cell. Here they are. Read them to the jury. Here's what's coming in. The problem, the detective had written in his own report, I read these lyrics and I didn't see they had any relevance to the crime charged. So when it's my turn on cross, I had exactly one question for this gang officer. Detective, isn't it true that when you reviewed these messages, these lyrics, you didn't think they had anything to do with the crime? And his face just fell and his shoulders fell. Yeah, I did. Thank you. No further questions. That's all I needed. Oh, the facts took all the wind out of his sail. That's what will destroy them far more than just like getting angry or getting frustrated or getting annoyed. Facts. In trial, your facts are your fists. That's what you hit people with. It's so effective. It stings. It stings when you get slapped by reality good and hard. So I'm not talking about mood. I'm talking about technique. And I think there are ways that they could have what I would consider to be better technique. And if a combative mood works for them, challenging kind of mood works for them, great. You can still do it that way. But you don't have to. You can be very polite with it. Or you can, poke them a little bit with it, torture them a little bit with that fact that you got in your back pocket. Jules Buddha, this is showing me where last jurors felt like the defense was trying to trick them. Not sure exactly what we're talking about at this point. I think we're probably, are we past Kerry at this point, or are we still kind of at Kerry? Yeah, I'm not sure, unfortunately, exactly where we were at when this comment came in. But yeah, there were a couple times where I thought that it wasn't really effective what they were trying to do, because it wasn't necessarily clear. Wasn't necessarily clear like why it was super important. Was it when the defense came back on Recross? Let me see. The arguing about technically false. I don't know. I don't think so. This isn't what I had a particularly big problem with. Yeah. I wish I knew where you were at, unfortunately. But yeah, I think that there have been some things like, I don't think we were here yet for this comment, but just with Whitley's testimony, and that we're gonna cross-examine him about, were you neighbors with Kerry and on the same civic board. Not sure what we're getting from that, and then impeaching him on prior inconsistent statement that really doesn't seem that inconsistent. Okay, you didn't say she was crying off and on, but you said she was crying and you were talking about a specific point in time. It just doesn't seem that inconsistent. That's what jumps out to me as situations that I saw today where I'm like, I don't think this is effective for the defense. I don't think they're making the impression that they want to, because I'm not sure they know what point they're trying to elicit. I'm not sure they are trying to elicit a point. I'm not sure that they're trying to elicit a fact versus they're trying to get a certain kind of engagement or just a certain impression of this witness based on how he interacts. Like, is it critically important whether this guy said in his prior report, or even whether it's true, that Karen was crying constantly or just kind of crying off and on? Does that really matter? I really don't know that it matters. And if it doesn't matter, you got to have the discipline to let it go. Just let it go. It doesn't matter. It doesn't affect whether John was hit by a car. Doesn't matter. So yeah, I can see how stuff like that, it does. It looks like the defense just kind of doing tricks to try to get somewhere, but they don't really have anything there. And I don't like that. I don't like seeing that. I think it's bad strategy. Paul Croak, Kerry never heard. She was told and lied about it in front of a jury. That's what I get from it. Maybe. I mean, I think the different ways the jury's got two ways they can look at it now. They know it's not true. They got that concession from her to the extent she said in the grand jury that Jen, she heard Karen ask Jen Google hypothermia. That did not happen. But remember, the jury only knows that she said that in the grand jury in the first place because the defense elicited that. That wasn't something that the prosecution brought out. So the defense elicited it and then, pulled it apart. I mean, you can do that. It's just kind of for context. I think that matters because it doesn't necessarily end up dinging the Commonwealth. They didn't ask that question. They didn't try to get that information in front of the jury. So it doesn't make them necessarily look bad. So we just elicited it's untrue. She said that at the grand jury. It's not true. Why is it not true? Jury can believe she misheard the question, misunderstood it. Jury doesn't have the experience with Lally questions that I do, so they may not have that degree of sympathy for her. But they could also think, that's a lie. You heard that question and you lied. You didn't qualify that. You didn't say, well, Jen told me, or this is my understanding. Like you said that as if you had personal knowledge, and the question asked you for what you had heard. They can see it that way, but they're going to have the option because they got asked. She got asked a few too many times. Should have just left it at, yes, it was false. Yes, it was false. Because she's never going to say, yes, I lied to the jury. I intended to mislead them. Of course, she's not going to say that. And you can't prove it. You can't bring receipts to prove somebody intended to lie to a jury when they said something like that. You can make an argument, but you can't prove it. There's no insight into her mind that you can slap down in front of her face and say, eat that. You can't do it. So it's just argumentative, and it gave her that room to wiggle out and give him the explanation. I find it unfortunate. James Cassatelli, the thing is, it's the defense's case to lose, but I think they see it as theirs to win. I hope not. I hope not, because you can never take it for granted. You can never take it for granted as defense. And again, this is something that maybe they have a different mindset because they came into criminal defense from the prosecution side. Maybe they've never really like adopted the full black cynicism of the public defender trenched criminal defense attorney. You always know you're on the back foot. You always know you're at a disadvantage merely by walking into that courtroom. Merely by walking into that courtroom, you are at a disadvantage. You can do your best to mitigate it. You can try to pick the best jury you can. You can try to connect with them as well as you can. You can prepare the case as best as you can. But at the end of the day, that accusation is powerful and it influences people. And they start from that position of suspicion, and some people are better at letting that go than others are. Some people will not let it go. They have that suspicion and they're watching the trial and they are just looking for whatever will confirm it. You do your best to try to weed those people out in jury selection, but nobody's perfect. And you don't always have every choice you would want. You got a limited number of strikes. You use your strikes all up early, then you get stuck with people at the end that may not be what you wanted. If you don't use all your strikes early, then you're making compromises about who you let on and who you don't. So you can do your best to get a really good jury, but no guarantee of it. It depends entirely on the luck of the draw with that panel. So yeah, you know, humility is really important, really important in the defense. And that's part of why it's important for it to be about the case and about the facts. It's not about your showmanship. It's not about your performance. It's not if you do the cross just right, you know, and you have a moment and you have a mood, then that's what's going to get the jury on your side. No, it's about your facts and what you can prove. And the more you can stick with that and keep it to that, the more likely that you're going to be able to overcome that hurdle, that suspicion, because you're using what you have to dispel it. Facts. Yeah, you can be suspicious, but here's the facts. And if you will allow them to, the facts will dispel your suspicions. That's what a good defense should be. Angie Lee, your input is welcomed. We are all adults and can have different opinions. Amen. You're the calmest lawyer I know, alongside the lawyer you know. Well, thank you. I haven't always had, you know, the most even keel, but everybody grows over time. Everybody, you know, figures out kind of what works for them. And I just figured out a long time ago, you know what? Stress, I don't like it. I don't like it. It's not necessary. I'm fortunate that you know, I'm a believer in kind of the big 5 personality traits. I'm very interested in personality theory. It's just one of these things that fascinates me. But neuroticism, one of those big 5 traits. Neuroticism, kind of just a big word for anxiety. Do you tend to be like anxious and nervous and worry about things? Do you tend to worry? Probably high neuroticism. Do you tend to not worry? Low neuroticism. I'm lucky from my perspective because I'm pretty low neuroticism. Like, what's the point of worrying? You know, worrying just means you're torturing yourself for something that hasn't happened, may never happen. Yes, of course, some degree it's always normal. Everybody can forecast that bad things are going to happen in life. Very easy for me to look at my dog right now and think about the fact she's going to be gone someday because I just lost a dog. And I'm going to have that day again with this dog. And that's the price of having a dog. But what's the point of worrying about that? It would just make my life now and my time with the dog now more unpleasant because I'd be unhappy. I'd be sad. I'd be fixated on this thing that only exists in my mind. At this point, the dog is here and with me, and we should enjoy that. So that's kind of, my attitude as far as like why I'm calm and and so forth. But I 100% agree. We are all adults. We can have different opinions. I'm just trying to make it clear that, I don't really expect that anybody here is like, Andrea, God, you're being so stuck up. Like it's so easy for you to sit here and Monday morning quarterback the defense team. I'm not trying to do that. Hurl it at me if you want to, but it's not what I'm trying to do. I'm just trying to share my own perspective on it. I don't really like to criticize other lawyers and how they perform. But we're watching a trial and we're trying to evaluate how things are going. Is this working? Is it not working? It's part of what commentary is. So that's all I'm trying to get at here is just share my perspective. It's completely unverifiable because it's not falsifiable. We will never be able to go back and do this trial under these circumstances the way I'm saying I think it should be done and know whether it would be a different outcome. We'll never know the counterfactual. So opinions are what they are. We're all entitled to them. You can give mine as much or as little weight as you think they are entitled to. Sentient Dreamer, you want defense to do a great job and win, Andrea. I do want the defense to do a great job. I always want the defense to do a great job. I don't always want the defense to win. If the facts are on their side, yeah, I want them to win because I want them to be successful at presenting those facts, the best argument ever. I don't necessarily want the defense to win just because they're the defense. Sometimes defendants defending a case that's like indefensible, it can get like, it's like painful. Like, God, just, nobody likes that. Nobody likes that when you're just like clutching for some explanation for why somebody did something. It's, this is how Daryl Brooks and Lori Vallow end up self-representing. Because no lawyer is going to clutch at those straws in a way that will satisfy these clients. And that's why a lot of times if you watch these cases like trials of the indefensible, and often it's a public defender, because you're usually not talking about wealthy people in the criminal justice systems. You're often talking about a public defender. Some of them really will give it their best shot, and just try and reach for the moon, try anything. But a lot of times you just kind of there to do your part, and what will be will be. And I don't know what exactly I'm supposed to do about it. Here's the facts. If you see some reasonable doubt in there, it'd be really great if you'd look for it. And if you do find some, please acquit him. Sometimes that's all you have for your argument as defense counsel. So I do want to clarify that I don't always want the defense to win, but I definitely always want them to do a good job. I always want them to do a good job because that's a fair trial. The defense doing a good job with bad facts and getting convicted is a good trial. It's a fair trial. The defense doing a bad job with good facts and getting convicted, that's bad. That's bad. So I do appreciate, you see my motivation there. I want the defense team to do a good job. Heather Hammond, I do enjoy watching comparison between trials. Yeah, I do too. In fact, I always have so many ideas and like things I want to do, and there's never enough time in the day. But I honestly, one of the things I was thinking about when I was down in South America, because I know Karen Reed's coming up and it's going to come up fast like that. And it did. So of course I didn't have time to do it, but I'm like, I'd love to go back and rewatch the Phil Spector trial because I'd like to watch Alan Jackson in that context. I'd like to watch him as a prosecutor on that side years ago. It was a successful case for him. He got a prosecution or got a conviction. I'd like to go back and watch that and just have that point of comparison. Just it would be interesting, no other real reason. I don't have like a thesis or anything like that I'd be testing. It would be interesting. I wonder if you'd learn anything from it. I didn't have time to do it, but it would be a good comparison. I think that could be fun. The rural juror, can Commonwealth even suggest that Jen's heart rate data means no nefarious activity? On whose authority do we rely for what Jen's heart rate would do if she did know about it? Well, that's a good question. Is this going to be just argument? If they're just going to argue and they're not going to present some kind of like expert to say, this is what her heart rate would be expected to do if she's conspiring. Obviously, if they bring in an expert, they got the limitations of the expert testimony. How do you know this? Is there any validity to you having this opinion? Is this well-founded in some type of scientific methodology? And is it based on appropriate information? It would be subject to all those types of things. So the question is really, can Hank argue this without any sort of proof? Generally, I think he can. I think he can. He can't assert facts outside of the evidence. He can't say there are studies that show that if you're engaged in nefarious activity, your heart rate would go up. He can't say that without having presented that through a witness. But he can argue about what facts mean. You can always argue about what facts mean. So that's what I expect he's going to do here. He's going to just bring in the heart rate data. At this time it did this, at this time it did that. And then he's going to argue it to the jury, ask them, use your common sense. If you were engaged in some kind of a cover-up, don't you think you'd be really nervous and your heart rate would be elevated? They can rely on their own personal experience. And the defense can get up and they can point out, he's here telling you that, didn't have anybody ever testify to substantiate it, that that's how it works, that it must be that way. And they can point out, he's just arguing. There's no evidence that nefarious activity correlates with high heart rate or something like that. That's how I expect it's going to go. It's because it's argument about what the facts will mean and not an independent fact in and of itself. David Liebold, Kerry Roberts lied to the grand jury that indicted Karen, mistrial. It's not proven. It's one possible explanation, but it's not the only one. And they gave her the opening to say, I misheard the question, so I answered it incorrectly. It wouldn't be a mistrial unless there was a reason to think this was like dispositive at the grand jury, even if she had lied. Even if she had lied, it's going to be a harmless error analysis, unless it's a situation where the Commonwealth knew she lied. Gets into many, many levels here. Mr. Lally asked her the question knowing that she was going to lie about it and did in fact lie about it and didn't correct it. Then you might get a, reversal without any type of prejudice. But 99% of the time, you got to show prejudice. So is this the reason why the grand jury indicted? Because Kerry Roberts got up there and said, Karen told Jen to do this Google search? I'm skeptical that they can make that case. So no, there would not be a mistrial even if it were proven that she lied and we didn't have this alternative explanation out there that the jury is allowed to consider. They're the decider of the facts. They will decide if Kerry Roberts lied or if she just misheard the question. The rural juror, has Bev ever said formally that the Commonwealth had a discovery violation? I feel like she always tiptoes around that wording when it comes to the Commonwealth. We had this question come up this morning and I was trying to think of one and I can't think of a single time. So I'll tell you what, I will continue to rack my brain tonight and go back through some of my old notes and stuff and see if I can find any sort of hint of when she may have suggested they did a discovery violation. But, no, sitting here off the top of my head, I can't think of one. And this is even in the middle, we went through a whole last trial where they late produced the mitochondrial DNA stuff. They late produced the Sally Port video. They late produced the inverted video. No, she didn't find any of it's a violation. So I don't believe she has. I can think back and verify, but nothing jumps out on the top of my head of any situation where she said they violated the rules. The rural juror, this woman has lost 2 of her children in tragic and unexpected ways. Even if she thinks Karen Reed is guilty, we should still be able to have empathy for her. This is about Peggy O'Keefe, and I agree 100%. People are complex. People are complex, and even people that you hate can be in pain. And it's not zero sum, feelings and compassion are not zero sum. Like, you don't take it away from Karen if you give it to Peggy. You can give it to both of them. They can both have your compassion. Everybody in this trial can have your compassion. That's kind of the beautiful thing about it. So yeah, I mean, I agree. I think that I think her pain is very real. I think it was very sincere. I think that she probably has suffered. Does that mean she's a saint? No, she's almost certainly not. None of us are. Does that mean she's bad and she deserves all this? No, also not that. It just means people are complicated, situations are complicated, relationships are complicated, histories are complicated. And so I bring up, what I see as her problem behavior, not because I'm trying to say she's a terrible person or anything like that. I just bring it up because it may shed light on some of the patterns, the relationship patterns that are at play here and that are implicated by what Karen Reed is accused of doing to John O'Keefe. So people have a tendency sometimes to misinterpret, stuff like that. There's, a certain attitude that you can't find fault with somebody who's been victimized, but every single one of us on the planet has been victimized by life at some point. Okay. I'm the last person to preach to about that because, boy, let me tell you, every single person that I've defended that has done, some of them have done terrible things. They've been victimized in life. Doesn't take away from the terrible thing that they did, doesn't prevent us from passing judgment on the terrible thing that they did. So that's just the complex reality of life. Angela Lee, remember not everybody watched the first trial. Yeah, I'm trying to remember, and I'm trying to spell it out, when I remember something that I think is significant. But I am aware of that. And so trying to bring that up and also trying to disclose. I can't look at this as if I'm seeing it for the first time. It's not possible because that's not the situation. I have seen it before. So I am going to be, colored by stuff that I remember, stuff that I think that I remember. I'm going to be looking at my notes to try to verify certain things and stuff like that. It's part of the commentary you're going to get here. Angel Wintrode, please watch Defense Diaries Richard Allen interview number 2 with FBI. Skip to the last hour. You were talking about ipsi dixit, and they go over how cops can ignore what people say and only see evidence. Interesting juxtaposition. I can do that when I get in my abundant free time, when I get a chance to go back and look at their take on the interview. Interview number 2 with the FBI. I'm guessing this is not the FBI. This is the interview number 2 that they had with Jerry Holman. Richard Allen had the first interview with Steve Mullen before they went and got the search warrant for his house. They then got the search warrant for his house, and he had 2 subsequent interviews with Jerry Holman. After that, Jerry Holman was with the Indiana State Police. So I'm pretty sure that's the one that you're talking about. Is that interview with Jerry Holman? And it's an example of, you're watching the Reed technique. I hear people will say, the Reed technique works great when it's done well. The problem is guys like Jerry Holman, they're the ones who are implementing the Reed technique. It's not done well. It's done by guys like that all over the entire country. So humans, Humans with their failings are the ones that are doing these types of interrogations. It's not going to be done perfectly. And given that it's not going to be done perfectly, is it worth the damage that this technique can cause? I say no. People can have different opinions about that. But I'm not sure entirely what this is getting at. You know, like I said, if I get a chance, I will watch it. But yeah, you know, the read technique is definitely not about listening what you have to say. In fact, some parts of it are explicitly against that. Like one of the parts of the read technique is that if you start to deny your involvement, they will interrupt you. They want to shut you up and not give you the opportunity to deny it. They think this has a psychological effect that it will like wear you down if you're trying to deny, but you're not succeeding at it, that you might try something else, and so maybe you'll try admitting, you know. It's part of the read technique. What you say is really only important in an interrogation like this if you're telling them what they want to hear. That's when they'll listen. As soon as you've told them what they want to hear. I will do my best to take a look at that, but I can't make any promises because things are a little hectic right now. Aussie Insider, re-clips. Stipulation to admissibility does not equal forfeiture of using it properly during trial with no witness to cross, right? Only if they've objected. Only if they've objected on that grounds. They have to preserve their objection. If they've done it, you know, at a sidebar before we've seen any of this, or, you know, somehow off the record, off the public record where we haven't seen it, but it's on the record officially for court purposes, then yeah, they can raise it. But if they haven't objected, no, they can't. They would have waived it. So we're not seeing those objections happen at this point. If they haven't already made them off the record, they're waived. Melinderp, I'm so curious about what types of human factors research has been done on witnesses' testimony during trials. I'm not sure exactly what human factors research is getting at here, but if you're talking about things like memory, if we're going back into like the memory and how well do you recall things, how accurate are you and stuff like that, there has been a lot of research on that. Again, it's been a long day now, and I'm already lost the name, Elizabeth Loftus. Dr. Loftus has done some research on that because of the false memory stuff. So she has her study, basically her work tends to show that roughly 25% of people will, under the right circumstances, they will generate false memories. So about one in four. Kind of a lot. There are lots of known factors out there about like suggestibility, things that tend to correlate with being suggestible, low IQ, other types of intellectual or emotional deficits, youthfulness. These all tend to be factors that make people more suggestible. What other kind of stuff? Fair amount of research on stress. Like we have this idea that stress makes you very reliable in what you remember. Like you remember traumatic events better than you remember non-traumatic ones. That's not actually typically the case. Stress can really distort your perception of things and your ability to then encode it, to be able to store it in a way that's reliable and not going to be affected by later information or later reprocessing it. Part of the problem with trauma is that people tend to work it over and over and over and over again in their minds. And remember, if Dr. Loftus is correct, she's got a pretty good body of work backing her up. It's not a videotape when you remember something. It's a rewriting. So every time you play it over, you're revising it, even if just ever so slightly, you're revising it. So trauma also has the effect on your perception, what you actually will even perceive in the first place. And this is a good example of this is something like tunnel vision, very common, very common. Somebody comes up to you and they're going to rob you, and you see them walking up, and then you see they're pointing a gun at you. Very common for your attention to just go whoop like that down. It's on that gun. You are going to be obsessed with that threat until that threat is gone. Very, very common for that to happen, for there to be tunnel vision like that. And so when that happens, you're not taking in and perceiving, even though it's like right there in front of you, it's part of your peripheral vision. You're not taking in the clothing, the height, the weight, the race, anything like that. Very, very common. So trauma can affect people's ability to recount stuff in that type of way, affects your ability to perceive as much as your ability to recall it later. So those are some types of factors I can think of off the top of my head. Hopefully that is the kind of thing you were thinking about. Otherwise, pardon the non sequitur answer. In Wings, imagine if AJ got up and roasted poor Mrs. O'Keefe. Well, it would depend on what facts he had, didn't it? If he had a fact to roast her, that's a good fist. It works well. But no, if you're just going to get up there and torment her with previous inconsistencies, that would be terrible. That would be a really, really bad approach. Young Black economist. Hank doesn't know what gray key is, that extractions are just JSON files, how Celebrite is a GUI for JSON, yet wants to do tech junk science with Jen's phone. No, I doubt that Hank probably has a superficial understanding of all these things. Like he's heard of them before. He maybe hasn't heard of a JSON file. Just depends on how deep you've had to go into these issues. He's been a defense attorney. He's been in criminal work for a long time. So I'm not going to assume he hasn't been exposed to any of this at all. He probably knows the big picture view. But the reality is most lawyers aren't going to know the ins and outs of this stuff either. They're just going to know the basics of what they need to know. Here are the tools. Here's more or less how they do, how they do their job. Here's what they do. But they often don't know what they don't know. And so sometimes you only learn that stuff kind of as you go along and as you get cases where it becomes relevant. Somebody might know generally that you can do these extractions and that you have these different tools to do the extractions, but they may not know that there are different types of extractions that you can do. Different ways to be able to get at the information at the cell phone, different scope of information you can get at within the cell phone, depends on the type of extraction you do. You wouldn't necessarily need to know that unless you had a case where it came up. Or maybe you've gone to a conference, where they focus on cell phone extractions or something. They do have specialty conferences and stuff like that, but did you go to that one? Maybe you did, maybe you didn't. It's not required. I think you're probably more likely to go to it if it's something that you already have an interest in. If you don't have an interest in the ins and outs of cell phone extraction, it's going to be torture to go to like a 6-hour conference about the ins and outs of cell phone extractions. So that type of thing tends to be a little bit self-selecting. You go to the stuff that you're already interested in and already maybe kind of know a little bit about. So I would expect he knows the big picture, but no, as far as the ins and outs of how this stuff works, he doesn't know that. And it's, honestly, it's really not his job to know that. It's not necessarily his job to know that. That's why lawyers have experts. We're there to be the expert on what the law is and the procedure in the courtroom and how to present the case and so forth. That's our lane as lawyers. We're not there to know everything about everything. That's why we need experts to be able to tell us. And that's why, helps if you got reliable ones that you can count on that won't lead you astray. Lift the veil, buy Bitcoin and dollar fat. Praise the chat, much praise. Oh, I remember back in like 2013 when I was first thinking about buying Bitcoin. Pretty sure it was about 2013, maybe 2014. It was back when the Dow was like 16,000 and I was alarmed. I was like, we're in bubble territory. Those were the days. I don't, know anything about any of these, so I don't know if I join in this recommendation or not, but Lift the Veil has it for you and do what you like with that. The rural juror, why do I get the impression that if the defense had sent Bev a file she couldn't open, she would have grave concerns? Yeah, the shared file with access. I will give credit where it's due. I will give credit to Mr. Brennan for having figured out the obsequious approach to Judge Cannone, the falling on his sword. I should have given you a zip drive as well. I shouldn't have just relied on the share folder. It's placating her. And it worked. It worked. Oh, just at your convenience whenever you can get it to me, But yeah, part of the reason why it wouldn't work that way with the defense is because the defense wouldn't act like that. But part of the reason why the defense wouldn't act like that is because the defense has been trained. They've been trained already that, Bev isn't going to like their explanation. She's not going to be happy with them. Even if they have an excuse, she doesn't sympathize with their difficulties. They've already been trained to expect that. So there's a little bit of a feedback loop there, But it is what it is. That's what happens when, the judge doesn't see the parties the same way. The rural juror, will this be the only voir dire for ARCCA? As far as I know, I would expect so. I don't know what we would have another voir dire for or why, but I have a hard time understanding, like I said, what we're doing in this voir dire either. I don't know why she's saying defense, you put them on. It's not really what a voir dire is in this type of situation. If the defense is putting it on, it's because they need to make a record or lay a foundation or something like that. But a voir dire under this circumstances, that's usually going to come from the challenging party. So I don't know what she wants. And I honestly think that's kind of the point. We're supposed to be sitting here like all fearful, like I should know what she wants, but I don't. And it's my fault. It's not my fault. I'm not going to be gaslit like that. I'm pretty gaslight proof. This is not something I should know and should be able to read your mind. You as the judge should be able to articulate your reasoning and what you were looking for and why. That's your job. Edward Kirkpatrick, rewatch that dash cam for Kerry when she misidentifies time she gets phone. Watch her slowly back away from scene, but walking backwards 30 to 50 feet. Okay. When she said she got the phone initially, it's when it looked like it was when they right when they first got there, and it looked like she just stuck it in her pocket, and then she backs away and she's walking down the street and she's making her own phone calls. I think this might be the time that you're talking about. She walks away and she's on the phone. And then like at some point she just kind of shows back up. But it is worth rewatching, isn't it? Now that we kind of know who's who and what we need to pay attention to and what we don't. I'll take another look at that and see if there's anything that is worth seeing. Chad Smith, seems like the state is wanting to use more of Karen Reed's own statements against her this time around clips, etc. This seems to be their big adjustment. It definitely seems to be a big part of it. I mean, at least from what we've seen so far. Welcher, I'm sure, is going to be another one, trying to get some guy that's got an actual grasp of physics on the stand to do the accident reconstruction, that's an adjustment. Otherwise, yeah, I think compiling and using these video clips is a different move, and it's a doubling down on the ipsi dixit, right? The ipsi dixit last time was just the I hit him, I hit him, I hit him. We're still going with the I hit him, I hit him, I hit him this time, but we're also just going with the other stuff Karen said. We're going with a theory of Karen Read is guilty because Karen Read said and acted like she was guilty, even if the evidence doesn't prove it. And even if the evidence in fact suggests it's implausible that that happened. Karen Read said it, so you should believe it. And this is really doubling down on that. So it is an adjustment, but it's not, I don't think, like a change in direction. It's a bolstering of what they did last time. Tara Rayner, they have a ring records keeper on their list. The defense does or the Commonwealth does? I don't remember which one of them has a ring records keeper on their list. That would have been definitely something I would have done if I'm on the defense team after the mistrial, because that had been an issue that came out during the first trial. They had subpoenaed, the law enforcement had subpoenaed these records from Ring, and they argued didn't get them, didn't get the logs, even though the return kind of says they did. They didn't get them. Buchanan's like, I never saw them. So that's something I'm going to follow up on if I'm the defense, because I want those logs. If they exist, I want them. And if they don't exist, I want to know why. And I would like to hear that from the source, because rule number 2, you don't believe the prosecutor, and you don't believe the prosecutor's investigators. We don't take their word for it. We investigate and we find out for ourselves. So that's definitely something I would have followed up on if I'm the defense lawyer. Yeah, I want these Ring videos. I want the logs. I want to get them. Of course, it's third-party discovery, so I might have to go to Judge Bev to do that. And I don't think we saw that, unless it was agreed and there was no dispute over it. So I don't know. But I would like to hear more about Ring for sure. Lauren Boborin, the mom acted like Kerry was guilty. IMM. Yeah, she did. She thinks Karen is guilty. I think that's clear. You can see from her demeanor and how she behaves in the courtroom, the faces that she makes and so forth. We can see from Paul's interviews and the things that he's said publicly. Yeah, she thinks Karen's guilty. At the time, did she act like Karen is guilty? That I don't know. But we heard that story from Kerry Roberts. You just left him there? Yeah, it's not really that unusual to take someone somewhere and drop them off if they're going to be there. Like, that's not a problem. So why are you looking for me to be the problem? I think that from the inception, yeah, that seems to me to be clear. Peggy is looking to blame Karen for something. Looking to blame her in some way. You dropped him off. Why are you even at the hospital? There's that antipathy. Comes through loud and clear. So whether that had actually transformed into, at the time, I believe Karen did this to John, or whether that's something that just evolved after the Commonwealth developed their case, I don't know. But the antipathy was definitely there from the outset. Joshua Frost, is Brennan trying to force Karen to testify to respond to all the clips between witnesses? Yeah, I mean, that's part of the strategy. If he gets to cherry pick statements from her, and they don't have rule of completeness objections they can bring up to put it into broader context, then that's essentially what he's daring her to do. Get up on the stand and explain these things that you said. It's only going to work if the things that she said are bad and damaging, and we already kind of know she thinks that they aren't, because she said so. Didn't she say that on the courthouse steps? Like, I don't remember if it was during jury selection or the last pretrial conference or something like that. She always gets asked the questions on the courthouse steps. I don't always see all that, but I do see bits and pieces come across sometime. And she said something like, bring it. I haven't said anything that I wouldn't say again. Then she may not feel a need to explain it. She may think it explains, stands on its own. It speaks for itself. It may be something she trusts her lawyers to be able to explain in closing. You saw Karen say this stuff. Put yourself in Karen's shoes and see it from her perspective. She's being framed. Might you see it like that? She might just trust them to be able to handle it. But yeah, I agree. I think that's certainly part of the strategy. Flush her out. Put the pressure on her to have to explain something. Hospice Jess, I'm far behind, but do you deny it? Do we need to get a billboard, send smoke signals, carrier pigeon? Please, any and all of the above, whatever will work. Can we just communicate? When they say, I don't remember, your next question is, do you deny it? Do you deny it? Put them on the spot. Don't just let them have, they don't remember. Put them on the spot. Stay on the front foot. It's not aggressive, but it's direct. It's direct, and it keeps you in control of the situation, sets you up for the impeachment, forces them to entertain the possibility. Sometimes the possibility is all you need. If it's possible you said that, then you might as well just tell the jury you said it. Okay? Because if it's possible you did, then maybe it did come out your mouth. Yeah, I really want to see that. Do you deny it? The fact that Bev had to do it this morning, had to hand feed it to them, and then he still hasn't picked up on it. I don't like it. I want to hear more. Do you deny it? Hey, it's me. Would you be willing to invite Mark Betterow on your show? I think you guys would elevate the discussion to another level. By the way, I'm a Hoosier that is so thankful of your Richard Allen coverage. Well, thank you so much. I very much appreciate my Hoosiers. Just the other day, got some good comfort from my favorite Hoosier ever when I lost my dog. So it goes. Kind of a black comfort, but that's the nature of my favorite Hoosier. That's Kurt Vonnegut, guys. So I mean, here's the thing. I don't really invite people on my show. Not because, because it's just kind of more coordination and stuff than I really do on my channel. It's just not really what I do. I'm not like an interviewer. I would love to be on a show with Mark Betterow. I think we've been on a panel together one time on Jerks, if I remember correctly, over on the Young Jerks. I think he was there, but I'm not 100% sure now. But I would love to be on a show with Mark Betterow. He's an excellent attorney, extremely good at what he does. Obviously knows a lot of the ins and outs of this case. Has a lot of like personal insight into the players and stuff that I don't have. I haven't met any of these people. He's met all of them. So I love the idea of being able to talk with Mark Betterow, but just in terms of having it on my channel, I don't know. That would be a big step for me. I think I've had 2 guests on my channel ever. The first one was during Delphi when we dropped Ian the link in the messages because he was in the chat, and he's the firearms guy. So when we had the ballistics expert come in, Ian Runkle, we brought him on so that he could rant about the ballistics while I was like losing my mind over what we heard and what had happened. That was the first time, very spontaneous, and it just sort of worked out. Second time was when I brought on the executive director of the Blue Mountain Land Trust, and that was just a like charity stream that I did. It was an organization that I used to be on the board. I'm a supporter of, and just kind of wanted to talk about why that type of thing matters, and just how it fits into my perspective. So it's a little bit, not really the core of what the channel does, but just a thing I did. And so that's really the only times I've done it. I don't have a show in the sense of like, I'm going to look for things to talk about and I'm going to plan them and I'm going to script and stuff like that. Like, no, man, that's not what I'm doing. I'm here to watch trials and tell you what I think about them. That's the bulk of what I do. So hopefully that answers your question. I would love to be on a show with Mark Betterow. And if I am, here's what I will promise you. I will put it in the community post. I will give you all a heads up. If I am going to be on the channel at some point with Mark Betterow, because I will be excited about that. So hopefully some of you would be as well. Half Irish is now a YouTube member. Welcome. Welcome to the channel. Robin, the ambulance report and ED report should mention if they were told patient was reported to have been hit by a car. Well, you would think that, right? We just talked about the history is important, but then he kind of limited that down to, well, it's just medical history. Well, no, it's not just medical history. The history of how the person ended up in this situation with this problem, that's very important to treatment. So yeah, if the patient was reported to have been hit by a car, that matters. Also, if the patient was reported to have been hit by their partner, that also matters too, because that's often a mandatory reporting situation. I have to look that up for Massachusetts. Now I'm curious. I don't know what the mandatory reporting situation is in Massachusetts. It's another one of these things, varies state by state. But a lot of times, healthcare worker finding out about domestic abuse, duty to report it. Somebody saying, I hit him, even if she didn't necessarily mean with the car. I hit him and that's your partner. You might be under an obligation to report that. So yeah, I would expect it to be there. It's important information for them to know for all the reasons we talked about. It narrows what you need to be looking at in terms of what the possible injuries are and what is the cause, what is the etiology of the circumstance that I'm dealing with right here. Lindsay, followed you during Depp v. Heard and love your coverage, Andrea. The pro-prosecution slant Judge Cannoni appears to be displaying reminds me of Justice Nichols in the UK Sun case. Remember pajamas equals no abuse? Boy, do I remember. Yeah, it is real similar, isn't it? And I'll tell you where the similarity is. It's because they already have the outcome in mind. The outcome that they want, they've already figured it out. And so their legal process is not a process of analysis. It's a process of justification. It's how do I find what I need to support the conclusion I want to reach, and how do I factually put that together? And so with Justice Nicholl, we saw like one of the things he did a lot that very clever judges will do, where they have the room to do it and the opportunity to do it, where judges are the finder of fact, their credibility determinations, untouchable. They're untouchable. And so that's one of the ways that Justice Nicholl got to, what was frankly, in many respects, just an absurd conclusion. An absurd conclusion. Kevin Murphy wasn't credible because he volunteered that he had given a false statement in the dog case that Amber Heard was facing down in Australia. He volunteered that because his explanation, she had threatened him that he better do it. He better tell the court it was his fault and not hers. It was his job to take care of the dogs and not hers. That way she gets leniency in that case down there in Australia. So because he volunteers something that is against his own interest, okay, the fact that he made a false statement in Australia, and he can suffer consequences for that, makes him less credible. Makes him less credible, according to Judge Nicholl. That is not how that presumption works in any normal court, any normal legal reasoning. The whole reason we here in the US have the statements against interest exception to hearsay is because it's generally presumed that if you say something that is against your own interest, you're not making it up. You could suffer consequences for saying it. So why would you say it just willy-nilly not true? It's more credible because it's against your interest. That was just one example. I mean, you know, so many examples of this very convoluted and self-serving conclusion that he wanted to reach in that case. Amber Heard is highly credible, and yet several of her accusations he found were not true. How do you square that? How do you square that? She told you it happened, but you're finding it didn't. And this is even under a relaxed standard. Even under a more probable than not standard, you're not going to find it's true. And yet she's credible and reliable. No. So that's where I see the similarity. And so Judge Cannoni does a lot of the same thing as far as justifying where she has the opportunity to make findings. She's taking advantage of it. Just saw it today. I found there's a Rule 14 violation. That's not really a factual finding. That's a conclusion. But, you know, she's pushing it. She's pushing it in the direction that she wants to go. And even if she has to really reach for justifications for making that finding, like the ABA guidelines, I don't know. I really don't. I'm really lost on what planet does a judge think that a non-binding ABA guideline somehow translates to a discovery violation? It's absolutely baffling to me. But that's her searching for justification of the outcome that she wants to reach. So I agree with you 100%. That's what they have in common. And that's what, very simply put, bias looks like. You're not open. You're not open to any possibility. You're not open to where the law takes you. You are trying to drive the law into a certain outcome. And that's what we see them both doing. Taylor Cook, as a lifelong resident of the best Northeast state, the Granite State. Oh God, don't test me. Is that New Hampshire? Is that New Hampshire? If I'm embarrassing myself, I'm sorry about that. And family to many a masshole, I don't find defense argumentativeness offensive. It may not be offensive. The question is it effective? That's all. Maybe it isn't offensive to argue, but is it effective? Is it getting them what they need? That's really the key question of what I'm kind of trying to drive in. Is it getting them what they need? What did we get? Did today go well for the defense? I mean, what do you guys think? Did today go well for the defense? Did they get good stuff out today? I feel like the things that I can elicit that went really well for the defense today are they got Kerry to acknowledge that her statement to the grand jury about Karen asking Jen to do the Google search was false. That stands out to me as that was something that the defense scored on. Otherwise, I mean, I'm just being honest. Nothing is really jumping out to me as like, oh yeah, that really moved the ball for the defense. That really took them further down the field. No, I feel like, at best they held their ground. They didn't necessarily like get pushed back, into their own zone. But I didn't see a lot of success today. And was there anything else really that was good from Kerry? I don't know. I don't know. Of course, we didn't cross Gorino. We didn't cross Peggy O'Keefe. Anything from this last guy that really mattered? Whitley? Did we get anything from Whitley that mattered? Did any of that matter? I just don't feel like any of it mattered. So it's really not about is it offensive or not. It's about is it doing what it's supposed to do? Is it doing its job? Is it effective? Is it good technique? That's what I'm taking issue with. I just don't think it's good technique. Because it's not necessary. You're not getting anything out of it. I hope I didn't embarrass myself with the Granite State. Leanne, question, does the jury know about the other trial? What are they allowed to know and not? I notice witnesses and lawyers mentioning other testimonies. Yeah, so we can tell that they're having to sanitize that a little bit. They're able to come out and specifically say the grand jury back in April of 2022. But other testimony they're having to be vague about. So they're not being allowed to specifically tell the jury there was a previous trial in this case. They hinted at it, though. Alan Jackson hinted at it just yesterday. You gave prior testimony a year ago in this very courtroom. So we know it's about this case, but, haven't explicitly come out and said that there's another trial. So pretty clear, I think, that they're not being allowed to tell the jury, we already had a trial in this case last year. That said, the jurors may already know that. They may already know that. It's not disqualifying to have prior knowledge about the case. And so we saw when they were going through the voir dire and they're asking who knows about the case, who has opinions about the case, who has bias about the case. Almost everybody knows about the case. A lot of people, but fewer, have an opinion about the case. And, fewer than that even have what they would admit as bias about the case. So I would think there's a pretty good chance that there are people on the jury that already know. They already know there was a trial in this case. It wouldn't be news to them because you wouldn't be able to root out everybody who knew something about the case, who had heard about it, who knew that it got tried last year and boot them from the jury. You'd have to bring like thousands of people in as potential jurors. So knowledge is generally not disqualifying. It's just can you put what you know aside, consider the case based on just what you hear in the courtroom, just the evidence and testimony that's presented in the trial. And if people say yes, the court's going to qualify them. You can put it aside. Don't think about the fact that there was already a trial last year. As long as it doesn't make them have a fixed opinion about the case, they decide, I can't acquit, I can't convict, I know too much. That would be disqualifying, but otherwise, no, just knowing about it would be fine. Glamasuse is a new YouTube member. Welcome, Glamasuse. Glad to have you here with us. Just Josie, why did none of the witnesses ask Karen what she hit John with? Weren't they curious? Why doesn't the defense ask why they didn't ask? Well, so far, the only one we really have is the true believer, Mr. Nuttall. He's the only one that's testified so far to the I hit him, I hit him, I hit him. And so they did. He already volunteered in his direct because he already knows. He already knows like this is an issue. It's inconsistent with how you would behave under the circumstances. So he's already explained, well, it's because it wasn't important. She walked away. He gave those two explanations, remember? I didn't have the chance because she walked away. And also it didn't really matter to me. So which one is it? Which one is it? Did you want to because it did matter, but you couldn't because she left? Or it didn't matter, so it didn't matter that she left because you wouldn't have anyway. they're answers that don't exactly line up with each other. And that's what old Scott Adams would call a cognitive dissonance tell. It's a cognitive dissonance tell when you have 100 explanations for something. That's a tell that you're trying to reconcile a conflict in your mind that you can't necessarily reconcile. So that's my interpretation of what was going on with Mr. Nuttall. He already knows. He already knows if she had said that, like even if just on some level, wouldn't I have done something differently? And so he's trying to come up with an explanation for that. This is not conscious stuff. This is not him doing it intentionally. This is like subconscious ego preserving level stuff. You know, why wouldn't I have followed up on that? Well, it just didn't really matter, and I didn't have the chance anyway. You know, every justification that can come up, that's your frontal brain after the fact, giving you the rationalization you need for what you kind of already think and want to believe. So he's the only one so far, you know, that heard the I hit him, I hit him, I hit him. They didn't emphasize that with Kerry, the fact that she didn't hear it. She didn't report that. Maybe they'll just call that out in closing. You know, Kerry was right there the whole time, never told you she heard it. Well, they didn't ask. You know, the Commonwealth can spin that. You didn't ask. But if they don't know the answer, then you wouldn't ask that question. If you don't know the answer to it. I don't know if they would know from like the grand jury testimony or anything like that, what her answer to that would be. But either way, they chose not to double down on that. So all we have is Nuttall. He did explain. He just gave, you know, explanations that are not easy to reconcile with each other. So I definitely hope they do the same thing with the other witnesses that we can anticipate hearing this from. Who else claims she said, I hit him, I hit him, I hit him? Jen. And some of the other firefighters, but not all of them. Flamati did. Kelly did not. Kelly specifically did not hear her say it. So that's another inconsistency with Mr. Nuttall's recollection of when and how this happened. Would not have been Flamati and Nuttall, or Flamati and Kelly, you know, down at one end doing the chest compressions because Kelly didn't hear it. And then Katie McLaughlin. I don't remember if there was a fourth. Nuttall heard it, Flamati heard it, Katie McLaughlin heard it. There might have been one of the other firefighters that heard it. But so the interesting thing, Seraph and Mulaney, the law enforcement officers on the scene, they didn't hear it. And part of the explanation that Katie McLaughlin had given in the first trial, her explanation was that Karen said this right in front of Officer Seraph. And that Officer Seraph said something like, you know, I'm going to need to go get Officer Good. And Seraph and Good are both like, I never heard this. So Katie's recollection is like way out in left field as far as what she told us from last time. So we can anticipate her explanation will be, well, I thought it was being followed up on, you know, Seraph and Good were right there, you know, I don't know. But yeah, I hope they ask the others because it does seem like that would matter. That would be kind of important for evaluating what are the treatment needs of this guy. How did he end up in this situation? Zippy519 is a new YouTube member. Welcome, Zippy. I love Kitty 73. I have lost a child and I have compassion. I also see. Thank you for all you do. I am deeply sorry for your loss. And yeah, it's not. You don't take anything away from anybody by having compassion for others. It's not zero sum. It's like love that way. You don't love one person less just because you find more people to love. Very sorry for your loss. Ryan Bibbs has gifted a membership. Thank you so much for that, Ryan. Very generous of you. And Glamasues, Peggy thinks Karen is guilty because a 46-year-old police officer cannot take care of himself. Peggy's son-in-law died due to his activities as well. I don't know about why his son-in-law died. Her son-in-law died. They said sudden cardiac arrest. if he's young and he's having a heart attack, I'm going to lean pretty hard in favor of there were some significant genetic factors at play. That's just going to be my assumption there. Doesn't mean it can't be contributed to by lifestyle. It could be a lifestyle issue. I don't know. That's just going to be my default assumption when somebody dies young of a heart attack, that probably going to have a genetic basis to it. But that in and of itself can be complicated. So I don't know much about that. I don't really want to go down the road of like, blaming people for their death or anything like that, which I'm not suggesting that this is doing, but it's just, there is a road where that eventually leads to. But we can definitely look at dysfunction and patterns of dysfunction and whether and how they cluster. And there definitely seems to be a clustering with John and Paul when it comes to alcohol. Seems to be a bit of an issue with alcohol. And this cluster is bigger. Okay. Karen's out there drinking with them too. Their friends are drinking. This whole crew is out there drinking. Patterns. Where does that come from? I don't know. Don't live in that house. Didn't get raised with that family. But if I see two kids that have alcohol problems, I'm going to suspect might be some alcohol problems or some other type of dysfunction going on in that family. It's unfortunate, but that's just how things tend to go. Things like that tend to happen in patterns. 10 hours and 44 minutes, guys. You had a lot of questions and comments and stuff for me today. Well, there's a little bit of afternoon left. I am going to go take off and enjoy it. 46, I'm still thinking, the 46-year-old guy who couldn't take care of himself. That's a bit harsh. It's a bit harsh. I mean, come on. He did have his own house, and they are very proud of what a big house that is, aren't they? Like, telling us over and over again what a big house it is. Taking care of the kids. Yes, he needed help with it. Had a job. I'm sure John is a complex person too. Just because John was killed also doesn't mean John was a saint. Because very, very few of us are. That's okay. I don't know that it matters. Saying John isn't a saint is not saying, oh, John deserved it or John was asking, no. But situations are complex and causes are complex and patterns are complex. It's just important to kind of understand how things happen to be able to recognize things like that. So that was just some of my thoughts today about a little difficult conversation there with domestic abuse. Domestic abuse, something to think about, that pattern as the case continues. So we know there's a lot more still to come. Well, we'll see what we get tomorrow. Don't really have a preview yet of who the Commonwealth is going to be calling, what their case is going to be. We got a full day tomorrow, then a half day on Friday. So I'm going to do my best to get over to the boxing gym tonight. I think I could use a little punching some stuff out, but we'll see. It's so nice outside. I might just spend some more time in my garden. Have it up in the air. I got to go check the trees and stuff. See how the birds are doing. The new chickens they're getting into that adolescent phase where like they get a random feather that like pops out different parts of their bodies. Their wings are already filled out, tails pretty well filled out. Starting to get one here and there on the head. It's like the awkwardest looking thing ever. Awkward little teenage chickens. But it's kind of when they start to be fun. It's when I typically start to take them outside supervised, but let them run around in the grass a little bit, get to feel the sun, get to scratch in the dirt and stuff like that. Be their best little chicken selves. So maybe that would be fun too. I don't know. No hard decisions, but appreciate all of you joining me here again today. I do just remain kind of dumbfounded, honestly, but very profoundly grateful that so many of you appreciate my perspective on this case. I'm not here because like, ooh, I want attention or anything like that. I'm really here because so many people have told me we value what you have to say about the case. Please keep doing it. And so if a little reluctantly, I do continue to do so. But it does. Gives me a sense of meaning and purpose and value, that you guys appreciate, just having my perspective, and just continue to say, take it for what it's worth. Obviously don't have to agree with anything I say. I'm not the world's authority on anything at all. I'm just another person with an opinion and a background. And so the fact that so many of you are interested in my take on this case as it unfolds and kind of how I react to it as it unfolds, really, it means a lot. Makes me feel like there's value to all this time I put in the public defender trenches and the work I did and stuff like that. So thank you again. Really value all of you, value your support. Look forward to seeing you guys bright and early tomorrow, and we'll see what day 3 of the trial brings. All right, guys, take care and enjoy your evenings.